Well, after the excellent Enforce Day yesterday, now we are going to discuss the second and third part of our event, and that's the part simplification and building our own European capabilities. It is my great pleasure that we are going to cover relevant topics which are on the political agenda in the last couple of months. Basically, one of the most essential topics in the last couple of months is the digital omnibus, with the two parts: one, the privacy reform, and secondly, the data reform. Then we are going to present our study done by Antonio Manganelli on the DMA implementation on the cloud hyperscaler. We are going to present also the Eurosky, one of the most essential projects currently going on in the field of social media. Unfortunately, because of Lufthansa, we're going to meet the digital minister of Hesse only virtually. But still, we're happy for that. We have also a great discussion on procurement after that. Happy to discuss also the issue of federalization and issue of building cloud capabilities with the two main German cloud provider, Ionos and Stegit of the Schwarz Group. And last but not least, we are really happy to announce, maybe some of you have read it today in some outlets, we're going to announce the first sovereign disaster recovery package. We're happy that we have the four small undertakings from Germany, Bulgaria, and Italy. So it's really worth to stay till end of the day. This is really worth listening to. But now, the floor belongs to our great friend of the Adenauer Foundation, Johnny Ryan. I'm inviting Johnny to have his say on the current issue of the GDPR reform. Dear Johnny, the floor is yours.
I'm going to try and use one of these floor mics, and I'm just going to move my laptop down here. I'm talking to the tech booth right now, not to you. So I've got the mic with the red. Yeah. Okay, ladies and gentlemen, and Pencho, thank you very much. I'm going to get back to this enforcement topic as a way to start off this discussion. Let's start off by zooming out the lens and taking a look at the biggest companies in the world. So I'm going to show you a list of the top 100, actually 101, companies by market cap. I'm just scrolling through them, and you end up, if you strip out any company that isn't reliant on processing an awful lot of data, and if you strip out any company that isn't in Ireland, you end up with this list. So what you've got is a huge concentration of very, very big tech firms that are processing Europeans' data, and nearly all of them have put all of their eggs in Ireland's basket. And the result, or the reason for that, might be called a Faustian pact. If you heard Owen's excellent keynote yesterday, you'll be familiar with this fact. It's another instance of fiscal irresponsibility that should evoke in your minds that moment that reached its peak in 2008 with the banking crisis. We have that moment again, but in a different domain. Ireland has tied itself to these firms, which are not from the EU, and their interests diverge from ours. So that's one side of the big picture. Now consider the other part, Trump, who is our adversary. We no longer speak even of frenemies, we speak of adversaries, if we're being honest. Now, Trump is in a very precarious position. His base, MAGA, has a pension, a 401k. The average MAGA person has a 401k. And the average 401k is entirely now dependent for its health and continued growth on a wildly speculative bubble in tech and artificial intelligence. I have moved my pension out of AI stocks. Americans can't easily do that. So this is, on the one hand, it looks like a tower of strength, but on the other hand, it's a vulnerability. Back to the first part of this picture. We have a situation where Ireland is the back door through which these firms can operate across Europe's market with impunity. And I will back that up in this presentation. The consequence to our children is profound. They are, in some cases, even fatal. And the consequence to our industry and our national security is no less fatal. Now, I'm going to play a video. It has subtitles, so it doesn't matter if the audio doesn't play. It's about 30 seconds long, and it comes from an Irish parliamentary hearing about a month ago, where the chair of the Irish Data Protection Commission is asked a very simple question. It's a very important question. I'm going to show you that video now. Have you ever, aside from amicable resolutions, taken a single Article 60 decision on Google since your establishment? Not just since the GDPR, since your establishment. Now, this political representative is asking the chair of the Irish Data Protection Commission this question. Have you ever completed an inquiry into Google? If he hasn't, European action against Google that crosses borders, not just in one member state, but across the Union, is utterly paralyzed. So his answer is important. And the answer is no. We have never completed an inquiry into Google, not ever, aside from so-called amicable resolutions. In nearly 100 months since the GDPR, nothing. Let's take a look at that nothing. So here is the record of decisions, of final decisions, against those companies that are in the top 100. Now, any of you who covers finance will know that ByteDance is not publicly listed, but this is the estimate that ByteDance is somewhere in between 7th and 25th rank. Almost no decisions. And when there are decisions, very few of them contain anything that you might describe as a substantive change in how those companies actually use data. 2. And if you break that down, now this is drafts, this is what the Irish have proposed. If you then look at what the European colleagues voted by majority to force the Irish to do, that rises slightly. So we've had 100 almost months of the GDPR, and we've almost had a GDPR, but we haven't had a GDPR. And it is worth thinking back to this stale, inert, much unloved law as we talk about reform, and because we're fixated with the next generation, whose failure rests on this generation's failure. This one was the most hyped of all of our laws so far. Some of you might criticize this presentation. You might say, well, what about the fines? We've heard there are big fines. Okay, let's take a look at the fines. First, let me remind you of the market cap, these are figures from late February, of the market cap of these firms. Not small. Here are the fines. So clearly this is a parking ticket, but it's a parking ticket that has yet to be collected. We are nowhere. We haven't begun. 8 years of failure, actually 8 years of absence of anything. It's a void. It is without form. And the peak of this sorry record, we reached it in January last year. I'm going to show you the title of an extraordinary court case. In January last year, the European Court dismissed this case, Irish Data Protection Commission against the European Data Protection Board, against all of its counterparts. In that case, Max and his organization, noyb, had complained against Meta, and in that complaint, they had said, you are processing particularly intimate data. This is an important part of this complaint you need to investigate. The Irish refused for years, And eventually they were forced by the European Data Protection Board to investigate. So what did they do the next day? Did they raid Meta, which they have the legal power to do? No. They sued all of their European counterparts who had voted by majority to force them to do their jobs. And what then happened? The European Court dismissed this. Now, for context, we have had a change of leadership at the top of the Irish Data Protection Commission. So any of you optimists might think this is good news. No. What Ireland did is it appointed someone who had been Meta's chief lobbyist during Cambridge Analytica and throughout the entire period that Frances Hagan complained about when she blew the whistle. This person then went into Stripe and then private lobbying, and then she moved to become Ireland's new Data Protection Commissioner. There's now a college of 3, so she's the most recent addition. In the process to recruit her, Ireland showed its hand. Here's the first part of that hand. There were 4 active members of the recruitment panel. One was from the government, another was from a big tech corporate law firm. We know this because we have asked and received the documents from the recruitment. In those documents, they also describe what the criteria that panel was assessing. Were they trying to find someone who has experience as an investigator? Or were they trying to find someone who has the expertise to supervise the most sophisticated companies that humanity has ever produced? No, they were not. They were looking for generic civil service management criteria. And that's all you were allowed to select on. So if, for example, you were a very, very capable person in the Department of Fisheries, in that you didn't cause too much embarrassment to the state, you were a good candidate. But if you had ever, for example, investigated any complex domain, you would not get through the process. And no one, it appears, did. In the interview on those criteria, fewer than 10 minutes, as you'll see, were set aside to discuss expertise. And that portion of the discussion was led by the big tech corporate lawyer. So this is quite astonishing. Now, here's the other thing that we didn't check when we were hiring our new enforcer. We know that Meta typically, in its severance agreements, binds its former employees with non-disparagement clauses and with a good share of stock. So, for example, when Cerre Williams wrote her whistleblowing book, she was not allowed to testify, even in the Senate. Every time she speaks, she will be at hazard of losing £50,000. She told The Guardian this could bankrupt her, so she could no longer promote her book, Careless People. This is a standard clause. We wrote to the Department of Justice, we wrote to the state's recruitment body as well, and we said, did anyone examine whether this clause applied to this individual who is now responsible for policing these companies across all of the Union? And we also asked the Department of Justice, did anyone check if this person still has stock options in the companies that they're policing? And the answer was no. The Department of Justice gave a vague answer and refused to clarify it. So that's who we've hired. The person who was being replaced has left and moved, as Owen described yesterday, to a law firm. She is on this side of the picture. The partner who runs the law firm is on the right-hand side. Now, it's unusual for these people to be pictured together because once upon a time, she was supposed to be supervising Meta, and he was Meta's lead lawyer, and still is. Even today, there are many active cases where this law firm is against the Irish authority on behalf of TikTok and on behalf of Meta. There's a long list, I'll scroll through a few. Why does this matter? Ireland does not matter, normally. Why are we talking about Ireland again? It's day 2, we should have moved on. We should have moved on. Why are we talking about Ireland? Why does it matter? It matters because when we fail to make sure that Ireland doesn't just win a race to the bottom, doesn't just behave like a tax haven and a digital regulation haven. What happens is some of the most dangerous companies in the world get into the minds of our children. What happens is our data, which are collected from one part of a company's business over here for one purpose, end up feeding all sorts of other parts of these companies who we are trying to discipline and scale and create space in the market for our own innovators to grow. And the consequence of this mess, this internal data free-for-all, it no longer just applies to online advertising, it applies to everything. And if Ireland were forced to do its job, people would be able to use the services that they want to use, and these companies, which are not European, would be deprived of their illegal, massive, and unassailable head start in AI. We're not going to beat them unless we actually apply our law. So let me conclude, because I'm over time, with two suggestions. The first is that we are approaching July. And in July, Ireland will take the presidency of the European Council. There had been a concern that Viktor Orban was an unreliable partner at council meetings because his motives were irreconcilable with those of his European partners. I suggest to you that Ireland's track record on digital, and I say this only on digital and nothing else, should cause doubt in the minds of its partners, and Ireland should recuse itself from all digital files during the period of its presidency. My second suggestion is, and first this requires honesty, we are not ready to confront tech. They scare us. We think they're bigger than us. They're not. We're not ready to confront Trump. Well, he's smaller than he used to be, but we're still not ready. We need an arm's length way of dealing with these two and conjoined problems. Here's what that looks like. Ireland is not just the problem. It is the solution. It is the pivot. They've put all their eggs in this basket, except for Amazon, which is in Luxembourg. So let's force Ireland. Let's put it under pressure, proudly and publicly, to apply European law. Let's do that. And let's count. 1, she's going to push. 2, she's actually going to do it. 3, and see what happens. Fireworks, ladies and gentlemen, fireworks. And she's nowhere to be seen. This is just the application of technocratic, unbelievably not interesting European law. You might get some accusations that Europeans hate innovation. We've taken that sling, that arrow before. This is arm's length because it goes through Dublin. You don't have to own it, but you do have to do it. So let's recap. 3 things. Ireland is no longer just a tax haven. It matured a long time ago. There is something much more dangerous happening. It's still a tax haven in interesting and innovative ways. We can innovate, but it's worse. But it's not just a problem, it's a solution. This is the way to close the back door, and closing the back door into Europe's market would be profoundly damaging to these firms, and it would achieve political objectives that currently are unachievable. And you can do that at arm's length, ladies and gentlemen. Thank you very much.
So now we're moving on to a panel about GDPR and the Omnibus. So I feel like, Johnny, you should come back. But yeah, so my name is Juretzki. I'm based in Brussels, working for Amalex as a reporter, covering data protection and cybersecurity as well. So the Omnibus is also something we're covering very closely, of course. So yeah, I don't need to introduce Junie now, but we have some other speakers, of course. Max Schrems, the founder of noyb, David Diel from the Federal Ministry of the Interior in Germany, and Matthias Zellarius from SAP. So please join me. Thank you so much and welcome. So I was wondering, do you want to do a very quick round of introduction of what you do, just in one sentence, and we can jump right into the panel?
Better? Okay. Okay. Thank you for your start of the introduction already, Julia. My name is Matthias Delarius. I'm SAP's Group Data Protection Officer, and happy to be here with you today.
Yeah, hi. Thanks. Thanks very much for having me today. My name is David Diel. I'm the head of the unit for data protection law in the Federal Ministry of the Interior.
And then, yeah, Max Schrems, I'm the, I think, head of noyb, or however we called it. We basically do this litigation that Johnny has talked about before.
Okay. Thank you so much. So in this panel, we're going to talk about the digital omnibus. And since there are no Commission representatives, I wanted to say just that it's basically a digital simplification package. And the Commission presented it in last November. And their aim is to simplify EU digital rules, but of course it immediately attracted some criticism as well. And just to be clear, I also wanted to mention that there is a separate one on AI, but on this one we're going to focus on the GDPR and the data package. So before we get into it very deeply, I wanted to sort of have an opening question for everyone. Which is, as I mentioned, the omnibus is represented as a simplification, but many argue that it could reshape core concepts of the GDPR. So maybe in one sentence or very short, do you think this reform is about making the GDPR work better, or is it making it less strict? I think we can maybe start with Max.
I would have a twofold answer. There's, let's say, 4 or 5 articles that were discussed where there was stakeholder engagement, etc., that actually do simplification and that make sense and I think are good to pass. This type of simplification we could even have for much more articles. The problem is that last minute we slapped on 10 other things that were not discussed, that didn't have the time, that quality-wise probably don't provide simplification. Best example is the personal data definition. That means if you have 10 companies that work together, each company now falls under the GDPR, doesn't fall, is not sure. Like this is unmanageable for companies in practice, so not really any simplification. And that's the other bit. So I would have a twofold answer, to be fair, to say there is a bit where what was the headline is actually delivered, and the other half where, frankly, quite the opposite happens. And a lot of it is really lowering privacy protections as well.
Okay, we'll get into that more. David?
I agree with the twofold answer. I would say the same. Some of the provisions or some of the proposals by the Commission are definitely aiming for making it work better, such as, let's say, Article 12, 13, 33 changes. Some of it might make it a bit less strict maybe, but trying at least not to lower the standard of data protection. So in general, both, yes, but viewing it a little bit more positive.
Okay, I think twofold answer goes for everyone, regardless of what position you have, because the Commission had the task to basically to address some practical problems in the application of the GDPR, and also to remove some innovation barriers that came out of the Draghi report and all the discussions that came from that. And they addressed this task, and they brought in some of the topics that I would clearly put on the better part, but there are some other parts that I could see on the improvement side. So for me, basically, if I heard you, Max, talking about the definition of personal data in the context of SRB ruling, I believe it's actually an improvement. It makes lives easier for businesses, and I think we'll get to that probably later during our discussions. Then there is certainly the curbing of the abusive and tactical access requests that we have, and then ultimately we have a strengthening of research privilege on innovation that I would put on the positive side. And criticism, there's enough, and we'll get to that later during this discussion, I guess.
Thank you. Johnny?
I think, like the entire data protection project itself, the Omnibus is a total waste of time. It's purely an editorial exercise. You know, we legislated a piece of paper, put it on a shelf in Dublin, watched it gather dust. The idea Vivian Redding gave a great brief speech. Do you remember at the 5-year anniversary, she came to Brussels, spoke at the EDPS, and she said, I didn't propose this thing for the local butcher or the sports team. I proposed it for the big players and for the state. And then it went into the member states and they got into the nitty-gritty. That was the phrase. So there's a frustration, yes, for small business because of the nitty-gritty. But the strange thing is, we allowed ourselves to hype this thing up, and we never tried trickle-down compliance. We never made sure that the big players had to comply, and because they complied, the people who used their services were far more likely to be compliant by default. So there are issues to take with the omnibus, but the primary issue is that it is DG Just in the Commission that failed to make sure that the GDPR was even applied. They then proposed, under pressure from DG Connect, they proposed this revision, which doesn't make a whole lot of sense. There are sensible things to do. Let me just finally say, here's where it doesn't make sense in particular. If the objective is competitiveness, that slide I showed of the free-for-all inside of Google, which feeds AI, you could produce that slide for any other major US business. The answer, if you want to make your AI competitive, is not to retroactively legalize that free-for-all for AI. It's to enforce so that they are deprived of their illegal training data advantage. So, I know I was blaming Ireland, but the Commission is the other villain in this piece.
We really went from positive to negative, I feel like. So we'll get more, of course, into the personal data definition, but I also wanted to start a little bit with fundamental rights, because it was always something that came up in the criticism. So I have a question for Max and Johnny, but of course you are all always free to jump in. Where do you think is the red line between a legitimate simplification and a rollback of fundamental rights? And is there something that should not be touched at all? Maybe we can start with Max.
Hard question to answer. So I think the first issue that we have in this, and I'm probably the boring lawyer here, but a lot of stuff is just we have a legal structure and we have a constitutional structure in the EU, and there's Article 8 of the Charter. So we usually always start with Article 8, and Article 8 of the Charter is super interesting because subparagraph 2 has almost all of these GDPR principles literally written into the Charter. So if we have purpose limitation, we don't have that because some politician said that's a great idea. Some politician did, but put it in the Charter. And that we're just not going to be able to overcome. So to pick, for example, on the research exemption, to say that anything that is research that is now defined as anything that can create innovation, interestingly, base research would then be like fundamental sozusagen Forschung would be outside of it because it does not necessarily lead to innovation and money. That would then not get a privilege anymore. To say that whole thing doesn't fall, for example, under purpose limitation anymore, gets you into massive tension with the Charter. There would need to be some balancing, there would need to be something on the lower levels of the law that then is operationalizable for a normal company. And that's the next problem of the structure of how it's written then, is a lot of it is like you as a company then figure it out. Now, an average little research company doesn't have the legal expertise to do that. So the legislator, from my perspective in a democratic society, has the fucking duty to explain how this balancing is to be done and not just write risk-based approach. And that is how, from a high level, from like what the Charter says and requires, down to how the secondary legislation is drafted, we would need to get to something that a small and medium enterprise can actually work with, which would be if you fall under these 5 things, you're outside. If you don't, then you fall inside. That is then actually helping innovation in small companies without needing huge law firms to explain to them what the risk assessment should be. That is where we actually get benefits. And it was really interesting for us because we have a mailing list with 16,000 DPOs, data protection officers, and we asked these people, what is the loads of work? What would simplify your life actually on the people that have to implement that stuff? Totally different answers than the lobby bubble in Brussels. That was really like, the paperwork is a problem, these risk-based approach in the sense that it's just like free-for-all risk, which in our litigation means Facebook tells us we're low risk, so we don't have to do any of this. and then you litigate 10 years at the Irish regulator to say you're not low risk. That's useless regulation. And I think that is where I would have hoped for the omnibus to actually think about how can we regulate better, in better quality. And a typical example that we do in other areas is that we do, for example, classes of companies, that we say you're class A, B, C, and then I know I'm an SME, so I'm probably in a class A that has 90% of the companies in it, and basically half of the GDPR is simply not applicable to me because it's totally pointless that, I don't know, my mom that had a jewelry shop has to do a risk assessment. That's just like insane. And I think that is a regulatory approach that would actually have helped companies. But what we got instead is like this wacko AI article that just says, oh, it's a legitimate interest, big news. But then, for example, the balancing that is really the problem in practice of how far that goes still says, oh, there should be safeguards, but no one knows what these are. And that is where really I think we have to be, especially if we want to have European business succeed, be very honest that this is a regulatory approach that will help some big tech companies, it's going to help some law firms to make a lot of money with all of this uncertainty, but it's not really delivering on that headline, and I think that is a bit our problem. Counterexample, Article 35 on like data protection impact assessments, that was more something where like, okay, that simplification that actually helps, could have been done much better or much clearer, or data breach notifications that you don't have to do them 3 times, but 1 time. That's all super logic to do, where there's no opposition by anybody to do that. And I think that is what I would have hoped for more, to actually deliver for the 95% of businesses that, yes, the GDPR is overwhelmed. I'm self-employed. I have to comply with the same rules at Google. That's insane. But that is something where I would have seen much more versus like these things that we got actually.
I know you said you don't like the whole thing, but maybe you can pinpoint some stuff.
I was really struck by the opening speech that Mark Speich gave yesterday morning, and he was conjuring this picture of the social market economy, going back to Konrad-Adenauer, and that idea that there are fundamentals in society that are not only compatible with commercial need, but actually make that sustainable and more commercially practical. And I think that is what we need to keep in mind. We cannot lose that frame. I did an analysis of big tech lobbying shtick speech over the last decade. They keep banging the drum. Europe, your fundamental rights stuff, it's not compatible with innovation. That is not true. Yes, there are refinements that we can and should make. But what I have found is that when, for example, I was in the online advertising industry, and when I worked for a publisher, and when I worked for a web browser, I could see from different angles the disaster inside the online ad market. And the remedy to that disaster was application of a law that actually was there to serve fundamental rights. There is a synergy, a real one, between efficient fundamental rights enforcement and efficient markets. And when you don't apply data protection, which sounds like it's just to protect data, you devastate journalism, you wreck the information economy, and you hand your politics to US firms that you now can't trust. So the two things do go together.
If I want to add one sentence just to put it practical, for example, we heard the AI slide that you had before. Now, they want to make it easier to use data for AI. Now, that sounds wonderful and hooray, innovation. But we also have to ask who has that data factually. And if we liberate that data, it's going to liberate Microsoft, it's going to liberate Google, whatnot, because a European SME simply does not factually have that data. So by liberating that, you liberate for exactly the people that in other political speeches would actually be the ones that we want to cut back on. And that is where really I was really disheartened with the Omnibus when I read through it, where I felt, okay, we right now don't have the political or the bureaucratic personnel in Brussels that see these things, and also partly the lobby industry, so to say, in Brussels, just jumps on the headline of, oh, there is, I don't know, less personal data, that's good. But a lot of these like secondary situations that we get out of it are just painted over, not thought about, and then will probably make stuff worse than it is right now. Because we have no problem if, there's less paperwork or something simplified. For us, it's actually a reason that the GDPR probably gets less backlash, legitimate backlash, which is good for us. But that's not what we see there. So just to give you an example of how that really interacts with, for example, the AI thing.
So moving on to personal data a little bit, which was, I think we can say, the most controversial part of the Omnibus, changing the personal data definition, the GDPR. So I have a question for Matthias about this. Do you think narrowing this counts as, is the digital omnibus narrowing what counts as personal data under the GDPR? And if we were to redefine that, what do you think would change? And maybe you can give some real world examples.
Yeah, first I will do all of that, and I will use that also to package some of the replies that I have for Max and for Johnny, of course, to make this one an interesting discussion here. So that's a task now to get all of this done into one answer. So let me try. So first of all, we have already a ruling by the European Court of Justice on SRB that presets a little bit what the Commission has tried to put into action. And that's basically, we are moving to a relative identifiability, or that's how I would translate that into English in the end. So it's no longer the question whether someone down the line of people who get in touch with personal data is capable of re-identifying that person, or if it depends on the respective individual that has it in its hand. And Max, I think it was you came up with that and said that causes a problem because no one really knows what applies and so on. But on the other side, before that, let me give you the example what our customers and SAP is probably the only European, or one of the few European big tech players that are also affected by this law, what it means to us. So SAP, like every tech company, needs to innovate to stay relevant. And SAP, for those who don't know, does software, cloud-based, and still a little bit on-prem, but mostly cloud-based, that companies use to run their businesses. So it starts, it's your classical ERP system. It's with the internal processes that you use inside the company to run it in an economically manageable way, accounting, finance, and so on. It goes to something like HR data for human resources. It goes to your travel planning. It covers virtually every aspect that you as an employee have in your company life, but also that the company actually has. So it will produce, if everything's right, it'll produce or it'll help the company produce its financial statements and so on, everything that it needs, and that's a highly complex situation. And of course, a company like SAP would like to know how our users use the software, what they believe is good for them. They would like to know where innovation is. We are also in a competition with global companies that crunch the numbers faster than us because they can use other technologies. And for us, that also means in the AI space that we somehow need to access this data in order to train it to come up with some improvements. To give you one example, if you had access to information, how a decision was taken inside the company, and not only how the results of the decision and who was involved, but really how that happened, which is the contextual data that you have around that. If you have all of that, then you can come up with rules, and the next time the system is going to propose to you a decision that should be taken under a certain time pressure. We'll provide you with all the contextual financial information. We'll help you with the planning, give you the alternatives that you have for your decision, and so on. So something that our customers truly would want to see. Now, in order to do that, and you need the real-world examples. And our customers, they would like to hand over the data to us, and they do that in many parts of the world, with the exception of Europe. Why Europe? Because in Europe, they fear that despite all the anonymization or pseudonymization techniques, and we can discuss that, that's a whole story in its own, whether this data meets the criteria so that they can hand it over to us, so that we can learn from them, that we can improve our software, that we can improve algorithms, that they then later benefit from. They would love to do that, but they fear that they might see action against them in the end if they do that. Now, with this changing from a hypothetical risk approach, ruling out every risk, to a realistic identifiability, this changes considerably. If they can, that now means that they can hand over this data to us. If we, in the end, if it's somehow ensured that there is no means by which we could re-identify that, or no realistic means. And that's a very practical example that will really free up innovation also within Europe. And again, it's not just the big tech companies that are here and that certainly took a certain advantage in starting, but it's also for us on our catch-up game. And the one thing that's important to me is, and that's why I'm standing here right now, is we want to innovate in Europe. We want to innovate with European technologies, and we want to innovate based on European data, because this data depicts how this society works. We can only produce software that really meets the requirements of European companies if we understand them, if we can work on them. So that's for me the decisive point why I think the personal data definition needs to change in the way that the European Court of Justice has already said in the SRB ruling, and now the Commission is taking this one up. Sorry for the long answer.
No, thank you. I was just looking at Johnny because I think he wants to comment.
I've been in your job, so I empathize with the challenges that you've described, and I've had that exact challenge. For a smaller company, but we had, tens of millions of customers. In our case, in a web browser, as it happens, we designed a system that was called privacy-preserving analytics, and it actually was non-personal data. It actually was anonymous. No one was able to re-identify anything. But if that doesn't get you where you need to go, you're going to have to do a little bit of work to get yourself a legal basis. Now, of course, it would be nice not to have to do the work. I really don't like doing work, and when I was in your job, I particularly disliked it. I wanted a free-for-all. But I recognized that a free-for-all benefited Google, who we were competing with, more than me. European business has a terrible problem that the regulator never actually made the law real. So you can make a voluntary decision. Am I going to comply just to be good? Because no one's going to really check. I mean, not in earnest, right? When's the last time your record of processing activities was compelled? Maybe it's happened recently, but I'd be surprised. So you have a challenge. Am I going to volunteer to comply with this set of rules that actually doesn't matter? Or am I going to bind my hands when no one else is accepting the rules? The logical thing for any business is just to ignore the rules because they actually don't apply. Depending on which state you're in Germany, they don't apply. So I completely understand your position. But what if the rules did apply? You would be able to look at your competitors, and you would know that they will never comply, that they will always be at a disadvantage, and that you'll only have to do a little bit of work. You'll have to go to your CFO and say, I need a bigger team and a bigger salary. Of course. So I think, if you're pushing for the win, you actually want European rules because it will hurt your competitors.
May I just very quickly get back to you? First of all, Johnny, thank you for all your empathy, but I do love my job. If you didn't love it, good that you left it.
I did like
the profession. And I only have to say we do apply those techniques, and we provide our customers with those techniques to anonymize and pseudonymize their data, because simply we are the company who has the means and the efforts to develop something like that. So we have this solution. So thank you for suggesting. But the thing is, they still want some certainty what is possible and what's not, because it's always the question, what happens if it can be re-identified down the line somewhere? And you cannot rule out this risk as much as we still don't know what the borderline between anonymization and pseudonymization really is. And that's the thing that needs to change in order to free up this type of data for companies to be used. And honestly, let's look at that. The risk that really something may happen to an individual down the line, and I could give you even numeric examples. I don't have them with me, so bear with me for a moment. It's really so low in the end that that you need to take a right balance between the hypothetical risk and the reality that's out there. Thank you.
If I may jump in to resolve some of
I
this
also
maybe,
want to
but-
let David speak
Yeah.
at one point, guys. So
It's all good.
yes, please.
Just one sentence. I remember
Should have an extra panel in audience.
as the Biden revolution in antitrust was kicking off, the big sentence was, enforcement brings clarity for everyone in the market. And we never had clarity, so we're wondering what the rules are.
to make it very simple, I mean, one problem is what you described right now is the SRB thing. So I always wonder if the Court of Justice already found that that's not personal data, why we now need a law? Because like that's logically inconsistent. If that's already the law, why do we need to have a new article that actually goes beyond the SRB's judgment? Let's be honest. Second thing, for example, situations like you have where there's one finite last person that gets it. That is the SRB situation, where we can say that person realistically is unable to really identify the data. I'm on board that that's not personal data right now, already under the current regime. Now, the problem is to say we have a generally subjective approach. The whole cascade down is a totally different thing, and that's what the Commission really, when presenting this at the European Parliament, said. A parliamentarian asked them, is online advertisement, online tracking, now still falling under the GDPR? And the Commission was unable to say yes. He said it depends. If online tracking is not falling under the GDPR and regulated anymore, then we're in a totally different ballgame, and that's literally what we now see in this law, or at least how most lawyers are going to interpret it, how most big tech companies are going to interpret it. For another 10 years, we're going to then litigate if it's not that. This is the risk that we have, and I think what you were looking for as a solution, and we would be totally on board with that, is a definition of anonymization. That's what we need. Because right now, the thing of anonymization theoretically exists in the GDPR, but there's no article, there's no threshold. So what we would, as a good solution, have is technical standards to say, if you achieve this level, then it's actually anonymized, also for downstream, and then you're falling outside of the GDPR. This kind of gateway out of the GDPR logically must exist, because once it's not personal data, it doesn't fall under it anymore, but we need a pathway in the law for that. That would be good regulation, and that could free up stuff. But just now confusing pseudonymization, which every tech system ever works with pseudonyms. We're all not names, we are a number, and that's a pseudonym. To say, by definition, a pseudonym may not even fall under the law means, in the thinking, most technical systems don't fall under law anymore, and that creates so much more confusion than just saying that is anonymization, and we define that better maybe in law. That we would be totally on board with and would solve the problem you brought as an example, absolutely. Make sure that online tracking would definitely still fall under law. And that's, I think, where we want to go to as a, solution-based approach maybe, rather than just defending something that...
I have something to the solution, but I'll let you first and then...
Please.
It's all good. I mean, a lot of has been said already. I pretty much wanted to say something similar to what Max just said. I think a lot of the fuss about this definition of personal data in Article 4.1 is the text of the first proposal of the Commission, that it went a bit further than what the European Court of Justice jurisprudence actually did, especially only because data is relatively anonymous, because it has been pseudonymized. It doesn't mean that it will stay anonymous forever. And that could have a little bit been read into the original formulation of the Commission. In the Scania decision, it has been made very clear that once the data is held by someone who actually has the means reasonably to identify it, it will be personal data again. And I think the problem a little bit in this discussion is that this first idea of the Commission was very far in the wording, and now it has been this big pushback from guys like you, and I fully understand that, and also a little bit other member states in the EU, which are afraid that we're going to the core of the GDPR with this. I think let's be more practical, and let's advocate for a solution that actually most of the people will be fine with. Just codify, and I do think a codification of jurisprudence can be of use for the people that actually work with the GDPR. Let's just codify the jurisprudence. And yes, that doesn't necessarily have to be in Article 4.1. It can be in the definition of pseudonymization, or it could be something on anonymization. And German government has also been advocating for it. I think we need a regulation on, we need a provision on anonymization. People need to know how do we qualify this? What kind of legal basis do we need? Which provisions of the GDPR do apply, which do not apply? We're ready to do this in German law if this is not happening in the GDPR, but we're hoping that we'll find a solution for that, and fully agree with you on that.
Very quick reply, and then I guess we're not holding up the entire flow of the thing anymore.
I love a good debate.
Okay, so the thing is, so Max, I mean this, and also to everyone else, this does not go like we would want the data, and be outside of the GDPR and nothing happens anymore. Certainly data is far too valuable. Even if it's non-personal data is very valuable. I mean, that's the fuel that drives our economy. It's an old one, so I'm not going to drive to that on too much. But in the end, what we would do in that, and I think one of the member states has made this proposal as well. So if you, even to that personal data that would no longer be personal data under the relative understanding of the term, you would still apply Article 32. So there are technical and organizational safeguards. And we do that anyway. So any data that we deal with is because it's valuable to our customers. I mean, it depicts their business, and it's valuable to us because that's the source of our innovation. We do protect that. We make sure that it does not get misappropriated, that it does not get into the hands of somebody else, that it does not get lost or stolen. I mean, it's if you say that data is just as valuable as money as a whole, you deal with that like money. And like you have a controlling department, and you are a controller of the data, you account for the whereabouts of the data, that applies to all the data, to all your valuable assets and also that. So basically, if we moved from hypothetical risk to a realistic view, that doesn't mean that there are no protections in place at all, and that we would simply trash around the data. That's not what somebody wants. We want a more realistic approach to take away the burden from our customers that fear that they cannot hand over the data to us.
One last sentence. If you're a data broker, you exactly do that because that's your business model to sell all that shit. Then exactly,
I'm not a
you want
data
to get rid of it. You know,
I'm not,
but the law applies to all of them. That's a problem. I understand from your, for your business perspective, yes, but this law is a general law that applies to 100 sectors. Last sentence, hopefully. What a lot of people said, and even the Commission said in like a public statement, is Article 4.1 is this red herring, basically that everybody should get worked up about and discuss, to not forget about the other 20 articles. So maybe we got exactly on that track on this panel now. And if there is any option, I would probably suggest to move forward. And I don't know, but.
Yeah, I think we can continue discussion certainly over a beer's too early in the morning, right? But a coffee maybe. Yeah. So. Yeah.
Thank you. I think I was honest when I said I like a good debate, because I think it really shows that like how interesting and controversial this definition of personal data is when you have so many different views on it. So thank you, everyone. I wanted to go back to you, David, and ask if you wanted to talk a bit more about the omnibus in general. Like, what do you think it strikes a good balance, or maybe not so much, and if you feel like there are further changes needed?
Yeah, thanks very much. It's actually kind of funny because every time we have discussions on the GDPR proposal, I'm always saying, let's talk about Article 4 the last, because otherwise we're not going to be able to talk about the other things in the GDPR proposal. It's a bit sad because I think there are some good ideas in it. And for example, we as a German government, we put a big emphasis on this whole concept of state modernization, debureaucratization, making things a bit easier for especially small and media companies, making things a bit easier for people that deal with non-commercial activities, Ehrenamt. And we were looking a bit more on the proposal from this angle. And the discussion is always surrounding a lot on Article 4, on the provisions on AI. I fully understand that those are very important provisions for the companies. But I think there's some really good things in the Omnibus. We have, as German government, we have actually sent a position paper to the to Brussels in October last year already, and we're super happy to see that a lot of our ideas have actually been taken up by the Commission in the Digital Omnibus. And those, I would just like to mention changes to Article 13. I find it very important that in the day-to-day work for, let's say, small companies, we have some the burden of information requirements, etc., are a bit eased for them. It's very important, I think, that we have a change in Article 33, that only in high-risk cases reports are necessary. I'm also happy that we are about to lengthen the time frame for those a little bit. I think it's very important we have a provision in Article 12.5 with respect to the abuse of information requests. Nevertheless, I agree. We agree. There's still a lot of work to be done with respect to the text of the proposal. They have to be actually practically feasible for people applying the GDPR. My favorite example is the text of the wording of Article 13. We're now introducing new unbestimmte Rechtsbegriffe such as the clear and circumscribed relationship, non-data intensive. Then we have a lot of carve-backs. If I transfer data to a third party, etc., I'm immediately out of that provision. So the same as in Article 12, we have now we are talking, Article 12, for example, is very important for us that we are also shifting the burden of proof a little bit. It has to be easier for the controller to actually prove or to prove that there are reasonable grounds to assume that a request has been excessive. So there's still a lot of work to be done on the text to make it actually work, to make it so it's actually easier for the people applying the GDPR. There are some bigger, I don't want to overstep the time because this is the counting down here. Last thing, I do think it's very important we will find a solution on training and use of AI. I think that how it's approached now by the Commission is not the best solution. It's very fragmented. We now have Article 88C, we have Article 9, we have Article 61F, we have Article 4A in the AI Act, etc. I think it would be very, very good if we would find a solution on that and maybe have one provision on the legal base and also the rights of the data subjects, all within the GDPR or in the AI Act. I think that would be very useful. Yeah, maybe keep it with that.
Thank you. Did anyone want to react, Max?
I mean, what I generally wanted to, if we have a higher level discussion for 1 second as well, is if the thing we want to have is to free certain burdens from European business. Let's be honest, the data omnibus is not going to do it. Like exactly the examples you made, like in certain cases, less privacy policy, that's not going to raise anybody's GDP. Like this is just like decoration. And I think that is really where I was like feeling the problem that we need more evidence-based decision-making here. We need to really go into what is taking the time, especially for the 90% of companies that are not the big tech or big technological companies that just have to deal with this. Just like I have 25 employees and I have to deal with like heights of work desks because there are rules around that. Not my core business, but I have to deal with it. And that's the reality for most digital laws for a lot of companies. And we'd have to look into that, how we do that. And I mean, we had discussions even with the conservatives, which I found interesting because usually other side, to say, let's do a class A, B, C controller. So that's simple to understand. I'm a class A, I only have to do these 10 articles, the others not. That is something that a company can actually comprehend, gives legal certainty. And exactly the example you made before with, if it's not in-depth processing, I was like, we are a nonprofit organization with 30,000 email addresses. Is that in-depth processing or broad processing? I don't know. If I get it wrong, the penalty is 10 million euros. Like this is just regulation that is poor. And I think one fundamental problem, if we want to move forward with digital regulation, is we need massively better quality at the European Commission in drafting this. Like really this one, it's unfortunate to have to say that, but we right now don't have the personnel, it seems, in Brussels that A, understands where the problems are, B, gets enough time to actually do deep research and not just talk to 5 lobby groups and do whatever they want, and then really implement that in a well-drafted way so that it actually helps anybody. And what we get is probably an end result that neither really helps anybody real innovation, because the AI article is not going to solve any of the questions we have, and B, probably generates even more confusion. I think that is something that on all sides of the game we would probably have to push for actually better quality. Last bit, for example, on the abusive access request, a totally German debate, I have to say. Really not a debate anybody else outside of Germany. But we looked, for example, at our access requests that we did. 16% of them were properly answered. 84% of access requests right now are not properly answered by the industry. but we deal with abusive access requests, really? Like, is that the biggest problem? If we look at the real life situation, that actually people never get answers to the access requests, probably that would have made sense to legislate around that and not about the two abusive discussions that we have in Germany. And that's a bit of the problem that I see, is that we don't deliver on these promises. So even if you want to have innovation, this is not going to give it to you.
Thank you. Do you want to add something?
Definitely, certainly, because I'm also looking a little bit at the time here and not going to show how we're going to go here on this one. So first of all, I would like to remind people that we have, that there was a target set by the European Commission at the very top level. They wanted to enable the development of new technologies, AI, and they wanted to take away the burden. What the Commission has done is basically it's done an approach by looking at the existing GDPR about certain points that they could change, but it was not the big thing that really changed. So that's true, and I see that, and the question is whether this is possible. But let's look at one thing here. If we don't enable the use of AI within Europe, that doesn't mean, that doesn't only affect a company like SAP as one of the companies that's delivering it. It's going to affect everyone here in Europe, because every company here that does not just work in Europe, but is working on an international market, will compete with international competitors that also work in this market and that are working in global markets. And those companies that use technologies that make their business decisions faster will basically win this market overall. And it regardless of what industry you look like. So if someone starts using artificial intelligence on a global market and gets a competitive advantage out of that, and the others do not use that, they basically they're doomed. So this is not going to work. So ultimately, where we need to get is, we need to be in a position where European companies can use artificial intelligence and new technologies, and B, European companies have also a fair chance of developing that also in Europe and with European data. And I think that needs to be the big goal of digital omnibus and any reform to the GDPR that we undertake. Not the small things, it's the big picture that actually needs to change.
Let me add, I don't think that until that video that I showed you, until that statement had been made by the Irish regulator, I'm not sure anyone in the Commission knew that, for example, Ireland had yet to produce a finished inquiry into Google ever. What about the monitoring? You know, what about the Commission's role? We are not going to have European AI until we have created the space in the market for European AI. And we're not going to do that until we have forced the Commission, DG Just in particular, to do its job.
Okay, I mean, there are of course a lot of other things that we could discuss, but I think we should move on to questions. Yes, because we're already over time. I see a hand up there, and then someone else. Please go ahead. I think so. Yes. Thank you.
My name is Alessandro Ichuk. I'm from the University of Exeter and shaping research for digital markets research project. The panel is fantastic, so I wanted to ask probably for a few. Coming from the DMA microcosm, you just mentioned about data anonymization, and this precisely vocabulary and requirement is one of the requirements of Article 611. We have here in this room DMA enforcers, access seekers, brightest minds who shape the agenda. Basically, the only designated undertaking in this core platform service, Google, refers precisely to data anonymization and possibility of de-anonymized data to prevent access, not to give meaningful access to their data, to click and query data, to access seekers. It's a labyrinth and it's a whack-a-mole game, we all understand this. So I wanted to pick up your expertise to reflect how to address this conundrum. Thank you.
Maybe together? Yeah, okay, please.
Yes, hi, Robin Burgeon. I also had that job. I was in charge of the GDPR at the New York Times for 5 years. And yeah, I agree that the pseudonymization thing would have been catastrophic for us. We would have absolutely hated the complexity it adds. But I wanted to ask about one thing that I find that is positive in the Omnibus, and that's Articles 88A and B about automated signals. Like Max, you've worked on it, like Johnny, you have experience with that as well. And there's one thing that confuses me somewhat about this article, and I'd like to hear the opinion of the panel on it, which is in the US, so this article is about automated signals to opt out of your data being shared to further controllers. In the US, the media strongly advocated in favor of having rules like this because they protect media companies from Google, from Facebook, etc. But here in the Omnibus, we have a media exemption, which means that the protection that at the market level this article should be adding is being removed from those who are most likely to suffer from the problem. So I wanted to ask, what is that about? How do you feel we could, evolve Article 88, A and B particularly, to, make it work better?
And I think there was one more question, yeah. I know it's difficult to answer all this quickly, but...
maybe also
memories.
have a question, have a remark. Thomas Schelf, I'm a political advisor on digital economy and structural change. So if I did not know that today is April 15th of 2026, I could feel with the entire debate in the year, thrown back in the year 2008, talking about the e-privacy directive. The idea of pseudonymous data was the basis for a very productive SME-based digital economy in Europe. So to say, being a man in the middle between the big platforms being under creation and the media landscape and the user on the other hand. And I have huge debates in the US that they say, oh my goodness, it's complicated, something between PII and non-PII. Today we have the different reality that we have the market dominance of a few platforms. So GDPR will not be able, in any constitution, to overcome this idea of market dominance. So the issue is, I think, between Johnny and Matthias, on the one hand, we have to create a law fitting all the needs and purposes, also for innovation. So we can't put innovation drivers out of the law framework saying, hey, Facebook, you're not able to use, and not or hope that European companies will create innovation on the one hand. So we have to overcome the idea that GDPR has this market effect. And maybe the last points you mentioned, Johnny and Matthias, this could be a particular, we could have a more deep dive how we overcome the situation that we haven't the chance to set a GDPR banning more or less the platform providers on the one hand and driving innovations on the other hand. So where we have the chance to create a new market environment leading to more innovation and of course then also to a little bit more of GDP. Thanks.
Could I start on that?
Yeah, please.
So the point that I hope I've been clear about in my remarks this morning and yesterday is that the GDPR should have a market effect. But, well, it doesn't, because it hasn't actually been applied to the US firms at the top of the market. So, in my view, yes, we should do many, many things to promote innovation, capital markets union, lots of things that are in the Draghi report. But those things may die on the vine if we haven't pushed back those dominant firms, which are cascading their monopolies by infringing purpose limitation. So once they win in one area, they just drop it into every other area. If we don't push them back and create space in our market and free that space from companies that have dominated the market by breaking our law, we will be unable to scale our innovators. How? I mean, I showed you a diagram with a lever. It takes political pressure on Dublin in particular. And what I would suggest is, I can give you a very specific how, because we would love to be able to litigate on this and we have all the material. We are blocked from taking that litigation because even though we're able to use the Collective Redress Directive, the Irish state prevents us from raising commercial funding. So we will talk to any regulator who wants to listen, but we have yet to find that regulator, who wants to listen to the kryptonite evidence that uses purpose limitation inside the big tech firms. It is there and they are profoundly vulnerable.
I think you wanted to add something.
I wanted to add something, and I realized that we are now focusing only on the last question here. But for me, that's one of the most relevant ones here, actually. So I need to understand what that means to push big tech out of the European market. Because,
Not out.
but basically the thing is, and take away the illegal data treasure that they have already accumulated. So first of all, that's not going to happen. European enforcement is limited to Europe. They will continue to do that outside of Europe, and certainly companies outside of Europe will continue using the technology that they provide. Giving them tools to those companies that are using this data and giving them the advantage, basically, of using the AI that's on it. So this will lead to a situation that potentially European companies can't use that anymore because they can't. It's not going to be offered in the European market, but others are using that. And then the question is really, and I don't have the answer to that. Which technology is the better one? The fairer one and the more legal one, morally on the better ground, certainly I would agree it's the European one. But is it the one that will help European businesses, regardless of what industry they are in competing in the international market, if they don't have the same tools, if they don't have the same AI wisdom? We are not going to push that genie back into the bottle. It's out. So basically, I think the best is to focus on what we are going to do going forward. How can we help European companies actually catch up? And the one thing is, how do we make sure that going forward we have an international rule set, as unlikely as this is going to be, that puts an international standard to that so that everyone is on the same level playing field. And we have not yet discussed the Chinese. We are just discussing US big tech here in this thing here. So it's a huge problem that I don't have the answer, but that we need to resolve. But it cannot be that we resolve it with a detrimental effect to the few European tech companies that we still have there. And that's not just only us in the IT sector that we are in here. It's also other companies, like in the automotive sector and others, that are also using data in order to enhance their products, that allow for autonomous driving, that allow for all these nice little things that are going to have an impact on how we live in the future. And I don't want Europe to be fixed to the 1990s from a standard of living and for the development, whereas everyone else in the world moves on.
Thank you. Sorry, I know I wanted to react, but I think I have to cut you because we have 3 minutes, otherwise we're gonna have a big problem. Exactly. So please keep it short. I know it's difficult. If you wanted to answer maybe some of the other questions.
I mean, I have a list. I don't know if you're... Yeah. So first of all, on a DMA question, I think that could relate to a proper definition of anonymization, and that would probably be a technical specification. That could give that legal certainty to use some of these things, and then later, also on the other side, if Google suddenly finds the GDPR as a reason to not share data, to also tell them, you know, there is this definition, follow that definition of anonymization, and then it's also freed up for someone else to use. I think that is exactly where clarity in the law helps the smaller guy. Like uncertainty in the law typically helps the people with the big law firms. So I think that exactly, to clarify these things, would probably connect your question to what we said before. Second thing on Robbins, on Article 88A and B, that is one of the things on A, for example, where we would now allow more use of personal data from cookies, basically, to limit the need for cookie banners, which would mean that 90% of the companies probably wouldn't need a cookie banner at all anymore because they use it just for statistics. And if you anonymize that, then you would fall outside. That is exactly something that helps. I know not SAB probably, but tons of other companies that deal with the GDPR as well. That is something that would help, and exactly the signals is something that would help as well. Why the media exemption? Basically because in Brussels everybody's worried that once Axel Springer says we don't want it, it's impossible to pass anything in Europe. That's, I think, the reason they put it there, but they're still against it, so who knows why. Last thing on the whole question of innovation and the German situation and so on. One thing I really, as an Austrian that speaks the same language, watches a lot of German news and so on, a really thing I have to repeat oftentimes here is it's a extremely German debate to say basically the GDPR is the reason why innovation doesn't work, this strong link. We have all the other reasons of financing, blah, 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 that were all mentioned today as well in the morning already, why there is problems with innovation in Europe. So we also have to say that GDPR is probably not the sole reason, and solving that and even killing the GDPR 100% is not going to solve these issues. Just like the media debate in the US, there is no GDPR, still media is dying. So logically, the GDPR cannot be the reason why media is dying. And I think to solve the problems again, we need to look at the real problems and try to find them and not have quasi-discussions that also don't solve the problem after all. And one part of the last questions that could, for example, go a little bit in that direction of how do we separate from the big and small guys is, for example, what we developed with the Axel Voss idea together, is to say, can we have a class A, B, C company? Because then we know most Europeans are going to be the class A that only half of the GDPR actually applies to. That actually frees up time and energy and compliance time. That would be something I would have wanted to see in the Omnibus that could have really solved that. Last bit, where I have a bit of a problem is with the argument of, oh, there are other competitors out there, which is largely the US, we have to say, because about 100 countries in the world have a GDPR-like law somehow. It's really the US as the big outlier on the market that doesn't. And to say if they are innovative, we have to lower our system, otherwise we have a hard time to compete. That would be true with any European law. Like then we also have to get rid of all environmental laws and worker protections and whatnot, because there's always someone else in the market globally that has less protection. So to a certain extent, we probably also have to swallow that. I hope that's useful for that debate, because that would pretty undercut most European laws if that's the argument.
I'll let David
close
panel.
A lot of things have been said. Just adding shortly to what Max just said, it's of course not about the substantial law only, it's also about the enforcement and interpretation of law. And I mean, we see the GDPR, one of the main goals of the GDPR is to make a level playing field in Europe for companies that work with data. In Germany, we have managed to have 17 federal and state agencies, DPAs, that monitor this. The question is, do we need that? Is it actually the way it is? Is it a good system, or do we maybe need to centralize authority, especially with respect to the economy, a little bit more in the Bundesbeauftragte instead of only the states, the federal states? And that's something that's been that's part of our coalition treaty. And it's also part of the federal modernization agenda of the federal chancellor and the prime ministers. And that's something that we haven't discussed yet, but it's maybe something for another talk. But very important for us to work on this topic. There is no decision yet on what we're going to do, but be sure that we're also going to tackle this issue.
Thank you so much. I have to apologize for the overtime. I think I saw some more hands up, so I invite you to come and catch the speakers after if you have questions. But thank you for being here. Thank you for listening. Thank you for your questions. And thank you so much to the panelists for their thoughts.
Hello, everyone. I have the pleasure of moderating the following panel on the digital omnibus. If it is a step forward, an actual improvement. And before, I have the pleasure to introduce Björn Juretzki, head of the unit on data policy and innovation at DG Connect at the European Commission. So it is the public body that is driving forward initiatives such as the Data Act and the Data Governance Act. And he will give a keynote now following a discussion with other panel members.
Everybody, good to be here again, as usual. So, I mean, following the previous discussion, it's now the villain speaking who doesn't know a thing apparently, so get ready for a wild ride. I'll talk about the digital omnibus, especially the data part. I mean, we heard about the GDPR part already. So I'll focus on the Data Act in particular and the consolidation of the other instruments, the Data Governance Act, the Open Data Directive, and the Free Flow of Data Regulation. I will also, because it was so much fun before, talk a bit about cookies, since my team is in charge of cookies. I see there's already enthusiasm over there, and that's always a very nice topic to discuss. I already saw the previous discussion. So, I mean, what is the objective of the digital omnibus, just to set the scene again? I mean, so it's really a very targeted burden reduction exercise. This is what we want to do. We don't want to rewrite the whole data acquis. We just want to reduce the friction for business to operationalize these rules, and in particular also not lower the level of protection. I think that's important to keep in mind. This is also based on extensive stakeholder input, not just speaking to 5 stakeholders that was alluded to in the previous panel. I mean, literally hundreds of stakeholders. I mean, in the month before, before the digital omnibus. I hardly did anything else but speaking to stakeholders. So we had like a public consultation with hundreds of submissions, an SME panel to get the views of SMEs, implementation dialogues chaired by our executive vice presidents, sectorial stakeholder workshops, and so on and so on. So it was really a very wild not, but wide consultation exercise. Maybe also wild, but more wide than wild, I would say. So let me talk a bit about the Data Act. I mean, you're probably all more or less familiar with the Data Act and its objectives. So it's about, among other things, giving the control to the person who has bought or rented or leased an IoT device, and then this person can decide what happens with that data. For example, also passing it on to another third party. Already in the Data Act, we have a number of mechanisms to prevent that data sharing, for example, in case of trade secret leakage, when serious economic damage can happen. And now, following the stakeholder feedback, we propose now to extend this trade secret handbrake and also enable data holders to withhold data when there's a high likelihood of trade secret data leakage to third countries. This was a feedback we heard from many industries, and I would be interested to hear what your point of view is. I see some stakeholders who aired this before already, that this is a concern that the Data Act liberates data, but I mean, what happens if this data goes to jurisdictions which have much less IPR protections than Europe? And now we have this new mechanism which hopefully addresses this issue. Very important to note, of course, that we still want to maintain the balance between, on the one hand, making data available under the Data Act and at the same time also protecting the legitimate interest of businesses. So all the oversight mechanisms we have in place stay also in place. So if you withhold data using this handbrake, you have to notify competent authorities, for example. There are the dispute settlement mechanisms that we have in place. We also have the European Data Innovation Board and the competent authorities which will monitor the situation, and any abuse will be discussed there as well. So I think the balance will be kept. Another aspect of the Data Act which we are changing is the so-called business-to-government data sharing chapter. This was originally born out of the Corona experience, where governments also needed to have access to certain business data, for example, telecommunication data, to monitor compliance measures. So we put that on a solid legal footing, but following the stakeholder consultations, we also found that the concepts we had originally included in the Data Act were a bit too broad and too vague. For example, we had a concept in there called exceptional needs, so that also business data would have needed to be made available if there was an exceptional need by public authorities, a bit vague, a bit broad, and now we propose to limit this to public emergency situations only. So also providing more legal clarity to businesses. The Data Act also deals with cloud, and it facilitates cloud switching. For example, it abolishes cloud switching fees and does some other things. But also here, during our stakeholder consultations, we found that there are some issues that businesses have with this, in particular adjusting cloud contracts signed before the Data Act into application on 12th of September 2025. And with the Omnibus, we're now proposing to exclude those cloud contracts from the application of the Data Act, so cloud providers don't have to renegotiate thousands or even tens of thousands of cloud contract, and this, I think, also prevents many legal fees they would otherwise have to pay to lawyers. Finally, we also remove an article that dealt with smart contracts. We were probably a bit ahead of our time with that article, where we tried to specify, what the elements of smart contracts are and how they should be handled. And now we're proposing to remove this article entirely and leave smart contracts to market forces. This is what we do on the Data Act. Now moving on to the consolidation of the other instruments, the Data Governance Act, the Open Data Directive, and the Free Flow of Non-Personal Data Regulation. So the idea here is that we get rid of all of them and we move the relevant parts into the Data Act. So ultimately, they will just be like one instrument dealing with everything we're doing. That's the Data Act, and then you have the GDPR with personal data, if you want. In the Data Governance Act, and now in the new Data Act, if you want, we've created this instrument of data intermediaries. Data intermediaries are neutral data brokers that connect supply and demand. And in the original Data Act, this was an obligation for these intermediaries to register with competent authorities, and then they're being monitored. But I mean, that we found was quite a heavy burden on these intermediaries, and as a result, we only saw, I think, 24 intermediaries emerging in Europe. And now we're proposing to completely remove this requirement and hopefully liberalize this as well. At the same time, the label stays in place, so you can still register to become a data intermediation service provider, but it's voluntary. And I mean, we hope that this, of course, still attractive for companies to register. It's an additional trust signal if you register and you get this label as an officially recognized data intermediation service provider. We do the same for data altruism. Data altruism is this idea that you can donate your data. We've included in the original Data Governance Act so-called data altruism organizations. Also, you can register. This wasn't an obligation, but it was voluntary. So you could register and then also use an officially recognized label. And now we're proposing to remove a lot of the very stringent requirements we had originally for these data altruism organizations. So the label stays in place, but the requirements are lifted a bit, and we also hope that this will increase the uptake of data altruism organizations. And when it comes to the reuse of public sector data, this is the original Open Data Directive, which we integrate into the Data Act. We also merged the relevant rules we have on public sector data from the Data Governance Act and the Open Data Directive, and we include clearer definitions. I mean, this is really the nitty-gritty for the legal connoisseurs, if you want. We extend it to non-digital content and so on and so forth, but I think the main thing is that it's much clearer to have everything in one place and not distributed over 27, because it's a directive, national implementations, and the Data Governance Act. So there's just one place to check for the rules on access to public sector data. And finally, there's the free flow of non-personal data regulation. The main provision there is to prevent or to prohibit data localization requirements in the EU. And we keep that provision and move it into the Data Act, but repeal the other provision. So out of 4 rules, we just make one set of rules, which hopefully make things a bit easier. Now moving on to cookies, the topic we all love, you know, the dreaded cookie banners, who doesn't like them? And we've also detected, of course, a lot of consent fatigue, I mean, including with myself. I mean, you just click on something to get rid of the cookie banner. No one is really reading what's in there, and that's, of course, not the intended effect. So we propose to move the cookie provisions from the e-privacy directive into the GDPR. That also means into the enforcement framework of the GDPR, and that alone already creates a lot of, or reduces a lot of fragmentation that we see or have seen before. Some of the key measures that we have, and it was already alluded to before, these articles 88A and 88B. 88B deals with centralized preference settings, so you should be able to, in the browser, say, I don't accept cookies, so I accept cookies, and then websites have to respect that signal. And yes, there is this media services exemption that we already talked about, since this is really vital and important for their business model to still ask that question. In addition, there should also be a single click refusal. I mean, nowadays, if you look at the cookie banners, there are multiple menus. You click on something, another menu pops up, and you should be able, under this new regime, to just refuse cookies with one single click. The validity of your choices should also be respected by 6 months. So not every time you visit the same website, they ask you again and again what your preference is, but I mean, they should respect this for 6 months. We also, in addition, include a wide list of for low-risk purposes. So, you know, for certain purposes, you can also process this data without asking for consent. I mean, that, for example, includes network security or certain aspects of audience measurement. And we think that with all these measures, we can reduce cookie banners in the EU by roughly 50%. Maybe that's a bit too optimistic, but let's see. And that translates into savings of around 1.5 billion euros, because businesses don't have to produce and host these cookie banners any longer. And in addition, of course, it gives also users much more control and addresses this issue of consent fatigue, we hope. So to conclude, we address a lot of different aspects on the data part of the Digital Omnibus. There's the Data Act, where we make it more business-friendly. We lighten the regime on data intermediation service providers. We reduce the fragmentation when it comes to public sector data, and we address consent fatigue when it comes to cookies. Overall, we estimate that this package leads to cost savings of around 5 billion euros, much less fragmentation. I mentioned the cookie example, but this is true across the board. So it will be a much more coherent implementation regime, and of course also greater legal certainty. I mentioned the example of the business to government data, where businesses told us, you know, what does exceptional need mean, and now we've taken that out. At the same time, and I just want to stress that again, also not of the previous panel, no reduction in the level of protection, and all the strong and enforceable safeguards and enforcement mechanisms stay in place. especially for trade secrets. Maybe just to, before we conclude, give you also a bit of an outlook where we stand in the negotiations in Brussels. So as you know, it's the Council, the European Parliament and the Commission. We've made our proposal. Now Council and the European Parliament have to make up their mind what their position is. Council is a bit more advanced, the member states. There are first compromise texts being circulated by member states, and no member states can comment on these texts. And the Cypriotic presidency still has the goal of concluding these negotiations during their presidency, meaning before June. Let's see if we get there. The European Parliament is lagging behind a bit more. They take a bit more of that time, also because it's more complicated. I mean, you've seen now the digital omnibus in its entirety, and it touches upon many different aspects, which also means there are many different committees in the European Parliament involved. There's the LIBE committee, which looks more at the privacy issues. There's the ITRE committee, which looks more at industrial policy. And it just takes time for them to reconcile these different positions and come to a conclusion. And I mean, we hope that they also have a vote on their position, in the third quarter 2026, and that we can advance into these so-called trilogue negotiations where Council, Parliament, and Commission sit together and try to hash out a compromise still this year. Looking ahead, the digital omnibus is just the first step, if you want. We've also launched a digital fitness check, so consultations don't stop, unfortunately. You have to submit more position papers to us. And in light of that, we will then also assess whether there's a need for additional omnibuses or additional measures that we have to say. So with that, I'll pass the floor back to you, and looking forward then to our panel discussion.
So we've had some illness-related changes. So please, I would like to introduce Jesko Gabriel from the Bundesnetzagentur, the main regulatory authority in Germany on infrastructure. Then we have Dominik Rose from VIII, the Association on Electronic Industry. Then Philipp Stammler from the newly created Federal Ministry for Digitalization and Modernization. He heads the unit on data economy there. Then we have Michael Dose from the Umbrella Association of the German Industry, Bundesverband der Deutschen Industrie. He is senior advisor on digital policy there, and of course, Björn. Björn, thank you again for the keynote. So you've mentioned stakeholder feedback regarding the Data Act, especially on trade secrets protection. So my first question goes back to the stakeholders in our panel. Dominik, do you consider the proposed article in the Digital Omnibus an improvement in regards to these concerns?
Yes, thank you very much. Thanks, Björn, for your remark. I think the digital omnibus comes to the right time. However, as we assess the approach and what have been taken is not enough to actually protect or to promote the data-driven industry in Europe. What we see is, and this goes without saying, the use of AI and data has an enormous potential. Recent studies has shown that by 2035, around 350 billion can be earned. However, this is if free flow of data is really achieved. What we, however, see is that the instruments taken by the Data Act is actually not sufficient to achieve these objectives. Actually, by contrast, our concern is that by data sharing obligations, and that is the feedback that we receive from our members from the electro and digital industries, is that data-driven products are probably designed in a way that less data is actually generated and that less data can be shared on the market. Why is this so? This is because data sharing is mostly based on trust, and we don't see that an obligation of sharing data can promote sharing of data. It's all about trust, and I don't see that a regulation can basically promote this trust. When it comes to the trade secret protection, we do recognize that the Commission see especially the, let's say, the downfalls when it comes to trade secret flows to third-party countries. This, however, has been in the Data Act before as well. And we see, or we still see, that there are many obstacles when it comes to trade secret protection for the trade secret holder. The barriers are still too high. And what we see is in a global competitive market that other areas like the US, like China, don't have these kind of obligations of sharing data, even though there are trade secrets within these data. And only European companies are obliged to do so. And we don't see that these measures that has been taken are actually sufficient.
Dominic, you've mentioned trust, and you said trust is well, a key foundation for data sharing. So this brings me back to the new competent authority on enforcing the Data Act. I mean, Bundesnetzagentur has been now officially named by the German implementation law, Durchführungsgesetz zum Datengesetz, Datenverordnung. How do you see, like, what is the strategy of the Bundesnetzagentur in ensuring that there is trust in this new data sharing regime? Yes.
Okay, it's working. Yeah, thank you for the question. So perhaps let me revert back to the first panel and carry on with a twofold approach. So I think on the one hand, and this is the more important part, is that this is a different regime from what Bundesnetzagentur is used to, being a regulator of markets where there exist monopolies. And because this regime is different, our role also is different. So with regard to the Data Act, we see ourselves more than a supporter or enabler of the market players, but you have to keep in mind that the market players not only consist of those that hold the data, but also that seeks access to the data. So it's complicated, you could say, but the way that we are looking to approach this is, and what we are already doing is basically holding stakeholder dialogues, keeping in touch with the market players, and our aim is also to come up with guidance as soon as possible. And this is also something that we are already involved in. So, for example, we are exchanging a lot with our colleagues from the other European member states, be it under the EDIP or other formats. And we are already working on guidance. So, for example, we were in a meeting before Easter, and we discussed also the trade secret handbrake. And there's actually one CA now working on the first draft of potential.
One CA?
Competent authorities. And they are currently now working on a first draft, which will then be discussed. And we might come up with internal guidelines, which then will, at a later point in time, perhaps somehow see the light of day, be it by information on our website, etc.
That would be great. And you've mentioned that there are market interests on both sides. You have the data holders, usually the manufacturers of connected products, and then you have potential innovative, let's say, companies that could use the data. So, Michael, you have a broad overview of the German industry. What could you say, what is the status quo there? Where do you think this could go?
Yeah, thank you very much, and thanks to Pencho, first of all, for inviting us to this great summit once again. So the Data Act is now applicable for 7 months, and so maybe not the best time for a deep impact assessment, but we have the first impressions, and what we hear from companies is that there are only very few requests on the Data Act based, and so this might be that's the reason why this is the case. Might be we don't have a competent authority yet. Yeah, we expect it in May to have it published in German law, and that the Federal Net Agency is in place. But I think our member association Bitkom last summer published a very interesting study. So there were 500 companies asked how their implementation level on the Data Act is, and the results were quite shocking. I have to say, because 30% answered they haven't started, but 50% were in the opinion that they are not in scope of the Data Act. And this is, I think, a big problem, because I would think that from these 50% of the companies, I think at least 45% are in the scope in some, or are in the scope in some level. And yeah, so now we can ask the reason why. So the Data Act was based on the assumption that there will be more data-driven innovation if we try to make this data sharing obligations. I was a little bit worried during the Data Act negotiations, because when we as BDI, who are representing 100,000 companies, only had also a few companies within this whole discussions telling us we are really happy with the Data Act proposal. We are really happy to be on this side, to now get access to the data and to share it to other parties. So this was really surprising for me. So maybe it was a little bit, the effect of the Data Act was a little bit overestimated. So it's not my hope that it will be like this when we think about the Data Act in 2 or 3 or 4 years' time. But I think, yeah, this is part of the situation. So yeah, the implementation process is still in place. We are happy that we will have the Federal Net Agency as a single point of contact for companies, giving guidance, helping, implementing these new rules. But we are also happy to have the Digital Omnibus, to also have like these first adaptations. The best solution would be to have this within the Data Act negotiations, I have to say, if we would have discussed this B2G and trade secret part there. But it's good to also have these changes at an early stage.
Yeah, so I think this points to a bigger question. So I don't know how familiar you are with the nitty-gritty of the Data Act. It does allow for a lot, like a broad sense of data sharing obligations, even when there are trade secrets involved. So it is quite a forward-thinking data sharing regime. And it brings me to, or like what Michael said, brings me back to Philip. What do you think? Why is, I would say, the state of the German economy so that when there is such a data sharing regime, no one is picking up?
Well, that's a hard question, but thank you anyway. First of all, I would like to mention that right now we're just talking about one part of the Data Act and of the Omnibus. Björn mentioned all the other parts that are involved in this part of the Omnibus. It's a very big Omnibus, and the Data Omnibus alone is a double-decker with, to be in the picture, with many diverse passengers on board. So what we're talking right now is the one part of the Data Act where it comes to data sharing between market players where IoT machines are involved. And when we talk about this part, my impression is that most of the time we talk from a point of view of compliance, from the manufacturer's point of view. And Michael has mentioned, probably rightly, all the others could also raise their voices and say, we are fine with that, and we are very happy that there is now this new law which allows us to go to our contract partners and ask them to provide data. And yes, we do have discussions with all of these market players. Many of them play in niche parts of markets where there are monopolies. But we also see startups coming that have a broader look on the market and try to see opportunities to get hold of a broader set of data. And so I would also echo what Michael said. We are still at a very early point of adoption of the Data Act. So my impression would be that we should take some more time to see how it really works on the ground and what people really make out of it. But having said this, I would also like to take a little bit of broader view. What are we trying to achieve with the Data Act, with this part of the Data Act when it comes to IoT data? We want to, well, it has one component of consumer protection, but more from a macroeconomic point of view, there is this hope, the wish that with this legal instrument, we will make more data available for the wider economy, for innovation, for efficiency, for R&D and whatever. And I think we have to be clear that the Data Act itself is not the only instrument to achieve this. Trust has been mentioned before, so legal rights to access data, I think, are very important. But if we want to gather, if we really want to open data silos, if we really want to gather data on a broad scale, these single rights are probably not the main instrument for this. We need more.
And what you are at the Federal Ministry of Digitalization. What are other instruments the federal government is thinking about? Yeah.
Well, one part of the Data Act, the Data Governance Act, are the data intermediate service providers, and I think this is a very important instrument, not necessarily the DISPs as laid down in the Data Governance Act, but on a more broader view, instruments, rooms, data rooms, where actors can come together and share data in a form of trust, in a regulated way. By regulation, I mean self-regulation, where actors can come together and define on their own the rules on how to share, what data to share and why to share it and how to share it. I think these are very important instruments that we, not just we as the BMDS, but as the government as a whole, promote very strongly the creation of data rooms. So this is just one example. I don't want to talk too long.
No, we're good, but thank you for keeping the time in mind. It allows for a livelier discussion. Björn, I've seen you scribbling away.
Absolutely.
But I will also have to ask you a question. That's just fair. But you're certainly allowed to react in a timely manner to what has been said, since you are defending the proposal, I assume. But would you say the Data Act, especially these data sharing obligations, are a classic top-down regulatory approach? So the European Commission is creating a framework and hopes the world will follow in a way?
I mean, let me maybe begin to react to what I've heard here. I mean, I hear your concerns, Dominic, but at the same time, I find it difficult to argue with the principle that a person or company that has bought a car or industrial robot or any other device has no control what happens with the data that that device generates. I think to argue with the principle, it's very difficult that that person should have no control in what happens with that data. And this is the origin of the data. That also maybe answers your question a bit. I mean, it's a bit more, it's a bit deeper than, you know, it's just a piece of industrial policy. I mean, it's, yeah, I mean, you know, who can set the conditions for accessing the data of these devices? And I think it was underlined here that trust plays an important role in data sharing, and I think we all fully agree with that. And I mean, there we also have the other instruments. Some of them were already mentioned here. And during my speech, I also mentioned these data intermediation service providers, the neutral data brokers that connect supply and demand. Also, the intention was, of course, to have this neutral intermediary which increases trust. It didn't really fully work out, but I mean, we were trying to still save the concept, I would say. And Philip and Tim already mentioned also all the guidance documents we are providing. I mean, there is guidance coming up on the definitions in the data Act because we understand they were not completely clear. There will be guidance on reasonable compensation. We have set out model contractual terms to help with the contractual drafting. We have developed guidance specifically for the automotive sector to facilitate the application there. So I think we're doing all we can to increase trust even more and to help with the implementation. But I think Michael mentioned also a very good point, and that's still the lack of demand. I mean, we have to be open and honest about that. And I think our task in the months and years to come will be to stimulate demand. And we're now trying to do that in the automotive industry. We work together with OEMs, the manufacturers of cars, the aftermarket, insurance companies, and so on to see, okay, what are still the bottlenecks? Why is there not enough demand? And maybe we can replicate this in other areas as well. And finally, and I'm glad this was mentioned, I mean, it's still seen so much as a compliance issue, and we always try to put the focus on it's also an opportunity, even for big companies. I mean, they can suddenly get data they couldn't get their hands on before. And this is, I think, something that should also be seen there. And to answer your question, I don't know if you mean follow the world, literally the world, but just to say that we also see similar developments in other parts of the world. Brazil, for example, is very keen to, like they did for the GDPR, to learn from the example of the Data Act and introduce similar rules. In Australia, you have a more narrow regime when it comes to car repair. So, I mean, there are similar regimes popping up here and there. And as I mentioned when I began my answer, it's really, I think, ultimately about the principle. I mean, who should have control over the data? Should it just be the manufacturers, or maybe not also the person who has actually bought the device and uses it on a daily basis?
Very good point. So if we look at the, let me allow to characterize the both political bodies as the head, like the where comes the thought of the Data Act, and the hands, which would be the Bundesnetzagentur. And
I like that picture.
I'm sorry.
Sure you would.
But I've looked at the law that now allows the Bundesnetzagentur to be the competent authority, and both of you have underlined the information aspect of Bundesnetzagentur, but there is a strong enforcement aspect. At least the law gives you these competences, so you can conduct investigations by your own right, not only through complaints. So there's some teeth, and I would like to ask you, how are you going to implement? How are you going to use these teeth? And in the previous panel, we had a suggested characterization of companies A, B, C, like in sense to size or importance. Would that be an approach that could be feasible here as well?
Yes, so I know that currently there is a big discussion going on the usage of those teeth and whether it's really necessary. And but let me paint a picture. I think when you take a look at the implementation of other acts that are implemented in the EU and the practice of the competent authorities so far. So when you take a look at what Bundesnetzagentur has done in the past, I don't think Bundesnetzagentur is particularly known for handing out large penalties or large fines, because the general approach we take is an approach of basically information. So, for example, we get a complaint, we get into contact with the undertaking that is complained against. And in most of the cases, it's more a question of informing them on the rules that need to be applied. Of course, you have cases where there is another goal or malicious non-compliance, and that's when the teeth get shown. But I mean, we are linked, or we are bound by the principle of proportionality, and that's what we do each and every day, and it's worked out so far. And that's why I'm a little bit confused why this argument has come up in the first place. So, but I'm saying, I think we have all the tools we need, and we are not abusing those.
Michael, do you see a risk in, let's say, a complaint-based approach? Because I can assume from my own practice as a lawyer that sometimes you feel like as though where the complaints are, the authority will go?
I hope this will not be the approach. I hope that the Federal Net Agency, the Bundesnetzagentur, will be an enabler in the implementation part, because the Data Act actually will be also enforced by private companies without the authorities. There's not that big need for the authorities to sanction everything. I think there will also be public players who will fight against. When we're talking about the trade secrets parts, yeah, there will maybe be complaints about it, and this will go to the dispute settlement bodies, which have been said, but also to courts. And from this perspective, the Federal Net Agencies should be an enabler to translate the Data Act a little bit also to SMEs. If I try to explain just chapter 2 and 3 to companies, this takes like an hour, and everybody has afterwards like 500 questions. So this is actually the situation, and if we want to get some efforts from the Data Act, we have to focus on these implementation parts.
Do you want to react to that?
May I?
Yes, of course.
Thank you very much, because I think this is a very important point that we're touching upon right now, especially with regard to the discussion we had before on the GDPR. I think we all know that there is a fundamental difference between GDPR, which protects fundamental freedoms and rights, and the Data Act, which tries to open up markets, which tries to fiddle around with contractual rights. And in this regard, I think the approach that has been taken by the BNetzA so far regarding themselves as an enabler, helping companies to understand these rights, to enforce these rights, is very rightfully. And like you said, mainly it's on the part of the contract partners to negotiate with each other, to understand what data are we talking about when we're concluding a contract, when we're buying a machine, what do we want to do with this data? And the buyers have more rights now in these negotiations. If you look at it this way, you wouldn't actually need a public enforcing agency. It would be sufficient to go to the courts as in other contractual terms and let the courts decide if you can't find a solution in contract negotiations. I understand that there's a high interest from the company side to have a public authority helping them also to understand what the Data Act actually means. This is very interesting. When we talked to many companies, they said, no, it's fine that we have the BNetzA here, that they're enforcing these rules. But I think you always have to keep in mind this difference. But having said this, I think we should not forget about Chapter 6 of the Data Act, cloud switching rules, which is a little bit different from the other parts, where you really try to open up markets a little bit. You can compare it a little bit to liberalization in the telecommunication markets in the 90s, where you really need some oversight, public authority to enforce these rules. Thank you.
Yeah, maybe to Björn and Dominic, maybe you could respond briefly. You've mentioned that, of course, there could also be more data sharing, especially in regards to the quality of data, right? So what we want to facilitate, I mean, what really brings innovation is data sharing of a high quality. If you're doing just the bare minimum to comply, to fulfill your compliance obligations, that will not allow an innovative startup to predict when your machine needs repairing before it breaks down. You need very high, detailed, granular quality data. So Björn and Dominic, what do you think are real incentives and still burdens there? In what way is the Data Act helping here?
Yeah, I just also want to briefly answer to your previous question. I think is very important, whether it will be complaints-based enforcement if you want. I mean, of course, there will always be some black sheep in companies for sure, and then we have the competent authorities. But overall, I detect really quite a bit of an openness, I think, even from companies that are like negatively affected, if you want, by the Data Act. And now that they've made the investments, they want the data to be used. So, I mean, I think it will, as I said, there will always be black sheep, but I think there will also be positive development. There is an openness by companies to, now use and hopefully will be used by others, the investments they've made. So, I mean, that I think will go in the right direction. But as I said, we also have to stimulate the demand. I mean, data quality for sure is a super important topic. I think that's actually more important for public sector data than for anybody else. I mean, we have a huge obligation to make public sector data available, and maybe I know that Philip is also very interested in that. So, I mean, it would be also interesting to hear your view there. We are currently starting the process of developing a data quality standard so that at least there is something that companies can orient themselves to when they make this data available. But most importantly, I think it's for companies to understand how valuable their data is. What we sense quite often is that companies sit on data, they don't know how valuable it is, and then they rather don't share it because maybe it's valuable, maybe not, they simply don't know. So if you could develop like evaluation techniques somehow, that it appears in the books basically of a company, the data they have. I think that would be most helpful to liberate data, to be honest.
I mean, Dominic, that is basically your task as a
but again, the question is whether obligation is the right tool to free these data that sits in silos. When we talked or when we opened this panel, I said that basically AI and data has enormous potential, and I think especially German industry has here a huge asset when it comes to domain-specific, high-value sets of data. And of course, we need to use this, and we have lots of industry-driven initiatives. In Germany, for example, the Manufacturing X initiatives. And I think these kind of initiatives need to be promoted, and that companies are incentivized to engage with these initiatives rather than pushing them by force. I definitely agree with you that the initiatives taken by the European Commission by creating European data spaces, by supporting data intermediaries is absolutely the right way. But again, and this is a day-to-day task that we try to fulfill as well as an association to show the benefits of data sharing for our companies. This is a task to do still. But again, I don't think that a obligation really will achieve these objectives. Plus, maybe to add another sentence, when it comes, I mean, you said some companies in niches see the benefits of the Data Act. Of course, Björn, you also has talks to a lot of industry representatives, and of course there are some that sees the benefits. But my question is, putting this in balance or in comparison, the effectiveness of data, the Data Act, of a few companies against the potential damage that can be caused by the Data Act by a huge minority of the industries. For example, the ZVI, our industry association, has teamed up with the Chemical Association, with the Pharmaceutical Association, with the Machinery, etc., etc. We addressed a letter to Carsten Wildberger to address some uncertainties, the lack of trade secret protection, yada, yada, yada. What does this show? That shows that industries along the entire value chain is highly negatively affected by the Data Act. And when we see the European Commission under von der Leyen putting competitiveness in the headlines over any strategy, then our ask is, so please do put competitiveness in the center of your doing, and not by hindering companies by a Data Act.
But Dominic, we are talking, I mean, I think we can all agree that data can be used for innovative purposes. It's not used enough, and at least in Germany, we need more innovative economic action, right? I think, and now I could play the ball back to you and ask you, so why is it only seen so negatively? Why is data not used if it is so valuable? I mean, we are not, it's not, I mean, how far can politics be the teacher for the economy to take that up?
I think no, sorry, but one quick reaction to this. I think one of the biggest hurdle of not freeing up the potential of data or innovation is currently the massive amount of regulation that especially SMEs but also large companies are facing. That is a problem, basically, that really catches resources within the companies to actually focus on what is productive.
Yeah, let me just, Pencho, we are, like the monitor tells us, but tell us what time, because we started later, so I want to fight for our time.
Try to close like in maximum 10 minutes.
10 minutes, okay, because we also said we wanted to at least get 1-2 questions from the audience. So I will allow you to react, and then maybe we can open up.
Yeah, just because it was brought up by Björn and also by you, Dominic, and also by Michael, the question being why the take-up of companies with regard to the Data Act is not as high as expected, for example, or the feedback is in some areas negative. I think what the Data Act under the Omnibus now does, it puts, on one hand, it provides 2 instruments to access data. So on the one hand, we have the voluntary data sharing with regard to the DGA part and the access rights with regard to the Data Act part. But the thing that is missing, which does not need to be in the Data Act, but is the information and also the education of the players that might seek access to data or might have data available. And I think that's one of the biggest tasks that we also as BNetzA have ahead of us, because it's also part of the implementation law with regard to the education on data literacy. And this will, if we are successful with that, lead to more take-up and also hopefully more trust and more data sharing. So perhaps that's the way out.
So now, do we have any questions from the audience? I'm happy to pose my own questions. Okay, no, then...
maybe final remarks, one statement, and then we...
Yes, then let's maybe we go this way, and Björn, you can react and give a final statement.
React to what? To everything? Or
Okay, then yes, let's start with Michael. No, it's a good idea. Michael and then Björn.
Okay, yeah, so I think when the European Commission published the data strategy in 2020, there was this 4 pillars. And when you now see after 6 years, I think the first pillar is really at the center. And this is the problem. This is the problem we just discussed, yeah? That we are talking about regulation, that we are talking about implementing new regulation, double regulation, cutting back regulation, which is in place for 7 months, which is a good idea, because and what the Commission also does, and this is what I want maybe also Björn to highlight at the end, the data union strategy has not been mentioned yet. Yeah, so in the data union strategy, there are also elements to invest and to incentivize the data economy with the data hubs, with facilitating the data spaces, and this is what should be in mind. I think the biggest problem, and Dominic raised it at the beginning, is the trade secret part. Because the trade secret part, when Björn said, okay, yeah, the user has to have some rights on his data, but we have to balance the interest of the data holder and the user and the data recipient. And the whole trade secret discussion was based on the assumption that every data holder will say, okay, I want to share data, but I can't because everything is trade secret, which is not the case. You cannot disclaim everything as trade secret. The Commission published a study where the headline was, there's no clear evidence if trade secrets has an impact on data sharing and so on. So if we want to balance these interests rightly, we should go a step beyond in the digital omnibus and make real exemptions out of it. The Federal Net Agency will be involved in every case. When there's a refusal on trade secrets, the Bundesnetzagentur has to be informed. So we will have evidence on how many times this will happen. I assume it won't be that big issues, but we can help especially the manufacturing industry by giving them real and realistic exemptions.
Philip, do you want to continue?
Sure.
Yeah, please.
Yeah, no, thank you. Well, I mean, there's so many different layers here in this discussion, which is making it quite a task to make a conclusion. Well, I think first of all, we all agree that we don't make enough use of the data we have. And we haven't talked about, it has been touched by one of you, we haven't talked about the data that the public sector holds. So I think the most important issue is data readiness, data literacy. So everyone, even us as private persons, we have to be much more aware of the data we have and the use we can make out of the data. And with ChatGPT and Le Chat and so on, there is a big push for everyone to think about this. So this is the very, very big picture. And I think we also agree, hopefully, that the Data Act itself is not the instrument, not the only instrument to solve this issue. The Data Act is one piece of the puzzle. There are many other actions needed to be more data ready as a society. But looking at the Data Act, I think it has been said, everything has been said here. It is a very important piece. Looking at the topic of our discussion, is there room for improvement? I haven't touched upon this. Yes, I think there is room for improvement. We would want to see the Data Act as a much more lean instrument, much simpler to be handled by those who are addressed by the Data Act for companies.
Just quickly, but you had the Data Act Durchführungsgesetz implementation law just passed now. Wasn't this an opportunity?
No.
Clarify? Why not?
Because it's an act. We can't, it's an act. It's enforceable by itself. So what we could do in the Data Act Durchführungsgesetz was only those parts, naming an institution and laying down administrative rules and so on and so forth. But the Data Act itself, the rules by themselves, we couldn't touch them, which is good. We need unified union law. We don't need 27 different rules on the core issues of the Data Act. But I think the rules that we have, and we are talking about this within the Council and with the Commission, there is room for improvement in the Omnibus. I stop there.
Thanks. Yeah, a lot of things has been mentioned already, so I can keep it short. First of all, I'm really looking forward for the 5 years evaluation and seeing whether the Data Act has actually achieved its objective or not. We'll see. However, if I'm bold, I would say I'm rather pessimistic in this regard. Because what we see is, as I said, that innovation rather will be held back for the European market when it comes to new data-driven innovations. Yeah, time will show. Maybe one last thing, but this has been made clear already as well on market surveillance and the role of the BNetzA. And I'm super confident that this will be happened, that the BNetzA will have a rather balanced and pragmatic approach, focusing more on advising and promoting rather than on punishing. We've been, or our experience with the BNetzA has been very good in the past, so we've been in favor of BNetzA for this position. So yeah. The only ask is to come up with guidance because they are really needed quickly and in close collaboration with industries as well. That would be nice. And yeah.
Yeah, so basically coming back to the topic also of this panel, and but also taking up the point Dominic just made with regard to guidance. So if I were to sum up my position, it would be I think the Omnibus was a step in the right direction. It was a necessary step. But what I would wish for now is that we take some time to let the rules sink in and have legal certainty, give the competent authorities time to come up with guidance and let that sink in. And then perhaps address the next steps during the actual review that is foreseen by the law. Because I think, correct me if I'm wrong, but my personal opinion is that it's also very important for the companies or for the market players to have legal certainty, and this gets difficult if you push one correction after another in quite quick time frames. Yeah.
Björn, you have the final word.
Yes, very quickly. I mean, I didn't hear really convincing arguments why the principle, namely that a person or company that has paid for an IoT device should also have control what happens with the data, is wrong. And this is really the underlying principle of the Data Act. Yes, there are definitely teething problems. We acknowledge that through our consultations. We are aware of them, and we are trying to address them now also as part of the Digital Omnibus. I would also echo what you just said. We have to give it time. It's now 7 months since it entered application, very early days. So, I mean, let's talk in a year again and see where we stand, and we will actively accompany this process through guidelines, through working with sectors to stimulate demand and so on. And the final word is we have launched the digital fitness check, so stakeholders are really invited to let us know again their concerns about the Data Act, and we will surely take that into account in the further steps as well.
Thank you very much. Thank you to all the panel members. Thank you to the audience. Yes, I had a lot of fun. I hope I see you again soon.
In the meantime, I can announce, thanks to Alberto and Rita, that President von der Leyen and the Commissioner Virkkunen are going to have a press conference on protection on minors. So we are really curious what she will announce today. But we have our topic for today that actually belonged much better yesterday, but we're happy to have them today here with us, Friederike Kaltheuner and Levi Sari. I hope I've pronounced it correctly, dear Levi. Friederike is a former special advisor to the European Commission and also a former tech director of Human Rights Watch, if I'm right. And I always enjoy listening to Friederike when she is at Tagesthemen, pardon, that's the news outlet in German TV. And Levi is a former advisor to the European Parliament and AI researcher. And since they have a fireside chat, I don't need to introduce them more. It's sufficient, the floor is yours. And yeah, happy to listen to you.
Thank you so much for the invitation to be here. I'm also an advisor at the AI Now Institute, where Levi is a fellow, and together we write a newsletter on what we thought was a nerdy niche topic of European AI industrial policy, which you're very welcome to subscribe to. I am incredibly excited about this chat because what we're discussing is a bit the missing piece of the puzzle. I've listened today, I've listened this morning, and a few things. I just want to share a few highlights that I picked up. Yesterday, the Commission said, go ahead, make a new Google. I also heard that we can vibe code our way out of dependency should structural interventions fail. And just now on the previous panel, we heard about the billions that Europe will make by 2030 in industrial AI. So we're here to crush your dreams, but not out of malice, because the focus of our work, and Levi's work in particular, who's writing an entire PhD about this, the focus of our work is the reality of the European AI market and how it often clashes with European AI industrial strategy, to the extent that well-meaning initiatives end up increasing our dependency rather than tackling it. Levi, let's get us started. You brought a few examples that illustrate the complexity of this.
Yeah, for sure, and pleasure to be here with Frederica, as always. And also a bit, my past life was work on Data Act and Data Governance Act, so it was a bit, last panel was a bit sort of a trip down the memory lane, but now I'm freely away from the world of rules and the world of money and power. And I think first we talked with Frederica, like a few examples, like there is, for instance, last week, DeepL, the sort of the great translation provider of Germany, partner with AWS. We have Black Forest Labs, the famed image generator, who has the main distribution channel is X. You have a situation where like Mistral is very much embedded in Microsoft. Lovable, the vibe coding software is going to save us from all these structural dependencies. The key funder is Google. And what's going on here, right? I think the key point that me and Frederica try to make to you in the next 10 minutes is that these are not isolated incidents. These are parts of the fundamental structure of AI economy. And it is time we stop talking about markets and start talking about ecosystems, because that's what all our competitors do as well.
So the usual response to this is people take a look at the AI stack. And I think this is familiar to this audience. I still repeat it. If you look at the AI stack, there is concentration at every level, and you see a really unique vertical and horizontal concentration of power. So we can look at chips. NVIDIA sells 90% of the highly specialized chips needed to train frontier models. Next comes compute. In European debates, that's often sort of not differentiated. You need compute to train models, but you also need compute to run them. This market is dominated by Amazon, Microsoft, and Google. Then we have the model layer. There is a little bit more diversity, but at the frontier, Europe is not really present, perhaps Mistral, but not in the same league. And then there are lots of different applications on top, but also here, the existing companies have an advantage because, as I heard from the state of North Rhine-Westphalia, if you're already a Microsoft client, you just use Copilot. And in response to this, I think European industrial strategy can really be seen as a response to this because it tries to tackle different levels of the stack. So Europe invests in compute because we want public compute that Europe can train models on. We want to boost AI adoption to tackle the top layer of the stack. But Levi's argument is this thinking, this isolated thinking on different parts of the stack really misses the picture. Why is that?
Yeah. Well, for one, I think we have been talking about this supply. We all know about gigafactories, and you're going to hear a bit more about those in a second. We talk about the data availability, as was just mentioned. Like, we talk about this supply of inputs, but we should think, what is the actual distribution? Only amateurs talk about models, professionals talk ecosystems and distribution. How do you get to the ultimate customer? How do you get to those infrastructures? Like building AI companies which are not attached to these great circulating flows of demand out there is like building cathedrals in the desert, or like trying to grow a limb but that doesn't have blood running in it. Like, it's doomed to fail, right? And I think there's also a part about the incentive structure, which we always miss when we talk about stack as this kind of static layer of components. For instance, we have Frederica AI company that is starting. We have to ask questions like, okay, you've now gotten your funding.
It's a hypothetical example, I wish, but yeah.
Yeah, well, maybe someday. There is one part of this, which is that, okay, what is your long-term strategy? I remind the esteemed audience in the group that the key exit strategy for most tech companies has been to be bought out by Microsoft, Google, or Amazon. This has been the default. So where is Frederica going to go? How is she going to reach the customers? Is she going to compete against Google when it comes to like reaching the end user? What is the product that she's going to integrate herself to? And I think we have to ask these kind of incentive questions as well, because it also happens to be the case that often, you know, the big players are already your funders because they think strategically, right? So this means that if we want to craft a path where Federica AI is going to absolve us from the sort of structural impediments of transatlantic frenemies, then we have to ask these questions like, how are we actually going to do this? Because the default path is a deepening of the existing dependencies.
And then another component. So now you talked about, you know, Federica AI, the hypothetical AI company I'm launching, but also what's less widely known. Mistral, the French AI champion, Mistral was trained on public compute, but the moment Mistral wanted to scale, it needed to enter a partnership with Microsoft. Because in order to run models at scale, you need a lot of computational power. I'm going to have a discussion with two cloud company CEOs later and have some follow-up questions there. But sort of this market is dominated by hyperscalers, and they are the entities that are offering the computational resources you need. And it's even that the cutting-edge models have existing agreements. So if you want to run OpenAI, you automatically generate money for Microsoft. We have
Can you please tell about your local LLM for the audience? I find it fascinating.
I run a local, we have a home server, we run a local LLM, and that's been a really fascinating, setting this up has been a really fascinating experience with the reality of the European AI market. So the compute we bought, the price doubled in the last year. You can really only run relatively small models at home. They're useful for some tasks, not for others. The moment you want to run a bigger model, you need an inference provider. So a provider that provides the compute to run a model. And it's really challenging to pick a European provider. So Stackit doesn't offer Mistral's largest model that came out. Ionos also doesn't offer it, which just shows that, yeah, it's really sort of, there's a bottleneck at the level of infrastructure. And the response that we usually hear in Europe to this is, well, we can do industrial AI, right? Maybe the ship has sailed on models. We heard yesterday, maybe we shouldn't really challenge the infrastructure level at all because it's so expensive. But in industrial AI, this is where Europe can win. And what's your response to that, Levi?
We just heard in the previous panel as well this idea about industrial data, which has been a very alluring policy point for years. And I just say that there is another monopoly brewing there that I don't think we've completely clocked. So NVIDIA, which is this small American SME that makes chips that run the world, have for the past 18 months completely entrenched themselves in that ecosystem. So if you look at venture capital investments in every single physical AI or a world model provider or like a leading edge post-LLM model provider, NVIDIA is there. You have Mistral deepening their relationship with NVIDIA. There's an Italian company called Domin, which is basically NVIDIA company. 80% of alternative compute providers in Europe are strategic partners of NVIDIA, and I have publicly made a statement that they wouldn't exist without this dependency. There is a situation where we are talking about gigafactories in the European Union, which is this idea that we are going to build these huge computational clusters. And it's quite, I'm hearing signs that there is a quite strong lobbying going on that these infrastructure will all be built on NVIDIA. And I will remind you that this is closed source architecture. This is a technological locking that is also going upwards from the hardware layer. So they are increasing, creating more software. And on the topic of industrial and physical AI, Siemens, which is a company that might be familiar to this audience, has Omnibus platform, which is the industrial operating system for most German manufacturing. You want to have a wild guess who has now just integrated very strongly into that operating system and provides the models to the platform. So if I just...
NVIDIA, yeah.
NVIDIA.
So let's bring this home. I think the question is, where do we go from here? The conclusions we want you to take away with is not that the ship has sailed and that everything is impossible. The conclusion we want you to take away with is that this is not a normal market. The market is already being shaped. Market shaping is happening, but it is currently being done by the companies that dominate this market. So one takeaway is, in order to have a sort of like, to have a strategy, we need to have a strategy of where we want to go. And the isolated, disconnected initiatives that we are seeing risk further deepening dependencies rather than challenging it. That's one component. And the other one is?
Yeah, well, I think the other one is, I think this is what you kind of was saying as well. It's not good enough anymore to say that we need fair level playing field and innovation and consumer welfare and beautiful things. This is not how this market works. We have to look at it, take a hard look, facts on the ground, and make decisions on what we are going to do. And this is not only about creating this grand vision of where we want to go. This is not the European model. But there is a situation where we are hitting our heads on very predictable problems. Like if we are down the line, we end up in a situation where right now we are looking at, like in 5 years, that okay, NVIDIA is now entrenched in the computational ecosystem of Europe. They did provide a lot what Europe needed. They provided a lot of money, they provided a lot of computational capacity, but now our computational ecosystem is locked into that. That might be a valid political choice. That might be a position that one could stand behind and say, well, in trenches you cannot be too picky, you know? Don't spit sideways. But let's have a discussion about this, because what's now happening is that nobody's talking about this. Everybody's saying, well, it's going to be fantastic. We need more innovation, and if we provide more supply of inputs, and if we got to create more regulatory flexibility, we're going to build this. And I don't believe that is to be the case. So hence, we have to take seriously this structure of this market and then develop forward from there.
And on that optimistic note, I think it's the lunch break. Sorry. Yeah.
No, I just wanted to say thank you. It was really excellent. Or you need a couple of minutes more? No.
We could talk about this for hours, as you imagine, but we can say, if you have any follow-up question, yes, there are nuances and caveats, but we really, this is the big picture, yeah.
I think we learned a bit more how to get free, how do we break free from this situation. And this was really excellent preparation for the next panel that we have after the lunch. We have shortened the lunch. I think half an hour is okay, so this will be a German lunch, not an Italian. I'm sorry for that. But I really enjoyed in your discussion, and in the previous panels, it was really worth prolonging the schedule. Thank you very much. Now it's the time for food, and you are welcome in half an hour to join the presentation of the DMA study on cloud. Many, many thanks. As we all know, the one promising piece in the legislation, and that's the DMA designation in the cloud sector, is unfortunately missing so far, despite some provisions that are already in the regulation. And many people were wondering in the past, why is that? Why is the Commission not active in this field? Do they have not enough resources? Do we have some legal challenges? What are the actual reasons? And I remember we had plenty of discussions in the last 2 months, 2 years actually, and there were even requests from certain governments across Europe asking the Commission to go into this direction. Even the European Parliament, if I'm right, asked the Commission to be active in this field. And finally, it coincided with the European Sovereignty Summit last year in November. The Commission announced 2 promising investigations that should lead potentially to a DMA designation in the cloud sector. That was the reason that we talked with each other, with Antonio Manganelli, and when we talked what could be a possible topic for a study, I asked Antonio, I said, Antonio, don't tell me that it doesn't work. Tell me how it works. And don't tell me, please, that we should legislate further, because as you realize, in Germany, we are quite fed up with legislation and bureaucracy. So I'm really glad that Antonio really produced an excellent piece of paper. And that is really helpful, hopefully, for Antonio and for for the Commission and for all your colleagues, Alberto, dear Alberto. And yeah, the floor is yours. We were proud to present your paper, dear Antonio. Please.
Thank you very much. Thank you for having me here and having given me the opportunity to reflect on this topic and to write a paper, a contribution that hopefully could be of some help or could be useful anyway. And just to set the scene, you already did very well, but just to remember that cloud computing is the foundation of the European data economy, and now it is also the critical infrastructure for the generative AI value chain, both upstream for the development of foundation model and the fine-tuning, and downstream for the deployment and the inference of the model at scale. And as we all know, the cloud is highly concentrated, and so I have not to spend any words on that, but especially at the upstream level. This concentration has both structural economic explanation. There are pronounced economy of scale, high sunk costs, self-reinforcing data advantages, but there are also behavioral ones. So several market investigations by EU national competition authorities have systematically documented conduct-based practices that deepen and exploit that concentration and lock-in. Competition law is unfit to address this issue because there is no single provider reaching the threshold of individual dominance, and as we know, collective dominance remains, as a matter of EU law, essentially quite unenforceable. So in this context, the Digital Market Act was designed precisely to fill in enforcement gap of competition law and to address some difficulties and problems that competition law enforcement has shown in digital markets. Cloud computing services are expressly listed as core platform services in the DMA. So those services that are considered to be more problematic and give more problems in terms of contestability and fairness, which are the two main goals of the Digital Market Act. However, as you mentioned, after 2 full rounds of gatekeeper designation, no hyperscaler has been designated, and therefore no obligation, ex-ante obligation, which are aimed to pursue the contestability and fairness in the market could be applied. On a third side, as you said, because this is a very multifaceted issue, the EU Parliament and a lot of stakeholders have repeatedly called on the Commission to act, but this is an important institutional point. This is law enforcement, it's not policy making, it's not law making. So you have to find the way to enforce the law and to interpret the law in a way that make it possible to apply to cloud services. So the Commission works within the DMA's framework where it has, however, significant technical discretion in applying the law and interpreting very general concepts, as it was the case for competition law before developing the extensive judicial case law that anyway now is designing the law in a much more strict way. So in this context, the Commission in November 2025 opened 3 market investigations, 2 in order to assess the designation, the quality designation of Amazon Web Services and Microsoft Azure, and the third one examining whether the existing DMA obligations are adequate to address fairness and contestability concerns in cloud market. So what was the reason of this path, not linear path in the law enforcement of DMA as far as cloud is concerned, is answering one of the questions that is the pile. Is the DMA fundamentally suited to regulate cloud markets? There is no short answer for this question. For sure, the DMA is built around the economics of two-sided platforms like App Store, search engine, social network, and its central concept is the important gateway function. So a large company sitting between business users and end users and necessarily intermediating, interacting, allowing interaction between them. On the contrary, on its basic, cloud computing follows a fundamentally vertical structure, value chain, infrastructure, development platforms, and application. In a way, it's more similar to telecom markets than the traditional two-sided market, two-sided platforms. The consequence of this is fatal for the quantitative designation, which is the operational expression of the gateway concepts. So the DMAs and the annex quantitative threshold requires 45 million active end users with a direct economic relationship with the cloud provider. And in a typical B2B context, a cloud environment user contract interact with application provider, not with the cloud infrastructure beneath them. And this is a gap that is structural and is not going to be reduced with higher adoption. However, there is the quality designation path under Article 3.8, which is this commission is now investigating. But the point is that the main concept anyway is the important gateway function, which is not per se resolved by the application of Article 3.8. So the criteria that are listed there, network effects, scale and scope economies, data advantages, user log kill, and conglomerate structure, are not themselves a substitute for the gateway function. Rather, they are indicators of the importance of an existing gateways. It is therefore crucial to conceptualize the gateway function specifically for cloud services. And this is where the main contribution that I try to give is relying on that. And the point is that one of the points is that the starter vertical pipeline of cloud services requires some distinction and qualification, especially for cloud marketplace. This is a big difference in terms of the concept of the gateway concept. Cloud marketplace are places where customer can discover and buy and purchase not only the hyperscalers services application, but also the services application developed by independent software vendors and other third-party providers. And the same dynamic of marketplace apply also to AI marketplace, that are run by hyperscalers. And all these contexts introduce genuine two-sided platform economics. So the bilateral interdependent structure that the DMA gateway concept is designed to regulate. So this environment is completely different. In a way, is a game changer in the definition and designation of the gatekeeper. But one point is that this is not ordinary intermediation, like in a Amazon, for example, marketplace. This is what I defined an integrated intermediation, because hyperscalers are not only intermediating, are also simultaneously the upstream infrastructure provider, the intermediation activity, and also offers, of course, downstream application, cloud-based application, and AI services. So this multiple integration puts contestability at a much more severe structural risk than any other intermediation situation. In a way, this is a specification of the ecosystem powers that become analytically relevant in Article 3.8, so the qualitative criteria, precisely when the quantitative thresholds are not met. A complementary route for designation, for qualitative designation, is what we call the indirect ecosystem capture, which in a way derives from the downstream to upstream leverage dynamic that, for example, in the cloud market, that, for example, are illustrated in the Microsoft productivity software case, where the market power is leveraged from the software application to the cloud and not vice versa. And this is more or less the way in which the market power in clouds has been built, has been based on the dominance of the different big tech in downstream markets, and then have been consolidated at conglomerate level. So this is what is the point. The point is that when a customer adopts an hyperscaler application, cloud-based application, that choice also carries the choice of the broad cloud ecosystem. So the cloud, the infrastructure is not chosen directly by the consumer, but is an indirect choice that is linked with the software in a constrained way. In a way, with some differences, is like the same dynamic that apply when you choose when you buy an handset, a mobile. You do not choose directly the operating system. The operating system, in a way, is an indirect choice, and the mobile, all the different mobile ecosystem is an indirect choice that are driven by the consumer initial choice. So in this context, the relevant end user base for the gateway function is not confined to those which have a direct contractual relationship with the hyperscaler and the infrastructure services, but extends to all those that are drawn into the hyperscaler cloud ecosystem through downstream services. And these services are those that have generated the scale, the data volume, and the network effect that Article 3.8 wants to capture. This is about the two possible way conceptualization of the gateway function that I think that could be interesting to explore. And what about remedies? Of course, remedies, application remedies is conditional to the designation, but one thing that I mainly reflect on is the application of Article 6.6 of the DMA, which is an article that I think is very powerful, but has also not been applied so extensively. So Article 6.6 of the 6.6 of the DMA requires that designated gatekeepers neither prevent nor restrict business users from offering the same product or services to end user through different channels on different terms, and neither technically restrict switching or multi-cloud in this way, nor degrade the condition of access or use for business user who multi-home or switch. I think this could be a very interesting obligation to apply, provided that hyperscaler are designated as gatekeeper, and this is at the base of what I called in the policy paper the cloud neutrality concept. Why cloud neutrality? Because it's I built on the analogy of net neutrality. Net neutrality, you know very well, is based on the Open Internet Regulation, which impose internet service provider not to discriminate among content application provider. If you think in this context, the internet access provider are served in a gateway function. They intermediate in a way between content application on one side and end user on the other side. So the net neutrality regulation in a way is structured in the same fashion that the DMA general principle. So I thought, given also the similarity in terms of vertical pipeline of the cloud with telco, that there could be an interesting analogy to explore. So according to this cloud neutrality and application, which is based on the application Article 6.6, the infrastructure layer must remain neutral to the application layer above. And in the cloud context, in the infrastructure, IaaS and PaaS services layer must treat all independent service vendors and their application on an equal, non-discriminatory terms. So no self-preferencing, no access degradation, non-discrimination pricing, so allowing switching and multi-cloud, and also application portability. And one point is that interesting, I think, to reflect is that these kind of obligation are in a way echoing somehow some of the provision of the Data Act, which is another regulation at the EU level, and so that of course requires some coordination. But the Data Act on one side is not so deep in applying those concepts, and especially has no pro-competitive rationale, because the Data Act, similar to what we discussed before, the GDPR, is a symmetric regulation. So is applied to all cloud and edge computing provider, while of course the DMA is an asymmetric regulation applied only to gatekeeper and in this case to hyperscaler, which of course could have a much more broader and deep effect in enhancing contestability in the market. And just another point, and I just mentioned that the fact that another complementary obligation which would be interesting to explore as a complement of 6.6 is Article 5.7, so the anti-tying obligation as much as the identification system is concerned. Because the identification system above on the infrastructure layer is another way in which the hyperscaler, especially also in the cloud, maintain their gatekeeping position, locking users and making switching and multi-cloud and application portability much more difficult. I stop here.
Hi, everybody. I'm Corey Kreider from the Future of Tech Institute. It is my very great pleasure, please, Professor, have a seat, to chair a panel where we are going to discuss this paper and our other options for the cloud with Alberto Bacchiega from the European Commission, who works on the DMA, as you all know, and who was speaking to us yesterday about some of the challenges in this geopolitical context of enforcement, as well as Thorsten Kaiserberg from the Federal Ministry of Economy and Energy, I think it is now these days, who we all know has done lots of work to keep markets contestable and fair, wherever you'd like, Mona. All right. So for those of you who are not so often in the weeds of this topic, let me just zoom out for a very brief moment and tell the specialists something that they already know, very sorry. But for the rest of us, because a lot of yesterday's discussion was actually about social media and less about cloud, but it is really quite a fundamental infrastructure for Europe's economic future and for the tech ambitions for sovereignty that we all harbor, especially but not only in AI. And it is an incredibly concentrated sector at this point where a few American hyperscalers, 3, really 2.5, set the rules of the game for absolutely everybody else. You know, the professor said their market share is vast. It's over 70%. The profit margins are about 40%, which I would say is suggestive of a monopoly rent. I don't know about anybody else. And in this context, European offerings have tried valiantly but have struggled to gain any material market share. And if you're a European business who sits on top of one of these, you find yourself very often locked into a hyperscaler and you struggle sometimes to switch. This is an economic problem, and it's also a geostrategic vulnerability, as we learned when the ICC found itself chucked out of various Microsoft services last year. And this concentration, I would say, is hurting our resilience, as we saw last autumn when, yet again, some part of AWS fell over and took a swathe of the internet out with it and did a degree of economic damage I don't think I've ever seen quantified, but which will not have been trivial. So the question for the panel today is really whether Europe, and exactly as Antonio has explored in his paper, whether we've got the right legal tools now to meaningfully open space for alternative providers, including Europeans, and what interventions would really shift that market towards competition and towards sovereign solutions. So just to come back first to Antonio yourself and your keynote, I mean, if I had to kind of distill what you were saying there, it's that the DMA hasn't worked in cloud essentially because it was mostly built for a completely different kind of market. So you've proposed these two alternatives. Do you think that will they work, or are they stretching the DMA framework beyond what a court litigating it might accept? And how do you think this cloud neutrality would work in practice?
Yes, I think they would work, and I don't think we are stretching this stretch too much the DMA for two main reasons. First one, that is something that is always often highlighted, is the fact that qualitative designation is something that already when you embrace qualitative designation, you are in a way going outside the scope, which is not true, because the main regulatory concept is a qualitative concept, so the important gateway. Then the threshold, the quantitative threshold, are a way to operationalize and give the presumption, which is rebuttable, by the way, of the fact that the gateway function is there. So this is not a secondary way. Actually, this is a way that is completely within the remit of the legislation. And the other side, as was mentioned before, these are general principle, general concept, and not so differently from what we have in competition law. I mean, the relevant market, abuse of dominance are very general concept. Then in competition law, we had more than 50 years of application, case law, judicial review that, of course, built a very strong, differentiated rules, and the competition law students know very well how much detail is the case law. So that's we do not have here. So, but we have to build this narrative and apply the different concept in the different markets. And, you know, for example, the same thing, competition law is horizontal, apply to both AI and concrete markets. So, of course, you can adapt. That's why general principle is there, to adapt to different circumstances.
Great. Alberto, I'll move to you. I mean, why do you think intervention hasn't yet quite worked in the cloud space? Do you agree with this diagnosis that we're seeing a kind of structural mismatch between the core of the domain and the way that the cloud market works? Or do you think it's more about, I don't know, evidence prioritization, like we'll get to it, but we just haven't yet? Like, how would you see this?
I think when Pencho introduced, he said, why not yet? Was it a problem of resources? Is it a legal problem? I could add, is it a problem what the DMA can actually achieve? And maybe a bit all of the above. We started 2 years ago. We have designated 23 core platform services. Of these, only one through a qualitative designation, which was the iPad OS. And the other 22 basically came through mechanically through the designation criteria. So clearly, from the start, we had the thing going for cloud will be a big investment because it's much more resource intensive to run a qualitative investigation than verify quantitative criteria. There is, Antonio, I think, as well identified possibly an issue. Is cloud really a platform? Since the DMA targets platforms, it is a real point that we need to address. To that, I would probably make a remark that is very, very unsophisticated. Cloud is in the list of 10 core platform services. So the fact that cloud is there means that the legislator thought, okay, this is potentially an important gateway between business user and end user, otherwise wouldn't be in the DMA in the first place. And the issue for us is to show that it is an important gateway, let's say in theory, but probably even more to show that the companies that we are investigated for designation are actually important gateways under this umbrella that is already defined in the DMA. And that's exactly what we are doing with the two investigations into Microsoft Azure and Amazon AWS. And then the third point is, what can the DMA do for cloud? How do the current provisions on the DMA apply to cloud? What impact can we have? 2 years ago, also knowing that the Data Act was fresh back in the day, and so there was something that was going to enter into force in September 25, that was in the future. So there was also a question mark there, where will the data go? But also we had the impression that the DMA, as it's written, maybe cannot achieve an awful lot towards cloud. And this is the justification for the third investigation we are running, which is not about designating, but is a market investigation to see whether we can tweak the DMA to make it more relevant for cloud and more impactful on cloud. I say tweaks because it's not really changing the legal text. That, of course, would need to go through the whole legislative process, but is a kind of expedited procedure that we call delegated act in our jargon, that would allow, for example, to expand an existing obligation that at the moment is not applying to cloud, to say cloud is also actually covered by this obligation, or to extend the category of beneficiaries, that to say also these beneficiaries could be a benefit for certain obligation and so on. So that's something we thought it would be important to do at the same time. It's the first time we do this type of investigation, and that also require resources and commitment.
Great, thank you. Thorsten, I'll take it over to you. So as well as asking you to react to those 2 points, I just wonder, kind of from a member state perspective, do you think that there's a role for national enforcement measures alongside sort of this, or do you think it's important that this kind of regulation and enforcement stay pretty centralized at EU level?
In the end, it's important to do this at the European level first. That's why we jointly created and set up the DMA. The other two speakers outlined, and you mentioned the firms. They are obviously competing across the board in the EU. It's supranational business. They affect all the member states. So it's just natural, and we are really grateful. And the federal government also last year, alongside a couple of other governments, actually supported the Commission in actually what Alberto just outlined. First, the designation of the strong gatekeepers, as well as Alberto told it, tweaking and trying to actually advance the DMA. So it's really it's at the European level, and it's good that it's there. At the same point, and you won't be surprised from me saying that, of course, in German antitrust law we have quite flexible provision. I'm not making the point again that at the time when the DMA was set up, we were actually in favor of having a more flexible instrument on the European level. But we live in this second best world all the time. Given geopolitics, we may even say we live in a third best world. But that's how we have to make things work, and that's why I'm actually grateful for Pencho having this timely flashlight on this debate, and for the Commission trying to do everything in that space to go for the designation. And to further and twist and tweak the DMA. If, and we know that there are joint discussions, exchanges between the Commission and the Bundeskartellamt on the Bundeskartellamt using this national provision of Section 19a. If there are spaces that the Commission cannot cover by using the DMA, specifically also in the cloud sector, plus where it makes sense to have an additional national instrument, then we would say, of course, we are happy to see the Bundeskartellamt using it. There is always the in the past, there have been a couple of cases outside the cloud space, where the Bundeskartellamt was able to sort of leverage and help filling gaps, but also leverage the case to a de facto EU-wide application of the remedies. But that's, of course, the limit to national enforcement. So coming back to my initial statement, it's good that we have the DMA and that the European Commission enforces it.
Great, thank you. I want to ask a kind of question about posture and like what we're trying to achieve here, because as our colleague Jonathan Cantor always says, who was working with much older and much less specific statutes when he was trying to enforce against some of these firms, you know, posture is sort of everything. I mean, for Alberto, for you, what would you say, you ask about what the DMA can achieve, what would you say that it's really meant to do here? Right? Do you see that it is essentially tweaking the edges of the kind of hyperscaler dominance and making sure it's okay? Or is it actually to open up space for others to be able to kind of grow and thrive?
It is definitely to open up space for others to be able to operate in this space, and both to competitors, cloud, other alternative cloud providers, and to for independent software vendors that are often offering solutions on the platform of the hyperscaler in competition with the hyperscaler, as Antonio mentioned earlier, which is, I mean, not so unusual even in more straightforward marketplaces. If you think Amazon is doing something very similar, and of course for business to provide more opportunities and more choice to businesses, and in the jargon of the DMA to end users, but the end users in the case of cloud, objectively, is not really us as as individuals, very often. So this is what the DMA wants to do. This is what the DMA aims to do, concretely to possibly to strengthen the possibility of switching The Data Act already is taking steps in this direction regarding termination fees and so on. There are many complexity in switching your providers of IT in general, on cloud in particular. There is always a lot of risk connected to moving. There is always also a balancing to make between a possibly more advantageous economic offer versus the cost of the transition, the risk of the transition. Sometimes you really don't want to touch it, even if it's more expensive, because if it goes wrong, you shut down your company for a while, and that's nobody wants to do. So there are things that are objectively there that the DMA will not do. But of course, what we don't want to see is that switching is impossible because it's contractually impossible, because there are clauses that make it completely uneconomical, or because there is, from a technical point of view, a lock-in that is not, if you want, grounded in the objective features of the technology, but it's simply because certain protocols are not shared or are not made public, or simply because there are clauses that make it impossible, as I said. So the DMA can unlock this last part, cannot unlock everything. As for all the provisions, it's also, I think, would be much too ambitious to think that a piece of regulation like the DMA can make up for the delay that Europe has, in particular on investment, on scaling up, on all the very important and very high-level considerations that colleagues made earlier today in other panels. So, of course, it's not the solution, but at least it has the ambition, if, of course, I have to be a bit bureaucratic here, if we conclude the investigation designating this platform, it has the ambition of creating a little bit more of a level playing field where there is a chance for alternative providers to compete on a more equal footing.
Great. Thorsten, did you want to come in there? I couldn't tell if you had a response in the works there, or if that was just an enigmatic smile. Not yet. Okay, then Antonio, just go over to you. So again, back to your paper, you've proposed a couple of ways to make designations sort of work. I want to ask you a question about remedy as well, because you skated over it for a moment there. And if I think about the cloud firms that I talk to, there's a lot of complaining about lots of different anti-competitive practices in these from the dominant cloud firms, including things like discounts, committed spend agreements, things like this. If you mentioned various, and if you get designation through one of your routes, what's your sense of what would actually bite in a way that makes a difference to these European firms? Is it interoperability? Is it anti-tying? The switching thing? If we've got to prioritize what we're putting pressure on, and you get to write you're king for a day and you get to write the prescriptions, what would you prioritize?
Yeah, no, I think it is more or less all of you said. So the different non-discrimination practices, the access, the switching, the application portability, so not only data portability, which of course implies interoperability. All these issues could be covered, and I mention Article 6.6 just because it's a very broad set of remedy could be interpreted and adapted to the cloud environment very well. And also just to go back a bit on the previous question, I think the DMA impact on cloud could be very, very, very big, most likely also more than happen in other core platform services, just because of the characteristic of the cloud on one side, and also the complementarity of industrial policy action that the European Union are putting into place. So the opening up is complemented with some action to build, which is, of course, is something that must go together in order to have this kind of dynamics. And this is just a note that I think it's interesting and also in a way a bit fun. When there was the opening of the market investigation at the Commission level, it was in the press release, they won't mention to enhance fairness and competitiveness of the European market, which is not one of the objectives of the DMA competitiveness, is contestability, of course. So, but in a way, this gives the picture, the bigger picture, and the scenario of this complementarity that I was mentioned before.
Great, thank you. I want to zoom out for a minute and talk about some other proposals that I've read kind of floating around the place. Some of the commentators from some of the civil society space who work on digital infrastructure have talked about maybe rethinking the structure of the market itself. So for example, a kind of shared marketplace for compute resource. There was a paper out of Leitmotif that talked about this. Basically try to treat compute as a commodity, right? And buying and sell it, which may sound esoteric from where we are now, but obviously we've done some of this market shaping work in energy. I just wonder if any of you have any reaction to that idea about a different kind of layer, that kind of market design intervention, or do you think it goes way, way beyond what those of us who think about kind of competition policy and the DMA should be thinking of? Too esoteric? You got to read the paper? What do you reckon? Anybody want to read? Anyone have a reaction to it?
Yeah, here is where the personal answer would be a bit different from the from the one I can give given my role. It's always very interesting to read about this. I think many commentators say computers are by design agnostic machine capable to run any type of software. So whenever there is a blockage, is artificially created, and we should bring everything back to that. And that goes back to the early days of the open internet and the good old days that are gone. I think there is a lot of attractiveness to that. It always goes that to basically openness and interoperability. So it's a very attractive idea. Is it something I think we can pursue with legislation like the DMA? I don't think so. It's really not written in there. So that's it's really a societal move. I even wonder at what level it could be successful in terms even of jurisdictions, whether it would require global coordination, European coordination. I don't know. It's very stimulating intellectually. But when I go to the office, I think I put that a little bit on the side and I deal with much more mundane problems.
You've got the statute as you have it, yeah. Fair enough, fair enough. Anybody else want to engage in a thought experiment?
No, I think I kind of agree. This could be some kind of remedy of structural separation and creating shared commodities on the base. It's something that maybe it goes beyond what is the DMA is describing, but anyway, in a way, applying the DMA in a certain way, the outcome could be not the concrete outcome, but the functional outcome could be not so different at the end. So that's if you manage to insulate the different infrastructure power, the conglomerate power, and trying to have some more open environment interoperability, at the end is not. It's an alternative way, which is in the scope of the DMA, I guess. While the other solution is maybe not there.
Yeah, and just to engage with, sorry, Thorsten, just to say one more word for this slightly odd thought experiment, I think it's meant to engage the idea that the European hosting providers are, if you just measure, let's say, price for compute, they're price competitive, right? It's way cheaper just on that. And exactly as you say in your paper, the way that Amazon and Microsoft built their dominance isn't because their server farm is more awesome. They built their dominance because of the aside services that they sell. Anyway, so I accept that the idea is still a ways away from where we would be. Anyway, I cut across you when you were wanting to come in.
I would accept the economic idea of price per compute. You said leitmotif, or it's a lens, and I remember that we discussed this public service or commodity perspective regarding the Google search engine a number of years ago with similar ideas and papers, and I would agree with the two other speakers. Actually, it's stimulating, but I would actually see another lens as more important, which is the sovereignty lens. And there, I'm not an expert there, but it's if you, I mean, the commodity analogy would be then probably referring to water and other commodity regulation. But we really have to think about European sovereignty with regard to public data in the defense sector and so on, being dependent on these cloud providers in the long term is just dangerous. So in a sense that I think politically speaking, at least to me, is the more important and analogy or lens through look at the problem.
Thank you. FOTI's actually got a paper coming out just at the end of this week about the defense sector and our kind of exposure to potential kill switch in cloud. So I couldn't agree with you more. Rapid fire, and then we'll open it up to questions if there are any. If you have, each of you, if you've got space for one move that you would think would do the most to open up this market genuinely to make them more competitive, what would it be? Professor, I'll start with you, please.
Yeah, I think the DMA enforcement would be one of the a good move, and I think of course also the coordination of, as I said before, of the industrial policy. So the forthcoming Cloud and AI Development Act is another piece of the puzzle that could be good having together. And one thing that I think is very important, and I think the Commission is embrace this road, is really to envision and to design the different piece of regulation as a piece of a puzzle that has to work together and go together, while in the past there was much more fragmented, overlapped, and externalities between one piece of legislation and the others in the digital sphere. I mean, nowadays, since a few years, there is much more coordination, and I think this is very important.
Alberto, what do you really have to do when you go to the office? What's your?
I think this is quite in perspective because we are investigating. I don't project any conclusion, but I think to me 3 things that are very much interconnected: reducing lock-in, reducing switching cost, and allowing interoperability. I mean, that's how you really unlock potential and you open up markets.
Last but very much not least,
have 1 or 2 European companies going big, investing big, and growing into a competitor of the 3 that are currently dominating the market.
Market share. I love to hear it. I love that song. All right, let's let some hands come up. I see one there. This gentleman in the maroon, please.
Yes, thank you very much for this report and this insightful panel. My question would go to the definition of cloud in the DMA, because we talk about cloud and everybody kind of like knows what it is. But if we look at the DMA, it's defined as infrastructure as a service, platforms as a service, and software as a service, like all of them. So how do you make sure that a designation of the cloud doesn't in fact entrench this vertically integrated stack? So for example, AWS offers more than 200 services, and with your open cloud neutrality, I think the idea behind this is kind of that all these secondary services need to be also open for other players. But AWS, with the designation of the DMA, would have a good argument to say, well, the DMA designates our entire cloud stack as cloud. So why would it need to be, like tying doesn't apply to it, for example, because it's one service. So how do you tackle that? Thank you very much.
Yeah, it's a very good question. I'm afraid I cannot say a lot because the investigation is going, but it really points at one of the complicated and interesting things we need to do in the course of this investigation is to draw the boundary of what the service is. And as you say correctly, cloud you can read in many different ways, and infrastructure as a service, software as a service, platform as a service is a kind of the traditional distinction, if you want. We have plenty of people saying this is an old one and that we should change. Everybody has his own cuts. When you start looking into any specific business, they organize themselves in the way that that history and their business model has produced, so nothing really fits within these boundaries. So this will be one of the challenges that we will have for this designation investigation. And you're right to point out whether some services are within the core platform service that we designate or outside have consequences. And is not one way only. Some provisions actually try to open up when the relationship between a core platform service and another service. So you say, okay, it's good then that we have these different services, so this provision applies. Other provisions apply within. So it is not 100, you gain some, you lose some. And so the approach we need to have is to try to find something that makes sense from a business and technological point of view, and not try to read where we want to get too much, because it will always be a trade-off at that level.
Something to this, that the annex definition of business users of cloud say that cloud computing service is hosted in the cloud infrastructure. So to me, this gives a very clear signal that the main aspect that you are talking about is the infrastructure layer of cloud computing. Also because, of course, the software as a service, also in terms of economic terms, are not the markets. I mean, our software, our application, cloud-based, that cover a lot of different functionalities. So it's very difficult to apply the DMA logic to the downstream part of the cloud stack. While, of course, it makes much more sense to focus on the infrastructure layer.
There was a gentleman 2 rows behind the first questioner. Yes, please.
One thing you didn't mention, thank you, is the DMA review process. So I guess that's also a way of looking forward. And I think one of the kind of problems in the DMA is this strong focus on B2C, which in a way you can say thanks to AI at least you get cloud in, otherwise you may have had a problem. But I think that may be a way which could be repaired in the review process. When we talk about industry in Europe, I mean, many businesses are users of the cloud. They rely on those cloud services, so that may be perhaps worth taking the effort of including also business users, so that we do cover the B2B aspect. So that's the one point. I think the second point is that as cloud services are moving along, we should be open to vertical separation. So I guess that's an issue which in a way we have been discussing yesterday. So that's clearly outside the DMA, but I think we shouldn't close our eyes.
Sing it. Any final questions? I'm not going to call on anybody or pick anybody, but I see you cloudistas up there. I see some of you who are out there trying to build something else. Any final questions, comments? This is your moment. Otherwise, I think I'll thank our panelists and close it out and be relatively on time. All right, great. Thanks, y'all. Thank you to all of our panelists.
All right, let's jump right into it. Good afternoon. It's great to be here. So, digital public infrastructure for social media in Europe. Wow. I mean, like, this arrangement of words, you have everything that you don't understand about computers, everything you don't understand about public governance, and the most boring word in the English language all put together in one presentation. Why did you come? Why did you come? I really don't get it. But so, let's proceed as if maybe you have an interest in the topic. And so I think one of the reasons that thinking in terms of infrastructure for social media is important is sovereignty. Now, we've heard multiple times, including at this conference, that people are like, we talk about sovereignty, but we don't really know what it is, yada, yada. I disagree. Sovereignty is simply self-determination. It's the ability to set your own rules within your own jurisdiction. And that jurisdiction might be a country, a continent, maybe just your household. Can you control your own devices, that kind of stuff? And yes, people will always say, but it's not perfect. It can't be absolute. Therefore, we don't know what it is. there's plenty of things that are not absolute, and we know very well what they are, right? Like personal freedom, for instance, it's never absolute. You can't liberate yourself from physics, last I checked, but still, we kind of know what it is, right? And so part of the problem the key problem of sovereignty is that the digital sphere is regulated by tech monopolies. And what I mean by that is, we have these conversations about like, oh, maybe if we simplified the regulation we have in Europe, we'd have all this growth, it would be amazing. This is like absolutely nonsense. Like, because we can simplify our own regulation as much as we want to. For most businesses, the regulation that matters is the regulation decided by Google, by Meta, by Apple. And I can tell you this, like, from experience working at small startups, they collect more taxes from, anything in the App Store, any revenue you make in advertising, than corporate tax rates. I was working at the New York Times. You would think that is a powerful organization. And we were really excited about GDPR. We pushed very hard to implement it as strongly as we could, because that really protects the media from, all that data being stolen by competitors in the market. But at the end of the day, what happened is that the rules that Google sets for data management, for how data works on the internet, are more important than the rules set by the European Union. That's how it works. So that's a little bit depressing. I'm not here to depress people, because I do think we can work our way out of that. So I love this horrendous diagram. It's from a great paper called Control Point Analysis that you can find on SSR, and I recommend it. I'm not going to go into detail because you would really, really, really want to die. But what this represents is all the steps involved in fetching just one web page just once. You click on the thing and you get a web page back. And even then, it's actually simplified. Every red balloon that you see there is a potential choke point. And anyone who controls those choke points can have some power over the system. And that is the kind of analysis that I refer to when I say that when you control digital infrastructure, then you control very essential parts of the process. And it's not just going to be like one big blob of things, it's going to be like a lot of these small things. Of course, if you only control one and the rest are pretty like open, it's unlikely that you can impose your will on everything. But if, for instance, like Google, you control multiple steps in here, multiple of the red balloons, then these really reinforce one another. So I've been talking about infrastructure, and people often get a little bit like confused the first time they hear me talk about it. Like, of course, if you see me multiple times, you will hear me talk multiple times about infrastructure. But essentially, we tend to think of infrastructure as, these big things. It's like there's a rail network, there's like roads, energy grid, yada, yada, yada. But in the digital space, it means the same thing theoretically, but it's harder to see, right? You look at your phone and you're like, well, Facebook is just like a consumer app, right? There's nothing underneath. But in truth, if something is hard to replace, and that can be like, maybe because it's a road, hard to build a second road network on top of the second one, agreed. But it can also be because there are intermediation effects like two-sided market capture, network effects, etc., that mean that having a second one is actually very hard and needs intervention. If it has many downstream users, that means there's very significant societal value in extracting rent from it. And if it sets rules for its users, then it's infrastructure. And if you go by this definition, there's a lot of digital infrastructure that we simply don't see. And, okay, infrastructure, the nerds are talking about their own fun stuff. Why does it matter? Well, because as I was saying, there's a lot of digital infrastructure going on. Infrastructure has power, it shapes the things. Again, the regulation set by these companies is more impactful than the regulation set by, democratically elected governments. And when you have an authoritarian infrastructure, you have an authoritarian society. And I think, it's not hard to see the signs of this around us. Now, okay, infrastructure, what do we do about it? Part of the problem is a lot of people have a vision of infrastructure that looks a little bit like this. It's, it's all stuff in the cloud, right? And there's some AI on top. And that's, it's getting truncated. Oh no, well, fine. But that's basically the core of it. I'm not saying that cloud and AI are not important. They are important. But if we only solve cloud and AI, then we don't solve the problem at all. Because a lot of the points of capture of value, of the points of power, are at other layers. They're in intermediation, they're in middleware, they're in like all kinds of other places. And so I'm not saying that this is wrong, I'm saying this is wrong if it's the only thing that people see and think of. So we're really thinking of building infrastructure. Actually, in the case of social media, we are building infrastructure, and I'll get to that. But people always worry, you know, one of the first pieces of feedback that we got when we started working on this thing of like, you know, shared infrastructure for social media, is people were like, oh, you're going to do like a national, like state-owned social media? Is that, you know, like forget censorship, is that even going to be cool? Because like, how do you get people to use that? And no, the idea is not that you do the product layer. The idea is that you follow what, you know, other fields of industry have done, which is that there is shared infrastructure for all the stuff where you have natural monopolies, for all the stuff that you have all these effects where you concentrate power, you share the infrastructure, you figure out a governance model for it, and then on top of that, you have a lively, thriving, competitive ecosystem of much smaller companies that provide, you know, innovative products to people. And there are multiple ways of thinking about how we can govern that infrastructure. One is like, you know, public broadcasters, public service media. You know, you just get a public charter, you're independent at arm's length from the state, you figure out your revenue model. Sometimes it's just pure taxation, sometimes you're autonomous. There are multiple ways of doing this. That's one of the models, and perhaps it's a good one for this. I'm not saying that any of these three models is the best. I'm saying we have options on the table that we can discuss as policy options. The middle one is interesting because, like, when you start talking about like, oh, maybe we should have shared infrastructure and some kind of cooperative thing, people are like, oh yeah, you're going to run like some kind of vegan supermarket maybe, or, you know. And it turns out that the banks, the financial, you know, industry had this problem 50 years ago, and they are a lot smarter in finance than we are in tech, I have to say. What they did is they were like, well, you know, if one of the banks runs infrastructure for all the other ones, it's going to eat us all. You know, they're going to have the means to like know what we do. They're going to have all the data about our transactions, and they're going to have all the power over what we do. So we can't do that. And so what they built is a transnational cooperative called SWIFT, which I'm sure you've heard about, that processes, I forget the numbers, they're stupid, like trillions in, you know, value of messages every year. And it's been going for 50 years, and of course it's imperfect. But in terms of a transnational cooperative, that's also a model to run infrastructure that we could apply to the system. And the third one that I want to talk about is the way in which they run internet access in Switzerland. I just spent 10 years living in the US, and I can tell you in the US, internet access is terrible. It's really horrendous. It's extremely expensive, extremely low quality. And the reason for that is because the market is completely deregulated, and therefore all that you have is you know, an oligopoly of cartels. It's a cartel, right? And in Switzerland instead, they have these semi-public things that lay down the fiber for everyone, and then an ecosystem of competitive, you know, product, consumer-facing companies competing for access to the market. And the result is Switzerland has the best, you know, residential internet access in the world for a very, very low price, at least compared to the US, where it's absolutely crazy. So all three of these systems are systems that we know are good economic models, are good governance models, and that we can apply to infrastructure in other spaces. And so with that in mind, we've been working, and I say we because Sebastian is in the room also over there, and with a number of other good people, on something called Eurosky. Eurosky is not a social media product that's going to like replace all your other products. Instead, it's infrastructure for other social media products. And we might ship some products of our own separately, but without, you know, competing with the others. But you can see, you can use it. So if you create a Eurosky account, you can use all the apps, move your data, move your identity around. So you can use it with Blue Sky, for instance, but you can also use it with Flashes, which is a German photo sharing, Instagram-alike kind of thing that Sebastian produced. And I'm not going to go through the list of features that we support, but like this is a network that is sovereign in Europe. it follows European law, but it's interoperable. I'm sorry to use that word. It's interoperable with a network that features 43 million users, and that's growing. And therefore, you get the effects of, internet connectivity, but also sovereign control over the system. And it's great for builders. It's great to develop apps with. It has all kinds of shared compliance so that you can have companies that don't have to worry about their own compliance because it's provided by the infrastructure. And it has really good economics and really good properties in terms of content moderation, child safety potential, et cetera, et cetera. And what I'm describing is not a project. This is not a consultation for maybe something at some future horizon thing. This is a thing, you can actually go to eurosky.tech and see this, and you can see that this is just a selection of a few apps, some of the major apps that you can use with a Eurosky account. But what's great with this is that you create one account, and then every time someone creates an app, you can just switch between the apps without having to create a profile, without having to rebuild your entire social graph, yada, yada, yada. You can just breeze between these apps, and there are many more than the ones that are listed here. Also for the apps, when an app gains a user, it gains a user for the network, which means that there's strongly reinforcing network effects such that everyone benefits from everyone's work. And, don't just take my word for it. You can try all these ads that exist. These are real screenshots from real people. There's blogging. There's stuff that's pinning. There's things that are a better version of Linktree. There's all kinds of things. Microblogging. There's stuff for code if you're into that. There's really a lot that you can do already with the system, and that has been built with very minimum, investment. We could do a lot more if we had more significant funding. And so what I want to say at the end of the day is that not only can we build European digital infrastructure, but by applying these principles where we have shared infrastructure and a competing environment of very active, much smaller, but much more innovative, smaller companies running on top of that shared infrastructure, we can actually make European tech world leading because it will work better due to the way in which we structure it. And so with that in mind, I really encourage you to sign up for Eurosky because today's the launch day, and this is something that's really taking off. But also I want to say this panel is about social media, so focused on this, but we can repeat the same process for search, for advertising, for browsers, et cetera, et cetera, et cetera. And with that, thank you very much for your attention.
So I'd like to welcome the three other excellent experts on stage. We have Sebastian Vogelsang, the co-lead of Eurosky. We have Tobias Bachele, the Germany senior lead at the think tank Future of Tech Institute. And last but not least, Felix Stiemer, managing partner at the Berlin-based consultancy Iconomy. Thank you all so much for being here. I'd like to kick us off with, I think, a rather, large but fundamental question, and maybe we can do a little round. What, in your opinion, is, the biggest obstacle preventing the EU from actually achieving a greater tech sovereignty? And I'll start with you, Felix. We're doing a round.
Well, that's quite the icebreaker question. So for me, Alberto Bacchega said it yesterday, the DMA can't undo past mistakes to a large extent, so it's very forward-looking. And a lot of what we're discussing right now is basically fixing the entrenched, sort of by now, errors of the past. We have observed sort of big platforms and big players enter the market, entrench themselves with an absence of laws like the DMA. Now we have them, and it's application time, it's enforcement time, and I think the last 2 days were a pretty stellar sign that there is by no means momentum to slow walk enforcement, despite the news that we sometimes hear and there, but we need to build at the same time. So for me, it's the duality of break and build, which is pretty well represented on this panel, and the launch of Eurosky fits very much into this. I think Eurosky itself, with everything it encompasses, would have a much harder time finding its way into scalability without regulations like the DMA. for sure. But it also needs sort of a lot of other resources that we need to pile up now in order to unlock private investment, the builders across the continent. And I think we're at a very interesting inflection point right now, but we need to walk both paths at the same time and very quickly now.
Tobias, what about you?
I think we're lacking a certain sense of proudness of what's possible within Europe, or to put it in the words of an outgoing prime minister from my home state, who once declared, of course, he's driving a car that's manufactured in this state. We're lacking that sense when it comes to tech. So we're quite lazy in looking for the alternatives, and this goes down into procurement. But I think we're on a good path finding this proudness. But we really need to channel the investment that we are, and when it comes for social, using a social is the most important investment you can do. So let's find a certain sense of patriotism, of proudness for the tech we have here.
Sebastian, is there anything you would like to add?
No, not that much, I think. I think the main driver will be, I mean, social networks or social infrastructure and the apps on top of it always grow in waves. So that have what they have done in the past. And the problem with the existing social networks are structural. I think Robin has laid that out perfectly. This is why we're focusing on an infrastructure level with Eurosky. But I think what needs to happen is that politicians, journalists, and opinion leaders need to onboard open infrastructure apps and platforms. It doesn't help that a lot of them remain on X or on any of these captured platforms that have this moat around them that won't let users escape. So we need these opinion leaders to drive forward the exodus of these platforms.
Yeah, I think, I mean, I agree with basically what my colleagues and friends have said previously, but also one thing that I think is missing is a combination, and this extends Sebastian's point, of political will, comprehensive strategy, and imagination. The value in my mind of thinking strategically about these things is you can bring funding, regulation, and building into alignment. And right now we're seeing things go in completely opposite directions, which isn't helping. So, we hear funding for sovereignty, everyone's interested in investing, that's great, but at the same time we have an omnibus that undermines sovereignty. We hear about the DMA that could help bring things, but society is not involved in shaping the DMA in ways that it could and should. And so I think there's a lot that we could bring together by imagining what European tech could look like and working backwards from that to a coherent strategy that brings these different branches into alignment.
So you've mentioned a couple of aspects. You've already talked about the structural dependency, but you've also mentioned, the sense of being more proud of what we already have in this innovative spirit. If we agree that there is some sort of structural dependency, for me, the key question is, can we do something from within, or do we need to fundamentally change and reshape the system as it is? We've talked a lot about the DMA already. So maybe, Tobias, I was wondering, would you say that sovereignty itself is achievable within the system that we have, or do we need to reshape it, break it up, change it?
Yes and no. I mean, I believe it is possible. But of course, there are things we can do to make it more likely to happen. When we're talking about the DMA, VIII is bringing out a report in a few, not sure when, but recently, soon, about interoperability, because the matter of, and it's not only about interoperability between socials, but it's rather about data portability. If I want to leave a platform I've been using for 10, for 12 years, I want to take my network with me. I want to take maybe not all the posts with me, but most of the posts I took the last 12 years on that network, I want to take them with me. If we're talking about something like LinkedIn, I don't want to do all the work again, sitting down and putting my CV in there. Having this ability to have this, not only being able to extract it, but to extract it in a common standard, that's in the end an interoperability issue. that would be great. This would help those guys launching Eurosky. This would help many other guys launching challenger apps. So yes, we are absolutely able to, but we can take more steps, and we need to enforce what we have already on the table. Data portability and extraction laws are already in place, but they need to be properly enforced. So yeah, I think it's really possible. And one last thing, it also sometimes already worked. When we look, I mean, Blue Sky is a working alternative, but when we look at Be Real, there was a real challenger on the market. Yes, it's hard to do political communication on Be Real. Let's be completely fair about that. But like the boldness in launching that, trying to hit the zeitgeist, trying to hit something people want, is crucial. And therefore, and this is maybe the last point I want to make, what we need to change, people need funding. We are talking a lot about get people into founding things, get people into building things, which is important. And I think we did great steps with accelerator programs we're having in many of our states, with Exist as a launching program for founders from universities. But if you have a strategic need in a certain area, where you realize this is geopolitics, this is critical infrastructure for our democracy. Social media is the key distributor for news, for information in today's age. So there is an interest in having an open ecosystem and in having European challengers. Where should they come from? Who is able right now to sit down, even with vibe coding and an open ecosystem as Eurosky, who is able to sit down and build something, to think something? How are we enabling them? First step, how are we funding the first few steps? Second steps, be bold, use them, understand. This is some kind of industry policy. This is some kind of regional economic policy. Use those that are already out the market. You're not losing anything. And I really can't comprehend how Macron, how the Belgian vice prime minister is still paying for X but is not using Blue Sky, how the chancellor is not using Eurosky up from today, how they're not using those challenger models. This is not only about why are they on other platforms, this is why are they not using the German, the European alternatives. And if they move that, then I'm really, really sure great things can happen.
I'd like to add, we've talked about interoperability a couple of times. How many people here actually know what interoperability means? Do we? Okay, so a fair amount. Okay, because I wanted to tell a story. I'll tell it anyways. The DMA already forces gatekeepers like Instagram, Meta, etc., to be interoperable with other apps that want to like enter the market. And I've faced this myself when I programmed this app called Flashes that you gracefully showed on screen. And I wanted to have my users import their Instagram photos. And so I took it on to Instagram and said, hey, what can you offer? And there are about 20 loops you have to jump through. It's made so difficult by complying to the DMA, but making it so difficult for individual developers or even SMEs to go through all these loops that it's factually impossible to do interoperable work with Meta, with Instagram, with all these companies. There's no data portability, although they comply, and but it's just not enough. There needs to be more enforcement, and I think when it comes to, for example, having accounts on social media, there must be some way to demand that those accounts can only be on platforms that are interoperable. This would be one of my demands, to say, if you want to use social networks, use accounts that are, or use platforms or protocols that are interoperable, so that the users can switch and follow you on other networks as well.
And just a small thing to add to that, I think there's tremendous power in the DMA and in what it could like enable in terms of like people switching platforms. Unfortunately, that power is locked up inside the Commission. And it's not that the Commission is doing a bad job with the resources it has, it's in order to, Meta can keep creating all these extra hurdles for people to join. We see it with choice screens in search and browsers. It's like every few months the commission goes oh, you're not doing it right. And they go oh, we have to change it. It'll take another 3 months. And then, they can delay and delay and delay. Instead, I think a model in which a lot of the best practices and a lot of the standards for how these things should work should be delegated to expert groups that involve the industry, civil society, and of course the platforms would participate as well. But we could get a model in which people who know how to build standards and know how to build standards for those specific problems could then design solutions that would be, enforced by the Commission as a backstop, but not designed, in a bilateral meeting between Commission and players, because that's clearly not working.
For me, so what I would like to add to this conversation is that, for me, there's two really important things. First of all, I think we need to understand social media companies as they today look, not as this monolith. You showed this slide of the tech stack. So luckily, the tech sovereignty conversation has matured over the past 1.5 years quite a lot, so we think properly about the tech stack behind things. And obviously, when we often said 2-3 years ago, can we build a European Meta, can we build a European Facebook, that has always bothered me, because obviously, this is not a moonshot, this is a mass shot, right? You have identification, you have cloud, you have recommender systems, you have the advertising stack, you have the entire sort of tech stack this company is sitting on today. So first of all, you need to understand sort of how vertically and horizontally integrated this is, from the infrastructure layer to the application and intermediation layer, and sort of start thinking about how can we start competition on these very layers, because every single of these markets and every single of these niches are multi-billion-dollar markets that were non-fly zones for venture capitalists and builders for the past years. And then on the other hand, when we think about social media, we also think about this European Facebook, potentially, that looks pretty similar, but instead of Mark Zuckerberg, Ursula von der Leyen would be calling the shots or something. And what that totally deprives this conversation of is the crazy diversity of applications that could be built and that that were completely deprived out of our creativity. If you think about social protocols and everybody's social life, there's more than just scrolling through feeds. So I think I can see what my friends had for lunch with a sepia filter, doom scrolling information, or potentially joining WhatsApp groups for my children's school class. That's pretty much everything we have right now in social media. And then imagine all professional circles that we have. Imagine the type of relationships you have with peer groups and hobbies, whatever. There are so many use cases to be built, so many different business models to be launched here, and none of them are even part of our imagination when we think about building European alternatives here. And Eurosky launches this and opens this up. So for me, it's let's not build the European replica of something American, and then also let's think about this as the tech stack that it is and start breaking parts of this tech stack off and then start launching activity, because then I truly believe there is not a scarcity of capital. We will see so much capital crowding in that we would never discuss the need for funding again in roundtables like this.
And very briefly to that specific point, at the Rebuild series of events that's going on throughout the years, the first event was a month and a half ago or so, there were 60 European products for social apps of different kinds. Now, I put anyone to the test. Could you write down 60 ideas for a social app? And I'm betting that you probably couldn't, or it would be challenging, right? It would take you time. But because these people can build on a shared infrastructure, they can just have an idea on their own with a friend, bootstrap it, look for some funding afterwards, and start iterating on those products. This is the world that we want. We don't want a Facebook, I agree. We want all these apps.
You've mentioned funding, you've mentioned usability, and also maybe sometimes lacking the simple political will. I've been wondering if there's one piece missing in the equation, and you can tell me if I'm wrong or not. The users per se, obviously that is related to the usability, but I'm wondering we've talked about interoperability. Obviously, that has an effect on networking effects as well. And yesterday, Ben Scott also in his keynote speech said we should establish a safe European social media. That should be quite a compelling argument for users also to switch to alternative infrastructures. So I'm wondering, what else do we need for people to make that shift, or are we actually underestimating user convenience, I think, in that entire equation? Is there anyone who would like to jump on that question?
I can keep talking. I've been talking too much already, but like, thanks. I think, I mean, in order to make it optimally easy for people to build new things so that there's proper supply and that could drive demand, we need to make it as easy as possible for people to build, right? The objective that we have openly is that you can have an idea in the shower in the morning and you've shipped a prototype that's functioning, that's an MVP by bedtime. Of course, using vibe coding, but like, you know, with enough of the infrastructure that it works. Some of the stuff for that we already have, like most of the key components we already have, but some of the difficult things, since you mentioned like Ben's point about like safe social, is doing shared content moderation infrastructure. And the idea there is not, you know, to content moderate everything in one unique way for all of Europe with, you know, CEO von der Leyen deciding like every tweet whether it goes or not, but rather to have shared infrastructure for strictly legal content, you know, being able to get rid of CSAM, being able to get rid of terrorist content, et cetera, for everyone, so that no entrepreneur has to worry about like going to jail and you know, like really horrendous content. And then because this system we have allows you to have multiple sources of content moderation as a user, you can decide who you subscribe to in terms of content moderation, really building up that ecosystem as well. And that essentially, you know, the technology exists. Most of what's needed is some funding to get it off the ground. Afterwards, it can pay for itself because like these businesses will pay for it. But like, we just need the initial investment there.
Thank you. Yes, of course. Another thing that it always bugs me, we talk a lot about social media, but like what we have today is actually not social media any longer. It hasn't been for 10 years. It's parasocial media. And it's a lot of the times it's only media. So what happened in 2018 was that Facebook until then showed you what these apps that we're talking about do today. They show you your social graph. When you log in, you see what your friends are doing, the people you connect to. And that worked quite well for Facebook until 2018, when they decided that this wasn't making them enough revenue. So their revenue model is showing you ads. And when you just look at the stuff that your friends do, you leave the app after half an hour, maybe 45 minutes, and you're done with it. And that's actually, in my opinion, healthy social media, right? So, but that didn't do it for ad revenue. So what they did, they changed the timeline. They started showing you stuff that they thought was interesting to you, and they quickly realized that polarizing content will get you stuck to the app. It will glue you to the timeline, and it will keep you scrolling and scrolling for hours. So a lot of what we're discussing today are the problems that result out of that decision. It's the algorithms that drive all these problems into our lives. So once you get rid of that, you get back to where we came from. You get back to the social graph that all these apps share that Robin talked about. You get back to building content and apps around a shared social graph that you build with the people that you like, that you're interested in. And I think when we get back to that, when we look at the polls that came out last year, I think where we saw that Gen Z is offboarding social media already because they're fed up with what the big tech companies deliver to them. They just leave. They have been leaving for 2 years, except the US, I think, is just one outlier in there. But in all the other countries, the young kids, they just say, we're done. We have enough. We want to go back to something that is more healthy for us. And we're trying to deliver that with Eurosky Social, because I think there's a lot of benefit to the social media that we once had.
I agree. You cannot overestimate, you cannot make sure enough to calculate in the laziness of people. I think people are fundamentally lazy, and as long as somehow it works for them, they stay there. But on the other hand, also don't underestimate the glamour of something new. And whatever this something new is, and I think this is, and in my opinion, this is the crazy, incredible, immense chance of Eurosky and the atmosphere and AT Proto, that it's, and this idea of sharing the most expensive parts of infrastructure. Because like, let's go back to Be Real, because like Be Real was the answer to this is not social anymore, I just want to see my friends and I want to see them not as they like to describe them online, but as they are right now. So this was back to realness. It took 2 years until it took off. It had no real idea on how, no path on how to become a global platform. So they did an exit, incredibly successful, nice one, congrats. But it kind of left us with we realized disruption can happen. And I think the learning is people like something new. People will go there. A hype can be created. Let's not dive into not dive too much into how much this hype around Be Real was really artificially created as well. But so this is a proof of concept. But it would be an even greater proof of concept if those users would be in an ecosystem where they could also try out other things, where content moderation and the infrastructure being built could also benefit and make it easier for another new kid on the block to build something. And I think this is crucial to understand. I honestly believe, I don't think we will win this idea simply with alternatives, with the idea, as Felix described. This is not about building the same thing we want to get rid of. I mean, those apps, they all look the same. Since TikTok, they all had to implement some kind of reel or shorts or however you want to call it. And there's no distinguishing between, I mean, some have a bit more AI slop, some have a bit more old comedies from the 90s slop on there. But it's the same on all the platforms. I am completely sure if there is something new, this can create a hype. Maybe for a small bubble, but maybe even for a certain range of age where people are going to change. And this is what we need. So once again, make it easy for people to build and then make it easy for them to scale. And on the other hand, as user and as public institutions, realize you are part of the product, your engagement, your using the app is like small kind of investing in it. Be risky, try all the alternatives, and try to give them a chance and invest your time in it. This is what makes them fly in the end.
Just 2 sentences add on. Exactly. The kicker is that it only needs one app to take off in this ecosystem to bring this entire market to a new level, because every app brings in new users. Every app with its unique use case shares the same user database or the same user base. So imagine one app taking off, bringing in 1 million users into the ecosystem. Those users can use the same account with all these other apps, and they will drive users to all these other apps.
In the interest of time, maybe one last question to round this up. So you've talked a lot about scaling up and to have that ecosystem where users also feel safe. Obviously, there needs to be funding. We've touched upon this issue a couple of times already during this panel. I know that, or we know that in the US, there's been a lot of public procurement, especially investing in US technology. So I was wondering, from your point of view, what's the role of the state in all of this? Is the state supposed to play a role in promoting or investing in digital public infrastructure?
Take a start. I mean, Robin, even though, I mean, you work for the New York Times, so you're the only person that's allowed to use Times New Roman on your slides still. So, no, but
Times New Roman.
no. So you showed. Sorry, that.
Well tired.
Yes. The question was.
About funding. Funding.
Yeah.
Money.
So, public infrastructure. These infrastructures we're talking about are tending to be natural monopolies, right? There's no means in sort of duplicating them, and natural monopolies have always had a need for state intervention, state involvement, setting the rules, and sometimes even some form of state ownership or some sort of private-public partnership. So for me, this is entirely indispensable here, and you pointed out correctly. But also, it is very important that the state and state actors don't crowd out or compete with private investment or try to sort of engage on the market on top of it. I think it really comes down to build the infrastructure to an extent where private money has not sufficient incentives, but just to the point where you see the first private investment coming in. And I truly believe for the first time in years that we're just months away from this. For the first time since we've been doing this and since we've been discussing this. So I see a super limited time span, super limited budget requirements, and then a role of the state to basically, like you said, adopt it, lead by example, and stay involved not just as a regulator, but also as a user and as a demand side as well. But I just want to sort of counter the idea that this might be this insane juggernaut of a multi-billion euro thing that everybody has to now sort of throw money at for a few years, so that these geeks can try something for a few years, and then we sit again at the conference Pencho hosts in 2029 and still say, when do we break some scalability? I think we're literally months away, and the funding required is minimal.
Pencho, you let me know, do we have time to open the floor for one? So no questions from the audience. Okay.
You can join the Pencho.
I mean, we can also...
Just one statement, please.
Okay, let's do one last statement. What would success in European tech sovereignty look like for you in the next 5 to 10 years?
You go ahead.
Okay, I can take that. I mean, I really think multiple things. First, we have to think in terms of the potential of things we do together socially. And like, again, we've said this several times, people think social media, oh, that's microblogging, maybe pictures, you know, maybe reels. But like, there's already people who are pushing out scientific data, draft papers, museum data out of there, because all of these activities are social. And therefore they can do them together, and you get shared curation of knowledge, shared review, peer review happening on protocol in an interoperable way. This opens up new potential for things we haven't even imagined. And in my mind, like, what, you know, we tend to like really approach, in Europe, we tend to approach tech policy in a very defensive way. Like, we get things like the democracy shield and all that. I'm not interested in defensive. I want to build new things. Like, honestly, I'm a tech person. I don't want to be at this conference. I love you all. I love you, Pencho. But like, I want to be out there like building stuff, right? And so what I want is a democracy sword. And I think that is where we can take this thing, because we can really have a European tech ecosystem that is world leading, that people want to copy, that people want to join and interoperate with, simply because it is better and it is delivering things that no one else is.
Great. I think with that, I'll close this discussion, so everyone has still 10 minutes of a break. Thank you so much for, well, having this lovely discussion.
We have 3 sub-headlines for the summit, and now we want to focus on the third, and really can't stress this enough, how important it is that we also build the infrastructure. And to kick the panel off, I just wanted to point out 2 quick stories. And I wanted to ask in the audience, who here knows the US company Oracle? Maybe by a show of hands. Who also knows where that company derives its name from? Not so many. Okay, a couple of people. They actually started out, and one of their first customers was one of the famous 3-letter agencies in the United States, and they built a program for them by the name of Oracle. Now the company is much, much bigger, not only serving security customers or public customers, but that is just one example in the United States of how an early company, a very small company, was trusted with such an important project by an intelligence agency. A second point I would like to make before we go over to the panel is that of 2 students, namely Bill Gates and Paul Allen, who, while still in high school, were entrusted by a hydro public company in the home state of Washington to do a program for them. So now my question would also be to the audience: who thinks that either a public power company or an intelligence agency in Europe would do the same thing to a small startup? Anyone think that would be a possibility? That's what I thought. And to discuss this further, how we can actually leverage the public sector and public procurement, I would warmly invite our panelists to come over. And please give a warm round of applause to our panelists. All right, and we're here to talk about preference schemes and a common approach, whether or not we can find one. And I'm very grateful that we have both a German representative here who can talk about it from the perspective of a chief procurement officer in our new ministry, and also a French counterpart, so to say, from the economic ministry. Thank you, both of you, for being here, and for a more market-oriented view from an economic perspective from the University of Mannheim. Also, thank you very much for being here, Martin. To kick things off, I was reminded by the remarks of Mr. Ralph Brinkhaus yesterday that if we don't start building our own public infrastructure and especially cloud infrastructure, we are continuing to be a digital colony. And we're trying to discuss how we can change this. So, we have this growing discussion now on the Bio-European or the national mandates introduced, for example, within the Industrial Accelerator Act. But we want to focus in the beginning more on public procurement in general, whether or not it can actually build an industry, whether or not it's a valuable industrial policy tool, and what your thoughts are on this. And actually, I would like to start with you, Martin, if I may. Directly to that point, do you see public procurement as an industrial policy tool, and if yes, to what extent?
It can be, so thank you for the question. So let me put it this way. I think it can be used as an industrial policy tool, public procurement, so clearly there is quite a bit of money behind. It is also spent in sectors which may be relevant, so not just staples. Staples have come out of fashion. That one perhaps wouldn't count. The question is whether it should be used and whether it can be put to good use. And I think that's what we are probably going to discuss here. And there is, of course, the question, what does it mean to introduce particular preferences? You can do this indirectly in the way that you agree on principles, and these principles make it also possible for European companies, especially smaller companies, to compete in that space. Or you have some explicit rules where you discriminate, and as an economist believing in open markets, I'm very much in favor of the first.
Yes, now we go over to maybe a little bit different perspective. Aurélien, I would also put the question to you, especially from a French perspective. How do you view public procurement? Are you in line with what Martin just said, or is there maybe a difference?
I mostly agree in the way that it is a tool. It is one of the tools, and it's particularly striking because in France we had this big investment plan for innovation of 50 billion euros. So we were financing a lot of innovation, and all of the startups, especially in some sectors, they just came to us and say, we don't want innovation funding anymore. We just want to have commands. We just need to have business. So, and we need you as a public, as the state, as the public authority, to help us in that way. So, via public procurement, but also via, as you said, incitations, also for private companies to think about also their vulnerabilities to non-European actors, especially in the digital sector. So we all think that we have to deal with this issue. The question is yet how to do that. Do we have to enforce that? Do we have to just make suggestions? There's a wide array of possibilities, and so we need to be very pragmatic on that. But it's really an important lever, in our opinion.
Bringing you in, Felix, from the German perspective, there's always the frequent critique that we have European providers. They do make the offer available, but for some reason they are not able to get the opportunity. They're not chosen because of specifications by the private market. Is that a true statement, or would you say that's an overblown exaggeration?
It's interesting. I hear it a lot of times. So, and I would say partly yes, partly no. We have really great German or European companies in our contract portfolio. I can say we have great Lancome routers, for example. But the problem is we don't have this big market here in front of us. So, so if looking on the market side, at the market side, we have all these, the most of interesting new technology coming from other countries. And I think this is the one side of the problem why we don't see a lot of German or European products in our contract portfolio, but we have them also. And the other thing is, yes, we can, for the first question also answering, yes, we can be a anchor customer. So I think, but we have to align with the demanders. So it's in German, it's Bedarfsträger. So the public buyers, for example, they can say, I don't buy what you said, for example, Microsoft Office. You can't say, I don't buy it for you if you want it. You take open office. So the problem is you have to deal with the infrastructure to build up internally all the personnel that is caring about. So the buyers only, they have to act together with the demanders. And I think this is the bridge that we have to take because we have a lot of centralization of public procurement, and this centralization is good for professionality in public procurement, but it's not that good in dealing with strategies to change. Yeah, and so all the last 20 years of centralization we are at a position where too far from the need itself, and so we have to build up this bridge to make more strategy.
Yes, so talking about supply and demand, Martin, to add you to the conversation as an economist, we've also heard the minister just talk about the Draghi report repeatedly. And for those of us who've read it, the numbers are quite staggering, that he points out that are actually needed if we want to have a meaningful actual infrastructure of our own. So the question would be, is the public procurement market and the sums we're spending in the European Union, are those actually sufficient enough to build an own market, to build a digital sovereign market that is European controlled but also owned in the sense of the companies?
Well, I guess we haven't, it's always useful to define again what we actually mean with digital sovereignty. There can be many different things, and I think we should make, and that's outside public procurement, we can provide also more legal certainty and provide an environment that foreign companies operating within the European Union not only have to comply, but also that there is a risk of disruption that we can reduce it. Plus competition always helps. So we should be, first of all, I guess, neutral to that when it comes to some parts of the infrastructure. And of course, whether it works or not, I think that first of all, we have to respect, it's very important that we do have an internal market and work on that. Otherwise, if we think about data centers, yes, of course, it's perhaps nice to have them, I don't know, in the Alsatian region or somewhere in Bavaria, but it's probably not the best location to have them. And so we have to make sure that it's really an internal market perspective when we think about building up that infrastructure. And I think it's important to think about, first of all, that investments are made, and then the question also is made for what? There's certain parts where I don't care whether those data centers are in the US. I mean, sorry, that's perhaps my personal preference, but I guess it would align. I mean, if all the porn material used in Europe is in the US, perhaps we are less concerned about it. Well, I mean, some people may be more concerned, but anyway. So what I think is we have to really define critical sectors, and in those cases, through criteria, we can have to make sure that certain parts of infrastructure is in Europe, and otherwise what we have to make sure is that there's access at rather competitive rates to be able that the value chain which is built where infrastructure is just part of it, that the value which is jointly created, that value stays for a large part in Europe. And I think there, what procurement can do, of course, it can help an innovation-friendly environment, and that's what also the Draghi report is about, the competitiveness. It's not only about I mean, data centers and digital infrastructure may be an important part of it, but it's definitely not the dominant part of it. Value creation, that's much more the non-physical part, and that's where I think Europe has to catch up, and where procurement can play a role. And I think there's some broader issues. So if you think about procurement, to what extent price plays a role, or to what extent we look at more innovation measures, it becomes more complicated, of course, if we just don't have a price in there. But it's also a matter of risk attitude. And if you are risk averse, you go for the large incumbent. So it's a very much also in communication exercise of politicians, of the public. Are we willing to take some of those risks? You were asking it exactly at the beginning. I mean, if somebody here in Europe would reach out to some high school graduates to build up an app, and then there are some problems with that, I mean, that person is in trouble. If the same or a more severe problem happens provided by SAP or Microsoft, then it's not a problem.
Thank you. Yes, very important point. Let me come back to you, Aurelian. On the European level, we are now revising the procurement directives, and there's also a Procurement Act supposedly coming this year. And I'm wondering, especially in the Franco-German debate, do we have enough reasons already to rethink the approach to public procurement? I know there was the summit last year in Berlin talking about this, but where do you see the whole conversation going, and how has it developed in the past years?
From the French perspective, I'm not going to be in charge of these subjects for the French ministry, but so maybe the insight of Felix is going to be also very interesting. But we are quite convinced that we need to simplify the processes, but at the same time, and that's going to be a strong position that France is going to push, is to find a way to implement a European preference in public procurements. The modalities still need to be defined, and we still have to find what is the best option. Should we make, as the US does, apply a bonus for a European solution, so that in the end the buyer can still buy a non-European offer if the bonus is not enough to, for instance, even if with the bonus the European offer is not considered as competitive as the American one, then you can take the American or whatever country. But we still have to define that. But the first step, since you mentioned the summit of last November, is to find a way to define what a European digital service is. It's quite complicated. We're working with our colleagues from the BNDES on that. It's an ongoing process. We hope we will be able to make some consultations towards the other member states and also towards our ecosystems, just to have some insights on some criteria, just to be sure that we're going in the right direction. But yeah, that's the main issue.
So in terms of also the industrial accelerator, and I will bring in just 1 second, two concepts that have been floating around and I think many have not been able to fully grasp is this first, this made with Europe requirement or a made in Europe requirement. And there are many different interpretations on what that means, not just the industry accelerator act, but maybe also in procurement. So if you could, either one of you, please explain in your understanding what these concepts are, and maybe also where you're not aligned in the Franco-German understanding of this. Please, if you want to go first.
Okay, well, made in Europe is going to be quite easy. Like you look at the value, for instance, in the Industrial Accelerator Act, it was what percentage of the value of these projects is made in Europe, in strict European Union, and made with Europe, and then you would extend that to some like-minded countries. I don't exactly, I have to admit, I never really grasped the exact geographical delimitation that was implied by our colleagues from Germany. So, but maybe you have more. I know it's not your ministry.
Yeah. So I think the difference is made in Europe is more reflecting their origin, yes, and made with Europe is more where is the risk management. So where is the data flowing and these things? So some kind of a value creation in Europe, but it has not to be the origin of the product. So I think that we are dealing with these both concepts. And perhaps it's the both. We are not at the end of the discussion, but perhaps it's the both. In my opinion, today it is really possible to have public procurement procedures with strong digital sovereignty aspects. So I added it in the paragraph 128 of the German procurement law that is coming, that these aspects are able to be considered. For example, if you see what is the influence of the legal company and the interference with legal legal influences, you can have it as a kind of criteria because it affects the way your data is protected or not, how secure you can have your data. So in my opinion, it is already today possible, but you have to be not risk averse. You have to have this courage to use these criteria. And I think that's more that the procurement law has to be more open, in my opinion. A lot of people in the public procurement law say, or they feel like it is the good Bible of public purchase. And that's not the fact. It's more strategic. It's not that these formal rules, so it's misunderstood, the public procurement law. And we have to give more competencies to the people to act for making good contracts.
I will come to you in just 1 second, but I wanted to build on what both of you have just said. A contentious issue that has come up during the summit quite a couple of times is our relationship or changing relationship with the United States. And when we talk about made with Europe and with trusted partners, simply put, in your view, is the United States still a trusted partner in the technology realm? You can go ahead.
So you see our contract portfolio is full of US technology. So I think they are a partner, but it's how to say, it's not that that confidentiality is coming from nothing. So we have to, we have to evolve criteria to know better what are we using in which contexts, and so we have to, we have to bring us in the position to choose and do it to choose, that's it. So I think we are relying in a big portion of IT infrastructure and services on US American technology. We have to admit this, and it will be a long time. But if we work on that, it's more a kind of building up strategic capabilities with public procurements.
And just to complete, actually, they are a partner, trusted, and we need to be pragmatic. For some uses, they can be trusted. If we come to very, sensible data that is going to be involved, then maybe we can be more cautious and consider that they couldn't be. For instance, in France, we enforced in the law the fact that for sensible data, especially data concerning health of citizens, they have to be processed by some offers that are not submitted to extraterritorial laws. So, for instance, and when we do that, of course, we think about the Cloud Act of the US. So we think that we really need to be pragmatic. For some uses, we can use the sensitivity is more going to be on the resilience of the service, and for some other, the data that is going to be concerned. And so we have to adapt and find the right criteria for the right use.
Thank you. Martin, you wanted to jump in?
Yes, so I'm fine with the criteria part. I'm definitely very much against anything of made in Europe. I mean, that's pure protectionism. I find it's completely dangerous. And I would very much encourage to have more the debate on what are the right safeguards. And that, of course, can sometimes mean that it boils down to offers made from companies based in a subset of countries, but that's based on the particular assessment of what is the use, as you are mentioning, I guess, with sensitive data. There's a very good reason you want to have them physically within the EU and also legally that they are safe, that nobody has access to them. And so I think this is clear, but that's then based on clear objective criteria, and it's not based on a general push towards a particular subset of firms. And so I very much hope that the debate is more in the made with Europe direction than in the made in Europe direction. I'm not speaking for any government, so I can really just say what I want to say.
Very good. Keeps the discussion alive. One idea that has been floating around, already coming back to you, Aurelian, what do you think about the idea to say, okay, we put in a procure sovereign requirement, but if no European alternative is visible or on the market, then it's okay to switch, not just in sensible sectors, but in general, in procurement in the tech realm. Is that something we should be pursuing, or would you say that we should be very cautious of the protectionism as well in that regard?
No, but once again, for instance, when I was talking about what the US are doing, for instance, putting a bonus, it doesn't mean that you are doing a protectionism per se. It's more because the problem in the digital, like for instance, the Industrial Accelerator Act was clearly made to try to save some industries in Europe and just keep them doing. In the digital, we don't have it, so we have to build. How do we build? Maybe doing that. Instauring a preference it's not closing the door to non-EU offers. And if there is no EU alternative, then of course we have to be still modernization of the administration and using the most competitive offer and products is very important. So we cannot just say, okay, if there is no offer, then we won't do anything and we will still do everything by paper. It's not possible. So of course we have to do that. But even if there is a European offer, or maybe just that's what we will try to do. I know you disagree, but that's what we want to do, is just to give a little bit, a little support for the European offer in all of the criteria the public procurer is going to go through.
Thank you. Excellent point to my next question, which would be for you, Felix. So something that I've been wondering is when we talk about functional requirements and the actual design of the public tenders that the contracting authorities put out. I mean, one way would just be to write in, it has to be, the company has to be headquartered in Europe, has to be value creation here. But there are also smart design choices that can actually lead to a very similar or even the same outcome. But one question that arises then is, when do these requirements actually become a de facto discrimination? Because they are so neatly tailored to European company XYZ that we don't have a global competition anymore.
Yeah. Yeah, it can be, it happens. Sometimes it is designed. I know these public procurements, but we have to take care that in our legal system, we also always have to have a good reason to discriminate. And I think this is one of the whole question. Why do we discriminate? What is the reason that we can understand that I don't know the word, but no. So, yeah, to justify this discrimination, and I think, yeah, if we tailor these public procurements, this would be not the right impulse to the market to get better and to innovate. So, yeah.
Yeah, please, Martin, anything to add on this? How do we balance this whole notion of remaining an open market while not sliding into protectionism?
Well, I do think at the abstract level, it shouldn't be that difficult. Just refocus a little bit your efforts. So first of all, first statement, bonuses are clearly protectionist. Yeah, I mean, even also a tariff, price or non-price, but a price tariff less than infinity is still protectionist. So as soon as you introduce a bonus, it is protectionist. Now, I'm not saying you can't do it, and I think in certain sectors you want to have it, and actually want to have it very large, but that's only for very specific purposes. And these purposes have to be explained. So there must be a reason of why you want to do it. It is resilience criteria, but they cannot be applied across the board. They should be applied very selectively. What can you do? What can you do? So I think you want to do, first of all, horizontal supply-side measures. And what can that be in the procurement context? You provide support to European companies in the procurement process. Make life easier. I mean, don't make entrepreneurship hard and then you run monetary subsidy schemes or bonus payments. No, I mean, I think the right way to go forward is to make life easier, to open things up, to make procurement in a way that it is accessible to small and medium-sized enterprises, that it is innovation-friendly, that you take certain risks. And once you do that, you provide an environment which helps small and medium-sized companies. And if we think about the digital work, I mean, well, that's where Europe potentially can enter if you make the procurement in a way that only the very large ones can succeed, then we have in most parts, we don't have any very large ones in Europe. So it's more it's a consequence of changing the procurement environment that this favors European companies and European companies which are competitive. So you want to have a competitive environment. So instead of spending all these efforts around tables of what we can do as specific investment schemes, rather think about how can we make life easier for companies to succeed in the procurement part, but of course also in the marketplace more generally.
Thank you. Felix?
I would like to say something because we have a project that is called Marketplace Germany that is consolidating all these about 160 portals for public procurement procedures that are existing in Germany. It's a project in the federal modernization agenda. And so we want to make a platform that is AI first and once only data, so that with a strong, how to say, company profile, where you don't have to put in every time the same data of you to compete in public procurement procedures. So this will be, so we just have an MVP since January. And we are seeing the first steps that, for example, we scan all these company websites and profiles, and and you can claim this profile, correct it, and you have all your public procurements that you have won inside, so that you have references aboard. You have the connection to the, how it's called, the Wettbewerbsregister and all these registers in Germany. So this will make the life much more easier for the public procurement agency offices also, and this is the intent for the market. And imagine that you, for example, you can say, I want to send to all these companies in such area in Germany that we have a public procurement procedure for their products here on this public procurement platform. So this would be great, yeah.
So yeah, making life easier is, I think, a very good point on that. I wanted to ask specifically on cloud, Aurelien. You mentioned the US Cloud Act and foreign judicial systems or judicial reach into European companies. In your opinion, can foundational technology like the cloud ever be truly sovereign if it is at all through some backdoor or joint venture or something subject to such an act as the US Cloud Act? Can it be truly sovereign?
Well, it depends on what you think sovereignty is. But so as I said before, for instance, for very sensitive data, we enforced in the law that you have to fulfill certain criteria that will not guarantee, but almost, that you're not exposed to extraterritorial laws. And so what we saw in France is that big tech, such as Microsoft and Google, they made some joint ventures in France, which are Bleu and Sens. And so the companies are 100% French. They are their infrastructure is 100% localized in France, and so the data stays in France, is not exposed, but the tech is still US. So it's safe, but is it sovereign? I don't think so. So we still have to go on. But we have some offers that are certified by our cybersecurity agency that are more sovereign in the way that the tech and the stack is European. And so we think that it exists. It's not definitely not at the scale to answer to all of the needs of the public administration in France. So not even think about scaling it to Europe. But we still, with these expectations, we are still driving the building of a stack, at least in cloud, a European, fully European. So right now we have hybrid offers that are considered as certified. So hybrid with US tech, but also 100% European tech.
Do we have time for a couple more questions? 5 minutes to get the voice. All right, so 5 more minutes. I would like to take 1 or 2 questions from the audience. So if there are any, think about them, and I will get to you in 1 minute. Just. Oh yeah, sure. Then why not? Go ahead, please.
Yeah, my name is Wolfgang Oels. I work for Ecosia, the biggest European search engine. I think in the 1960s, South Korea and Japan were really poor agrarian countries. And then within 1 or 2 decades, they became, first tier industrial countries in several sectors. What can we learn from how they did that? Because we're kind of in a similar situation, perhaps in digital. What can we learn for our digital growth, catch up from these countries?
Martin, do you want to?
Yeah, I don't need to. I can say whatever I want to say, exactly. So you should be sweating already. I think the South Korea and Japan tells you one possible way of success. I guess another one might be Singapore, a more recent one, and Taiwan. Long-term commitment. For that, you don't want to live in a world where populist intentions drive policies. So we are not in a good situation, I guess, in Europe to emulate those models. You need to have an understanding, which may be a broad understanding in society, or an understanding which is driven by somewhat more autocratic ways of governing things, as it arguably was also in Japan as a democracy, where it was always the same party. So that works. So I think that's one concern why I think it's difficult to emulate in these times in Europe. The second aspect, I think, is you need to have, among the smartest people you have in the country, they have to be in the ministries or in those places. And that's, of course, something which we are aspiring to in Europe, but I'm not taking it for granted that it's always the case. So I think, so what you need is you need to have a strategic perspective, and that strategic perspective has to be really driven by technocratic knowledge and not by gut feelings by people who are not in the position to evaluate those things. Okay, because we have seen, of course, if you look back in the past, I mean, we always know what are the key technologies, only to be sometimes then proven wrong, sometimes be proven right. So I think it takes a long-term perspective and a lot of technocratic knowledge and a culture of cooperation between government and industry. And that means also a high level of trust. And that's something perhaps to work for, but you won't get it immediately.
I believe there was a second question somewhere over there. Yes, please.
Finally, I had the same idea regarding then China to say, okay, what their approach in the automotive sector, and what you said, say, having in mind China 2025, to say, okay, I have a strategic idea how to develop my markets. And to narrow it really down is we have to live with dependency until we are that strong to leave dependency behind us. Saying that is we have to think about, for example, Deutschlandstack, the idea to say we have a predefined set of suppliers following sovereignty criteria, so maybe also some kind of EU preferences, and demand it from the market. So say, okay, we have the idea that the market should deliver, and then, of course, use them with a strategic approach to look, to copy, to invest then, of course, in more or less local solution, and then to overcome the dependency. But of course, this means we have a strategic approach for 10 to 15 years. And obviously, I don't see this long breeze we have to take in Europe that we are able to say, okay, we have this strategic vision. So my question to the audience is, how do you see the project like Deutschlandstack or others as a front runner of to making digital sovereignty real concrete products in the end, as in the sense 60% of the GDP is public procurement? Thanks.
Yeah, I was going to suggest, yes, please.
Mikrofon.
Andreas Reken, ITSMF Germany, IT Service Management Forum. I have even 3 questions. I hope it's okay. I make it short. First, I address it to Aurelien. First, we have a problem with shadow trade of data. Proposal from my side, make data trade transparent by the means of stock exchange, by a kind of stock exchange that is visible, public and controllable. Second, the digital avatar of people, make it controllable and manageable by giving the lead to an organization like the United Nations. Third proposal, mandatory public. Most discussion concerning social medias and other solutions are turning around the circle of algorithms. But my approach is not only think about algorithms, but also think about the structure of data. And the proposal is make mandatory data dictionaries, not only transparent algorithms. That's it. Thank you.
Do you, since you were addressed personally, do you want to give it a...
Well, I'm not sure I really got a question. I just had more...
Okay.
Yeah.
Yeah, since we're also in the interest of time.
Yeah, so I said, the question for the Deutschland Stack. So in my opinion, and that's what's ongoing, it's to build up a strong portfolio. So we have to build up a portfolio of these products in the Deutschland Stack. But we have to take care that it's interesting for companies to build something for the Deutschland Stack. And I think this is something that, from my perspective of the public procurement, we have to work much more harder because the business logic behind the Deutschland Stack has to be more evolved. It is not only to be interoperable and having, predefined data APIs and so on. It has to be interesting to make business inside of the Deutschland Stack. And so this is for me, and the portfolio that is coming out from this is for me the guideline what to procure. Yeah.
Thank you very much. This concludes our panel. Thanks to all of you. Please a warm round of applause.
I am incredibly excited about this panel because in discussions about sovereignty, cloud is the elephant in the room. We all know the facts. The European cloud market is heavily concentrated. More than 70% of the market is controlled by Amazon, Google, and Microsoft. We've heard various proposals in the last 2 days, including to give up and entirely ignore the stack, not engage. What we're trying to do now in the next 50 minutes, I don't want to do another general discussion about sovereignty. We all agree here. What I want to get to is sort of how can we change the trajectory of this market within the next decade. And I'm very excited that I'm joined by 2 people who are trying to do exactly that and who have deep industry experience that will hopefully enlighten also the policy discussions that we're having. We have Achim Weiss, a seasoned veteran of the internet industry with more than 25 years of experience. He has built data centers long before this became a policy issue. I think that's fair to say. As the CEO of Ionos, he's responsible for the company's overall strategy and product development. I know you're doing lots of things to change the market, but just to highlight one of them, you co-founded the Sika API. It's an open industry standard for cloud infrastructure management. So one of the approaches you're taking is federation. Then we have Bernd Wagner. He's the Chief Sales Officer of Schwarz Digits and responsible for Stackit, the group's sovereign cloud platform. Fun fact, before joining Schwarz Digits in late 2024, he was General Manager of Google Cloud Germany, so he brings deep expertise from inside a US hyperscaler. Stackit was built to serve the Schwarz Group internally and is now open to external customers with the ambition of becoming Europe's first homegrown hyperscaler. So we have 50 minutes, no slides, no presentation, and I would like to do, Pencho, could we have a timer? Otherwise, we'll just go on forever. I'm joking. I would like to split this up in two parts. So we know the general problem, but there are various interpretations of what problem we're actually trying to solve. So I want to talk about the problem first and then move on to solutions. And my first question is this. A German CIO who is deciding on a cloud provider if they're not already locked into a contract that's very hard to leave, they're not making a political decision, they're making a business decision. And the reality is that currently they are choosing US hyperscalers. My question to you is, why are European providers losing on the merits, or are they losing on the merits? What's the reason for the market concentration that we're seeing in Europe today? And this is directed at Achim.
Yeah, I mean, the history, I mean, Amazon, AWS is like 20 years old now. So they have the first mover effect, they had tons of money, and they grew very fast because they got very big contracts very early in the career of the company. And that's something which is actually missing here in Europe. So the whole government, all agencies you can think of, poured millions and billions into AWS in the early stages, which helped them to grow much faster than what the system is here in Europe, really. And, first mover effect, lots of money, and the government and, and an environment which make them really thrive. That's why they are so where they are now. So, and then Microsoft, the other thing is Microsoft is a huge company, has a huge ecosystem, has millions of, tens of thousands of big partners around the world. So they could utilize whatever they had in the past to make their cloud business run fast. And then, of course, we have Google to a certain smaller degree. But Google, we know Google is also very big. They have lots of technology, lots of people, huge data centers. So these are pretty big advantages. And as a CIO in Germany or in Europe, why would I decide for a European company? Yes, we don't have as many services as they have, not even close, to be honest. And I think everybody who's saying something different is kind of neglecting reality. But the Pareto principle actually applies here. You have 80% of your workloads can be done with 20% of the functionality. All these large hyperscalers, they have tons of functions, satellite downlink station as software. I don't know any company really needing this, maybe Airbus, yeah. So I think the normal CIO has to look on, what's in for the money, what do I get, stability, scale, great support, mindset of am I a customer which, on eye level, which is with Amazon, only if you're a very large company. Smaller companies, it's very different. And then you said without serenity, without politics, but serenity is a key argument, even for smaller companies, because nobody wants to be, putting his business at risk if, got shut down with your email addresses, which happened with Microsoft. We know all these stories. So, that's another business decision, and everybody doesn't need to do risk management. Yeah, and this is part of it. So I think there's a lot of reasons. We're not more expensive. We can scale. We have the basic services. So we're just not as old. Yeah, we just didn't pour as much money in the last 20 years into that business. So that's why we're not on that scale.
I'd love to direct the same question to you and really say...
Frederica, can I build up on what Achim said? I totally agree to everything what you said, Achim. In addition, you tackle it a little bit, it is the anchor customer. In the United States, all three hyperscaler do a significant amount of business with the government, with the defense sector, and a couple of others. Significant. And most of the new inventions also had been financed in this approach. And that is one of the major differences when you compare this to what we see here in Germany and Europe. We discussed quite a lot, also we both, in different discussions, by European. That does not happen here. Yeah? We are open to all across the globe. but try to get business in critical infrastructures in China, in the United States, or in other countries, protected countries. That is not only difficult, that is usually impossible. And therefore, we should not underestimate that. And that needs to change if we want to be successful for the future. And one other answer, I mean, we had been pretty comfortable in the past 20, 25 years. We said, okay, let the American do the NATO stuff and the defense stuff, let they do X, Y, Z, and of course cloud, AI, data, security. It's only the Israelis and the US-based companies. So, and out of a sudden, it turns out that we are dependent on in many angles. And that needs to change. And that will not change from one day to the other. We heard this in the former panel with regard to South Korea or the success of the Chinese automotive sector. That is a clear program and that needs to take time.
You've both publicly commented on the security dimension of the sovereignty or of the dependency risk. I would like to shift a little bit and focus on the economics of Europe's dependency. Can you put a number or an estimate to what it costs the European economy to be dependent on US hyperscalers, where in many markets, especially AI, the money is being made?
I don't have a number for this one. It would be tremendously large because in the end, everything depends on it. Our freedom in the end, because if our politicians in the EU cannot freely do what they think is best for Europe because they are, getting basically blackmailed by the US companies to shut us down. I mean, if they shut down clouds, I think probably most traffic lights would not work anymore. I think there's so much dependency which we even don't know that, just shutting down Excel, I think every other company would be bankrupt tomorrow if Excel would not work anymore. Yeah, so I mean, that you cannot put a number on this. This is kind of, our political life depends on it and much of our personal life as well. So huge number.
I would build up on this example you mentioned with the CIO to make it more tangible. Who of you in the audience ever has negotiated a commit contract with a cloud provider? And who of you have did it in a consecutive way? Means 2 times. And who of you was able to achieve to discount at the next level? So it means if you did it for 10 million in the first round, 3 years later, what was the commit? Was it 7 or was it rather 13 or 15? Exactly that. And in the meanwhile, the price increase kicks in as well. That means the discount opportunities those guys had been paid by all of the customers already. And it is from my point of view, it is a pitfall if you believe that you should stay and stick to this rather than swallow the pill once. But then, like Achim said, take whatever you can and also balance this out. Because whenever you have an opportunity, an alternative, then immediately the pricing will go down, for sure. And I can't speak for you, but I'm not preaching here to say, okay, never do any business with any US-based or any other company or cloud provider anymore. That's not what we are talking about. But it is what Achim said. I mean, imagine, we saw this in the recent war in Iran. You can bomb infrastructure, and that, of course, is disgusting on the one hand side. But you don't need to bomb an infrastructure when it comes to the network, the electricity network. You just switch off the data lake. You just switch off the data lake because in the modern networks, for keeping the 50 hertz stable, you need to have a big data lake, a very big data lake. Every 15 minutes, latest, rather 1 minute, your smart meter at home is sending a data set, to keep this 50 hertz stable. If you switch off the data lake where those people are sending, or the infrastructure sending in, and the others are taking the data to manage the network, and you don't have the data anymore, you cannot prevent to have this this infrastructure collapse. As simple as that. And there are many examples around here where we are fully dependent. And to me, infrastructure is one thing, being it the payment infrastructure. Who of you, unless Vero, and Vero, by the way, is also running on a US-based cloud provider, who of you knows a couple of platforms, financial platforms to exchange money, which are not 100% dependent on elsewhere? And that definitely needs to change, especially given the current politics of what we see across the globe.
So we mentioned historical reasons for the status quo, pricing, the lack of the state as an anchor customer. We talked about lock-in effects. We talked about the security risks of sovereignty. I want to go back a little bit to the offering and to talk about AI in particular. So if you're a company or actually even an individual who wants to deploy a frontier AI model, all the large proprietary models come with a hyperscaler provisioning. You both offer AI workloads, you offer open weight models on both of your platforms, not always the largest available one. This is an area where the concentration risks further increasing in the future. What is your response to that challenge?
I believe we need to really distinguish between the supermodels like Gemini, ChatGPT, XYZ, and also special purpose models. Yeah, we rolled out with Aleph Alpha a special purpose model in the German Agency for Employment for up to 100,000 users. And it is doing a great job. And it must be 100% precise, because it determines if anybody is getting the right amount of money and if they get really the substitute or not, as an example. And if you just put and spill a super large language model on it, there's a big risk that you lose a certain percentage of this preciseness. And we see that about 25–30% of the civil workers, public sector workers, might go to enter pension stadium pretty soon. For example, also in this agency. And then you have two choices. Do you try to fill up it with people you don't find on the market, or will you fill it up with technology? And certainly that needs to be done with technology. And I truly believe we have the opportunity, and that is why we're also investing so heavily into AI with the EPI in Heilbronn as an example, for 5,000 people working there in AI. And by the way, we as a company using AI heavily, up to 1.8 billion AI decisions every day in this group with 600,000 people. And of course, some we use public AI, but for our core business model, we never would use any public AI. We will only use it with our internal AI, personally trained models on the Stack Cloud. And I think you are doing it exactly the same with Ionos.
Yeah, in many ways. But you also asked about, frontier models, and the frontier models are only hosted and built by the frontier companies. So like 5 in the whole world. So this is the next ecosystem, which is completely out of European hands, training the models. We are all on the inference side. So we all have GPU cards, which by the way are American made. And we offer these services, and there's some free models, and we're using them, and so on and so forth. The Model Hub, we have all tons of different AI services, which we obviously internally use, but also have a service in the cloud. But looking at the whole ecosystem, in the end, I mean, even Amazon is offering Opus, is offering Anthropic's models as their frontier models. They have some own models, but they're not even close to, if you look at the leaderboard on whatever, Hugging Face or something, you will see there, the frontier models are not even owned by these large cloud companies so far. well, it can be changed.
What is ownership these days, right?
Yeah, that can be changed. Yeah, they have deep enough pockets. I don't see European companies having deep enough pockets to just buy Anthropic tomorrow. Yeah, it's many billions worth right now. So it's a problem. The inference on, I'd say, license, models which can be licensed, like there's some models, obviously you can also license, but if it's about ownership, about really true sovereignty and independence, we have a big problem here, because the most models we really Teuchem, European model, that's not, nobody's using it. I mean, the day it came out, everybody was like testing, and then next day never used it anymore, because it's just not even close to the frontier models. And so this is a huge problem for, if you really want to have the last 40% of technology. And so we have to see how this works out. In the end, a lot of inference stuff will be done with not the most expensive and most frontier models in the future. Having a voice model and stuff, you don't need the frontier models for this anymore. So the technology advance is so high already that even free models can do most of the daily work. But when it comes to the best technology, the best research, inventing new stuff with AI, being at the front, there's nothing in Europe.
I'd love to ask if you're concerned about the dependence on NVIDIA, but I also want to move towards solutions. Or maybe do you have thoughts about this? The hardware layer dependencies. You all have GPUs from NVIDIA in your data centers.
Yeah, of course. I mean, NVIDIA is dominating the market, then AMD. And then, but there's also Bull coming up right now. We are also working with Fujitsu, with their latest technology, which we find pretty interesting, and which you will find also in our data center soon. That means we need to diversify also in the hardware wherever possible, because I do see a big risk that we face the next VMware effect. And what do I mean with this? I mean silicon diversity. I tell you what, silicon diversity. First of all, today we are 100% dependent more or less on the US-based GPUs and TPUs, yeah? Being it NVIDIA, being it AMD and Google with TPUs. So that is why we are now working as well, evaluating Bull, evaluating Fujitsu and a couple of others. So to spread the risk. The next thing is NVIDIA and AMD are doing it very, very smart. And now coming to the VMware effect. With VMware, of course, we have a big login. If you want to use NVIDIA the best way, you usually also use their software ecosystem, which is called CUDA, or ROCm at AMD. So imagine, if you come to the point where NVIDIA will not grow in the way they grew in the past, so what will they do to still keep up with the earnings? They will leverage the software. And you will not have an opportunity to get rid of it or get out of it, because it will be the next login. Because more or less every large company I was dealing with in my previous role, and also today, most of them are using an software like CUDA or ROCm and a couple of others. So that means silicon diversity means also we need to come up with a platform which enables us and you, our customers, to be able to run those ecosystems no matter what platform or what hardware is underlined. Yeah? And that is pretty important from my point of view.
You probably have thoughts too. I want to move on to the solutions component. And let's start with what industry can do. You both represent slightly different approaches, and I want to surface a little bit where you also may disagree if you do. So Achim, federation is one approach we already mentioned. Bernie, scale. You're investing 11 billion in Lübbenau. That is a lot more than Schwarz's annual turnover. It's a lot of money. What can industry do?
A lot more than Schwarz's turnover?
No, I'm just saying it's a lot of money, 11 billion.
Oh, yeah. Okay.
Yes. It's a lot of money. I mean, in AI, we've lost all sense of scale, but for every normal purpose. So what can industry do to change the trajectory of the cloud market in Europe in the next decade?
Well, there are a couple of things ongoing already. So there are, for example, industry and public sector. First of all, I think, and I saw the numbers, I think IONOS is doing great and we are doing great as well. We are growing like hell, sorry for the explanation, but which is good. That is what we stand for. That means that Achim is right, that people can grow already with what we have. The second thing is investment. I don't want money. Of course, everybody takes money, but I don't want money for nothing. What we want to have is orders. We want to have orders where we can predict that our 11 billion just in Lippenau, but the next investments we are doing in Netherlands, in Switzerland, in Hamburg, in Bulgaria, and Romania, and maybe a couple of others, that this is really a hardened business case. Because fortunately, this group is doing, or did in 2024, the numbers are official, 175 billion turnover. But who on earth would, except for the hyperscalers as such, would invest such a huge amount of money in one dedicated data center? It's because we are leveraging it, and it's because we believe in the market, in the demand in the market. But we can't do it. We discussed Italy as an example. We can't do it just out of a gut feeling, saying, okay, we enter the market in Italy without having any idea how to come to a reasonable business case. And that is where the public sector and the economy needs to work maybe a little bit closer together, and the public sector can not only be the anchor customers, but they must be also the regulators, which enables those local players, the local companies, to do easier business with the local partners like IONOS, us, OVH, Scaleway, not to miss anybody.
Should we all become hyperscalers?
Superscalers would be enough, I think, for Europe. But, to second what Bernie just said, I mean, in the end, I think the industry is doing a lot already to what they are capable of. We're spending a lot of money. We're building software, building data center, availability zones, regions, and so on and so forth. But somehow in Europe, we think, or especially in Germany, I think we think a bit different than Americans would do. We talked about legislation. We need legislation maybe to buy European, because that's kind of, if you buy European, we are protectionists and whatsoever. I mean, if you ask the NSA if they consider buying something in China or in Europe because they want to be open to the world, they would probably shoot you, I guess, for such a crazy idea. And so we for whatever reason, we think we don't, we need to be open, and Americans' inclusion and whatsoever. This is something really, really special here. You will not find this in American government. So maybe they don't need a rule, because the common sense in American is, okay, we buy American stuff because we want to keep the jobs in America, we want to keep the knowledge in America, we keep the taxes in America. But here in Europe, and especially in Germany, you think, we need to be open to everybody. They don't pay the taxes here, the knowledge is not here anymore, and the jobs got lost too. So as a business owner, for me, that's the strangest thing in the world. If I have 50 companies, I try to make the business, so I buy from my other companies at all possible. I would never have had the idea to say, this is not inclusive enough. Instead of my company where I can buy the material from, I only need to have everybody else in the room. And I'd rather buy someone else just not to be in the corner of not inclusive enough. It's totally strange. So I think we need to come to the point where we say, okay, if you want to keep the jobs, if you want to be sovereign, and sovereign is not the wall around Europe, it's the floor we are standing on. That's sovereignty. We need to be, it must be rock solid, should not shake if the world around turns crazy. We should have a floor which is solid. That's sovereignty, not the wall we're talking about. Nobody cares. So we should be fostering the European businesses, yeah, and that's cloud, but that's all, and a lot of applications on top as well. We're not just talking about the cloud. We should come back to a point where we say it's actually very clever and very wise to spend our money on European companies. So what we do from the industry, we are pushing it as much as we can, but we would be happy if the governments across Europe and the public sector comes to the point where they say, okay, we do the same what any other country is doing. The Chinese are not looking into European companies to build their new whatever data center. So get the same mindset here. And what the government does is kind of a role model for the industry as well. You know, if the government is at that point, the industry doesn't, you know, gets the same mental adjustment here and comes down and says, okay, why not? Yeah, and if the government can buy local, why can't I? It's absolutely feasible now. So I think that is the move we need to do.
That is a super dimension you mentioned, the social security, taxes, and so on. I'll give you one example. We decided for Lidl, but only for the Lidl Germany stores, to take out the Huawei access technology and network technology and replace it with Lancom. Lancom is more or less the only left German-based company, daughter of Rode and Schwarz. And then when we announced it, I was asked, but Mr. Wagner, why do you do this? I mean, Huawei is way more advanced in its technology, and are you sure that Lancom can do what you need? And I rest assured, because we do really a decent job in testing all the technology, and Lancom is doing a fantastic job. But I said to the person, listen, I'm 100% sure that if we are not investing this significant amount of money into this company and buy German, I'm 100% sure in 3 years of now, or maybe 5, we will not be able to have the opportunity to find out. Yeah, because it's most reasonable or possible that those companies vanish from the market or will be bought from anybody else. And that is, and of course that came with a premium. We are paying a premium cost compared to others. But we make sure that we invest into German intellectual property. And I would like to build up with the social security you mentioned. I saw your Tagesthemen contribution, and I pretty much liked it. The question was, okay, Google is investing 5.5 billion in Germany, and is that for whom is it good? And you mentioned this most likely for Google, because at the end of the day it will be 12 people having a new job, yeah, because a data center as such is not contributing significantly to headcount and labor, but of course, on the other hand side, the most important thing is you said that about 30% stays in the country and 70% goes back to the United States. And if you imagine, of course, a huge portion is hardware, also energy, but we invest in the data center and building the data center. We invest in the infrastructure, which is coming most likely from Siemens Energy, Schneider Electric, Rittal, all the others. So at the end of the day, if you do the mathematics, I guarantee you that we have maybe even the other way around, at least 50-50, where we keep the complete value in Germany or in Europe. Yeah. And not only that we apply our stack and our operations in this data center, but we are also working with not the frontiers, but the German and the European AI providers. And this will generate an ecosystem, and step by step, we keep the intellectual property inside the EU, and step by step, we will also increase the ability to do new things, because we keep the money, the pensions, the social security in the EU.
I have 2 more questions, and then we open it up to questions. You can already think about what you would like to ask. The first one is, so the US hyperscaler model has produced enormous scale. There's also significant backlash happening in the United States against AI. Time magazine featured this movement, which happens in both the Democratic and the Republican Party. People are concerned about the environmental impact. They're concerned about electricity models. And I want to ask you, Achim, when we're thinking about the European cloud market, do we want to replicate the US model, or should we try to build something different? And you're both trying to do something different, but I'd love to surface a little bit more whether you're taking a different approach.
A different approach. I mean, AI is AI, and technology today demands these chips, which, you know, billions of calculations per second to make it work. And there's not so many different research around the corner which neglects this or, you know, has different solutions for it. So I think we're stuck in this for now. And of course, the development goes, you know, improves token efficiencies and power efficiencies. We have companies like Quant here, which we're working together, photonic chips, which might be much more energy efficient. But this is all still in the early phases and just a little part of, you know, what could happen. So I think the backlash is, yes, energy is one thing. I think backlash is also because, you know, what happens with the AI itself, you know. I mean, people are scared in the meantime, and rightful so, because in the end, I'm working a lot with AI, just as a developer and in my daily life, and just to see the advancement in the last, 6 months, 12 months, with the agentic AI coming along, I think the AGI is really not long around the corner. And Sam Altman, I met in December or November, I think it was, you know, he's completely at the point where he's saying in the next 2 years we have AGI. And now talking to Anthropic, they think even in the next 12 months. And somewhere around that corner, but it doesn't matter if it's in 1 year or in 3 years, it will come.
And we're focusing on smaller models?
Yeah, the smaller models is fine for the, you know, if you have the traffic light control, you can have a smaller model. That's totally fine. But, you know, but if AGI comes along, you want to have the frontier models, because then, you know, your economy is depending on it at some point. If you want to compete with the Americans, with the Chinese, you need these frontier models, you need these huge data centers, you need these computing power. And for the companies, they don't care so much in that moment if it's European or not. So we have more dependency in the end because we don't have these models here, we don't have these data centers so far. And even, you know, we're both applying for the gigafactories and that stuff, but this is a, you know, drip on the stone, if at all, you know, compared to what is actually needed for making AGI. But I think, you know, there's a lot of fear from people. What is happening to the jobs? What's happening to society? You know, the arbitrage model of work is going away. You know, and so what's happening with the society itself? It's going to be huge changes. You know, and then people get 150, 200 years. My sons, they will get 200 years old. You know, what do they do? 180 years long, you know, 20 years, a little school and some work, and then nobody has to work anymore. So another 180 years to, you know, go to the Teal Park, I don't know, you know. So I think there's a lot of things that will happen, and it's all within a very short time. And I think the Americans start, not just because of energy and they don't like these data centers anymore, that's only a portion of the people there, really. But I think everybody is now scared a little bit about what is happening to my personal life, to my workplace in the future through AI. And the solution, I don't know. I mean, there's like studies over studies now what is going to happen, but it will be fantastic for a lot of people. It will be disastrous for a lot of other people. I think that's fair to say.
I'm sure you have thoughts as well, but let's open this up to questions. Who has burning questions? You were first.
Thanks for the great insights. My name is Anke Obending, and I'm from the German Digital Service. And I want to come back to this point on like, how do we get the state as kind of the anchor customer? So because you alluded to some ideas and, you know, like make a preferential treatment in some way. We heard about procurement in the previous panel, and also this point, which I think in the public sector is very important, about risk aversion, that people are like, okay, I need to buy Microsoft because I'm, you know, like everyone has Microsoft, so I need to do the same. And for me, I would like to hear your perspectives on like what if you had like one wish, like very concretely from the BMDS or from kind of all of these new instruments that we have, the Digitalvorbehalt, like the new like spend control mechanism, something where you think this is going to be really effective in making the state our anchor customer and making this more effective in the public sector. And then we start from kind of developing from these investments, or that which are kind of not investments, but really actual market? Thanks.
If I can take this question, and if there's only one wish, my wish list is pretty high and long, but if there's one wish, I would say enable Buy European. Buy European. This will solve a significant amount of problems because, as I said, we are not aiming for give us free money because then it will not be invested wisely. No, we want to compete for business, but we want to compete for business in a fair way. Yeah? We cannot compete and win if you as the customer or you as the state, I saw one article, 440 million, I think Mr. Wildberger said, just paying to Microsoft. Yeah? And now ask Mr. Wildberger, what was the recent price increase for not getting any additional feature, not a single feature? Yeah? And maybe you just take, if you are a great negotiator, maybe 10%. Out of 400 million, 440 million, so the 44 million stand against our offering. Because it's easy to compete against us because the money has been paid already and ridiculously already by us. Also by you, because you paid the taxes.
Can I add my wish real quick? I think on the European Union, on the European level now, the Parliament is thinking about the sovereignty criteria, and I think that's going in the right direction. It's better than the UECS, which we had, which was only technology and licensing and stuff. But and my wish would be the supply chain. Thank you. The supply chain. Make sure that this needs to be sovereign, and with sovereignty here, I mean also patches and updates, because what happens right now is sovereignty washing in a big scheme again. I have, Microsoft is a German company, AWS, German company, and a German data center, and all of a sudden everything is good. No. Even if they have some admins here, but if they don't get updates anymore because Trump doesn't like us anymore, and he doesn't do it anyways, but even more, you could shut down any updates process. So you don't get updates more from Amazon, from Microsoft, for example, Delos, yeah, and that company is done, or that cloud is done within weeks because, the security, every day you have to fix security issues, zero-day exploits, and so on. If you don't get the updates, you're done pretty quickly. Yeah, and then there's no sovereignty left again. Yeah, so that would be my wish. Make sure in the politics that sovereignty criteria is defined in a way which includes real sovereignty, including updates, including the whole thing.
+1.
We're out of time, so I'll collect the questions. Who else wanted to? We didn't talk about market concentration enforcement, for example.
Yeah, Felix Schur, I'm a PhD student in the area of data law. I'm wondering about, everyone is talking about digital sovereignty, but my question is, everyone is developing its own solution. Every European nation is now producing a sovereign cloud and stuff like this. So my question would be, to what extent do we have to pick a winner? To what extent do we have to coordinate which member state is doing something? Or will it work out if we just leave it to the market and every member state will just bring forward their own sovereign product? Thank you very much.
Love this question. I'm adding another one. So.
Should we buy Anthropic? And is that politically even possible?
Oh, I have thoughts on this. Last time you asked a question, it was a very long comment. Do you have a question? Yeah.
I just only like to raise awareness that we need a European operating system. That's it.
Thank you. So.
Maybe I start with the first one. You take the idea. Do we, pick a winner? I don't think, competition is good, even within Europe. So I don't think we need to have one winner. It takes it all. It doesn't happen. Doesn't need to happen. But then again, we can collaborate and we can do things together. For example, we have the SECA, which you just mentioned, the European Cloud API, Sovereign Cloud API, which we invited everybody to, use the same API, so it's easier to migrate between different clouds. We are working on the Euro Office right now. We just released that news 2 weeks ago in the Parliament, and everybody's invited to work with it. It's completely open source. and is a real desktop, is a real it's a real office suite, including mobile and everything, absolutely everybody's invited to work with that. And you can host it. We certainly will host it. I guess there's other players. So I think instead of picking one winner, we should just collaborate in certain ways. But on the other side, we're still competitors. So this is not we still try to get each other's customers on a daily basis. Although we're nicely sitting here together, and that's fine. That's normal. That's business.
And there is, coming to this competition topic, there is a European common thing going on, even common because it's in its name, it's the IPSAI. Are you familiar with IPSAI? Yeah, so, and this IPSAI I pretty much like because with IPSAI, it is a pan-European solution. Everybody can participate. You are participating. We are participating. OVH and others as well participating, which is great. And with this, we are building open source technology. Yeah, even though who gets the most money, like last time SAP got the vast majority of the money for the Gardener project to garden Kubernetes. Which we are now doing together, and this is now in NeoNephos Foundation. NeoNephos is an open source foundation, and you have access to it, we have access to it, we are using it, everybody else is using it. And if we do those things, then I don't fear the competition of the US players, because if we do this across Europe, there will be way more developers, way smarter developers, and very faster new technology, which we all can build up. Exactly the same like, for example, in the centers you referred to with the Open Desk and so on. And I can just encourage you and invite you to build up on that.
And should we buy Anthropic, the loss-making model?
I don't know how much money it will cost, but I like that. Anthropic, I think it's a fantastic company. If they, due to the discussions with Mr. Trump, maybe discount the price, we should all put some money on the table and buy it. But I don't know if this is the solution. I ask you rather, who of you is using Anthropic, ChatGPT or Gemini every day? Who? Okay. Who of you, and I'll do now the math, I tell you 4. Who of you is using Mistral, Aleph Alpha, Black Forest AI, or you can choose one other? Okay, less than 50%. Why? Why? Because it is very comfortable. If you are a big enterprise or if you're also a mid-sized company, you do a frame contract once and then you just by one click add the AI and the security and the mobile device management and the office and the data management, blah, blah, blah. And this is also something. We have some really, really great companies across Germany and Europe. But if we are not trying and start to work with them, bring them strategically, not only tactically, but strategically into the business, then of course the next logical thing will be that they will be bought by any other bigger company where it will be easy to make just a click. Up to you.
Thank you for the discussion. We'll end here, and an applause for our panelists.
Thank you very much.
Thank you very much.
We have 2 more very important panels. One addressing the issue of skills and the issue of certification schemes, which is a really, really important issue that is not necessarily on the political agenda currently. And this is one paper that I'm announcing now, had to be actually ready for the summit, but we have unfortunately not succeeded to bring it till end, but it will come in the coming weeks, months, where Francesco, Sebastiano, and my former colleague Kai Zenner have drafted a really solid recommendation how to deal with the issue of vendor certification in Europe. Now the floor is yours. Letizia, please enjoy the discussion with Francesco and Sebastiano.
Okay, thank you. So we are at the end. You are tired. So we try to, okay, okay, I have the time. Okay, 30 minutes. Okay, so we have a reduction. And I will have a different question. So very quickly, the same question for both. Okay, the same question for both. How do vendor-specific certification shape today's digital skill ecosystem and market demand?
Right. So let me just maybe set the tone before, because I think we are. What are we talking about here? We have been addressing, I think, in the two-day event, obviously many different angles how you look at the topic of tech sovereignty ultimately. And one thing that has not been yet looked at is the issue of skills, of talent. How do we actually create talent in Europe, and how is this talent suitable to make Europe a sovereign or not sovereign economy and technology? So as Pencho introduced with Francesco Bonfiglio and Kai Zenner, I was co-authoring this study, this paper, which looked into the issue of, what is actually happening with our education system. How do we educate our IT professionals and even the IT users, by the way? Every one of us in schools, we do learn some e-skills, some technical skills, how to use software, how to even write software, and so on. And what is the role of the vendors? Because what we have seen in the last couple of decades, at least since, or even before, since I was in school, our schools and universities were not always in the position to give us actually all of the skills that we needed, or the competencies we needed to handle the digital products. And so what they did, they progressively delegated to the vendors, the US vendors, by the way, as you can imagine, the task of providing trainings and providing certifications. And this has started probably 2 or 3 decades ago, and the trend has continued dramatically to the point that today, if you ask a young person who might maybe want to work in the IT industry, so what do you prefer? Do you prefer to take a university curriculum, university education, or do you prefer to just go to the industry, to the vendors, and take a private certification? And probably the person might say, look, I'm going to rather go for the private certification because it's going to be faster and it's going to give me what the industry, what the employers actually want. And this is actually happening. And it is happening, unfortunately, with the permission or with even the support of our own states, with the public money and so on. And what is actually the result of all this, if you think about it? The result is that we are locking in all of ourselves, because we are training the future practitioners, we are training the future users, we are training everyone how to use proprietary technology, which we have not developed. So we are trained to become users of such technology and not developers of an independent and European technology. And we have been asking ourselves, okay, what we have been doing, is it normal? Is it what other countries have been doing? Or is it just something that the Europeans did because we didn't think about it? And I think maybe Francesco can explain a little bit more in detail, otherwise I would speak all by myself. What are the key findings of this report and why we think it's very important to talk about it? And I look definitely forward for the publication of this report by the Konrad-Adenauer Foundation under the leadership of Pencho.
Okay. Francesco.
Yes. Okay. Can you hear me? Yeah. Well, as some of you know, I've been spending quite a few years trying to explain what I believe should be done to achieve digital sovereignty. But one day I was talking about it with Pencho, with other friends, and I raised a simple point to me, because unfortunately, many people also being on stage these days, they have not been in the business. They have not run any digital business. They don't know technology, and they don't know also what the business requires to run digital transformation. Some of them do, many don't. That's the reality. So I said something very simple, and this is what I said. Digital transformation is not about technology. It's about transforming technology into business outcomes. And if you think about it, this means that whatever type of European digital sovereignty, whatever type of European stack or German stack we build, if we don't have a layer of skills, we will not produce a business outcome. That's a very simple statement, but if you think about it, you understand the importance of this paper we try to sketch out, because basically what we say is, watch out, because the big techs are not big, are not great just because they are big. Are great because they did a great job, they developed fantastic technology, fantastic platforms that everybody is using in the world. We need to be honest. Akim said it very clearly. You know, the frontier is led by those companies that are capable to invent, deploy at industrial grade solutions that can change the world. And they have been great, and maybe they've been first in doing it, and of course they've been helped also by public investments or the buy US in the US, and we don't have to buy European in Europe. But even if we had that, and we don't have the people capable to transform that technology into something, being an application, being a platform, being a social media, nothing would happen. Now, what the American company did was something incredibly powerful. They understood the power of colonization. In other words, if you want to conquer, if you want to diffuse your technology in the world, you have to build academy, training program, and certification programs. Why? Because in this way, you have a lingua franca, you have a common language that everybody can use to express their competence. And this is the gap they feel towards the end users. So if I am a customer, I don't mind using OVH or Ionos or Stackit Cloud versus AWS, unless I have the people with the competence to evaluate whether this is a good choice or not. So it's not a trivial thing. The Americans, they built their competence through a huge, gigantic network of partners. They don't deliver services directly to the customers. AWS, Microsoft, and Google, they don't provide services directly through their personnel, through the customers. They do it through a network of partners. And you know, to become a partner, you have to do one thing. You have to train your people on that platform technology. So it's like the Romans, I used to make this joke, that's why we started in this paper. The Romans were very good in making colonization. What did they do? They arrived in a territory, they built the streets, they brought the lating and the wine, which helps a lot. But speaking the same language brings us a kind of a civilization. So we have been colonized, or I should use a different example. We outsourced not only the training capabilities to the American companies, but also our ability to build our future. To the point that now university, even higher schools, they include training programs coming from private vendors, so vendor-specific training. This is what we are trying to address here. So yes, it's a problem, and it was built on purpose, and we are kind of slave of this situation now. Without becoming free, and maybe we can discuss what it means to become free or rethink about our digital education ecosystem, we will not solve the problem of remaining dependent, and therefore we will not achieve any sovereignty.
Okay, thank you. So you are not very quick in your answer, because you had explained the motivation of your paper, of your research. So I have another question, but probably you have already told your point of view. Are we witnessing a form of digital colonization through skill, where talent pipelines reinforce long-term dependency? And I will add another question because you can answer at the same time, but probably you have already said. Can Europe realistically rebalance its workforce away from vendor-specific skills, or is it dependency already too entrenched?
So you're asking, okay, what is the situation, and do we can we envisage some possible solution for that? In a nutshell, you look at the numbers. First of all, we are talking about in Europe. We estimate there are, if you estimate an ICT workforce of approximately 10 million people. There are at least 4 million certified professionals. Certified meaning certified by vendor certification, non-European vendor certification. So you see already a little bit the size of the problem that we have, and of course, as I was saying earlier, the issue is the trend, which is unfortunately we have done nothing to reverse the trend, which is there for the last, at least the last 2, if not 3 decades. And the unfortunate situation is that we have, in Europe, we have the luxury of having a fantastic public education system, pretty much in every country, which has been able to deliver, fantastic professionals, which we, by the way, also export to the US itself. But nevertheless, besides exporting the most brilliant people, we still import a lot of their certifications, which, as Francesco was saying, do nothing else than lock ourselves into their technology in a generational way, meaning it's not just today, but it is the professionals of the future, the practitioners, those who develop the technology, and those who use the technology, which will be locked in. So it's not I also believe that they have done this obviously very deliberately, the Microsoft, AWS, and the likes, not even with the purpose of running a sort of education or certification business which makes money. I'm not even sure they make a lot of money, but certainly the secondary effect of it is that they will do a lot of money selling their own products and licenses, right? Now, what we try to imagine in this paper is also what should Europe do and our industry do to reverse the trend, and we think it is still possible. Again, it is possible because we have states which ultimately, with some issues, but they do function. We have an education system which is there, primary, secondary, and in the academia. It does work. It can deliver. What has been missing, in our opinion, is the coordination of the European industry, because what we envisage is that the European vendors, they are capable of working with the public sector and imagine an orchestration system where we can define a framework for skills which include technology developed in Europe and owned in Europe, and we are together able to deliver trained professionals, skilled people, which learn this kind of framework as opposed to the non-European framework. I know I seem to be talking about something which is a little bit in a warfare scenario, but we have to take account of the fact that the world has changed, the geopolitical situation has changed, and as I think many people in these days have been pointing out, technology means power, and if we do not make the strategic choice of training our own people on the technologies we own, we will end up becoming a colony even more than what we are today.
Okay, Francesco.
Yeah, so I try to give you some concrete examples. The problem exists. So the biggest, the most simple way to look at the problem is that if you look at the public or private tenders, okay, doesn't matter, when you evaluate a proposal coming through a tender, you assign technical points based on the proposal. A big portion of these technical points is assigned to the number of certified individuals that you can offer if you are a system integrator, for example. What type of certification? Google, Amazon, Microsoft, VMware, Oracle, IBM. There is no European digital certification scheme. And that's, a pain in, where. Because actually we have no way to qualify professionals in a fair, equal way that are not using one of the dominant commercial solutions. The second problem is that, as I said before, those American companies were great in developing these training and certification programs. And of course, they haven't done it to make a business line. They have done it to support their core business. But we need to do the same with our European providers. So if you compare the size of the partner networks of American providers and European providers, you will find a huge gap. Best case, the partners of European providers are small. Most of the time, they are territorial, regional. German providers, German partners. French providers, French partners. And even more difficult, if they have their own technology is not supported maybe by a set of certification. If there is some certifications, there are few professionals in the market. Even more important, the value chain of digital, like it or not, is made by the following. End customer has a problem. Maybe I want to implement a new ERP system in my company. Then there is some ERP system providers, okay, it may be SAP, maybe someone else, or maybe a bespoke system. In between, you have a system integrator. The system integrators are not the many, Capgemini, Accenture, Atos, still there, and a few others. Again, if you are in the business of the system integrator, you have to sell people. Your business is to train the best people that can match the demand in the market. Where do you train them? Where do you certify them? You certify on the best sellers. You don't certify them on OVH, on Ionos, or other platforms, regardless of the quality of the platform. So this is another gap we need to fill. Finally, to answer your question, we are not entrenched, we are not lost for two reasons. One reason is that now we understand that we need to do something. So we have been talking for these days about all the good things that we can do and that we are doing. We are here to say, and in this paper, we try to give a recipe also of what needs to be done also on the skills side, because otherwise it will be, a table with two legs. It cannot stand up. But also, we can imagine something simple. Imagine that we can build something new. Again, the only way to be successful in Europe is not to replicate what they've done in America. So let's try to do something new in the education as well. What can be done new? Well, people confuse digital skills with the technology skills, STEM. I'll give you another bad news. We have only 20%, less than 20% of the graduates in Europe is STEM. So even if we leverage on them, we do have a problem. And most of them, if they want to find a job, they will not look for some fancy certification. They will look for Google, Microsoft, AWS, training programs, and possible certification. But digital is not about technology only. It's about economy. So we need architects, we need economists, we need lawyers, we need people that can design new business cases through technology that nowadays allows you to do basically whatever you want. Most of the people don't know what to do. And we're talking about companies, they have data, but they don't know what to do it with them, so they leave the data there, also because they're scared that maybe those data are stolen or exfiltrated. So the problem is creating a new generation of professionals that can address digital at 360 degrees, not just from the technology side. The second thing to do is to build a competence, skills, and certification scheme that balance, let me say, competencies on non-European platforms, competencies on some European platforms, and competencies on open source. How many times we've been talking about open source? Now, find people skilled or certified on open source platforms. It's almost impossible. They're fantastic. I mean, open source projects are fantastic. But if you don't find people that can use those open source solutions to build something industrial grade, you won't use open source. And this is another big gap. So we can do something different. We can train not just technology people. We can rebalance, let me say, vendor agnostic and vendor specific skills and certification. And we can also force, let me say, a new generation of digital literacy. Because this is, again, another mistake. We talk about digital literacy. Literacy is about knowing something that has already been invented. I can be illiterate on Microsoft Office 365. Digital competence is what allows me to invent a new Office 365, maybe completely different. If we are losing the competencies to build something new and we just develop literacy on something existing, it will not fly. So we need to force into secondary, higher school and academy credits based on this new European scheme of competencies and certification. This can create, of course, not overnight, but in a few years, a new generation of competencies that will allow maybe us to use not just European solutions, but any technology solution to build something new. So we have an opportunity to do something different.
Okay, thank you. So I will suggest to read the paper when the paper will be published. No, yes, because very interesting. So we don't have too much time. I have the last two questions very quickly, and after I would like to leave room for some questions from the public. But I think that they had an important distinction between technological skills and digital skills. So we have to point out this distinction. It's very important for everybody in business and in university or academy, because we have to work together in order to improve these things. So the last two questions, very quickly, and after we leave. But probably you have already given an answer. Should public procurement be used as a lever to prioritize a European or vendor-neutral certification? I've already said that, but I will have this question. And reshape the market. And the final is, what is the important action Europe must take in the next 2-3 years to move from dependency to sovereignty? So these...
I'll give it a start.
Okay.
Well, I'll try to be brief, but the point, I think, even beyond public procurement, the point is where do we put actually the needle? Because what do you think is the role of the market, and what do we think is the role of the state? What I'm aiming at is the fact that ICT professions in Europe are essentially left to the market. It is a non-regulated type of profession. Anyone can become an ICT professional. Anyone can decide whatever education they take, whatever private certification they take. So it is ultimately the market that decides. Even if you go into university, there is little strategic consideration about what kind of curriculum we are going to teach the pupils. At best, the university will try to align with what they think the industry, local industry, they may want in the short term. So, which is is not a very strategic consideration they will do. And this approach, we have been thinking, it is what we have. It is what has happened in all the European countries until now, but it is not necessarily the best choice. It is just a de facto situation. But why should it be the case? I mean, if we try to compare with what happens in other countries around the world, the situation might be completely different. For instance, if you go to Japan, and I'm not going to say that Japan is much better than Europe in many respects, but if you look at what it takes to become an ICT professional in Japan, you realize it is a regulated profession. So you have to take a state exam in order to be recognized as an ICT professional and in order to work in the industry. And obviously, when you introduce that type of step, it means that it is the state which thinks about, okay, what is our strategy? What kind of professionals we want for the future? What kind of competencies should they have? What kind of technologies should they know or not know? And it is not trivial, as you can imagine. And obviously, we have been thinking that technology was a commodity and the market should decide. And we were all very fine until very recently that this was the case. And now we start realizing that, unfortunately, we are losing the game because we don't control technology. So what we argue in the paper is that, we should move a little bit in a different way the balance between the market and the state, and start considering education and training as, especially in technology, as something highly strategic, something that responds to a need of our economies and our society in the short, mid, and long term. And therefore, we argue that the role of the state and the role of especially at the European level, as a competence, should be much higher than what it has been until now.
Okay,
the question was the one thing that we should do. Okay. Yes, I buy into what, to add upon what Sebastiano said, yes, it is strategic. That's why we should consider it in a different way. But I want to give another couple of examples that you will find in this paper when it's out. It's quite complex, that's why it took some time to make it, but it's going to be interesting. You may ask, okay, so are we the first asking the question? No. Imagine what? America, Australia, UK, Japan, Korea, many countries, they have their education programs on digital that are 50 plus vendor agnostic. So it's a known problem. It's an addressed problem. Guess what? Not in Europe. Europe started, there is a program called DigiComp, DigiCompetence, which is nice, but it's generic. So we need maybe to take that framework and expand. But the problem exists. It can be addressed. The one thing that I think we should do, if I should choose one thing, is develop this scheme of competencies and certification and launch it to the market. But it will not fly unless we combine it together with some detaxation, fiscalization incentives to the companies that hire people with such certification. I think it's a win-win, because in the end of the day, this is the only way to attract talents, already professional, to get this new type of certification, because they know there is an opportunity to be hired. And also to attract students and from the beginning of their education cycle. So this can produce results in not less than 3 to 5 years because of the education cycle. But some results can be seen immediately in 1-2 years if we combine it together with the incentives for companies that not necessarily buy European, but they hire people with certification according to this European certification scheme. Somebody on the stage, Akim, a friend of mine, said yesterday, we are the only place where buy European is outrageous. Nowhere else in the world anybody would accept that we have to buy from China or Europe just because we need to be open. Same applies to the skills. Why we should not hire people with certification or skills that have been achieved through a European scheme? I think it's natural. We just don't have it. So I think that's the one thing we should do.
Okay, so if there are questions from the public? No? Only one, okay. One and one there, so I don't know. You decide, you had the... Okay.
I keep it very short. Thank you. We talked about ICT professionals, but how far should we go? So should we also, let's say that maybe not from primary school, but from secondary school onward, students, just regular students, should be required to use either open source or European MS Office alternatives, something like this, so they're actually used to it, and when they go into the job market, it's not a retraining, but rather a natural thing for them to adapt to it.
Do you have another question? Maybe?
Probably the other question, and we finish.
Yeah.
Very quickly.
One remark to the whole problem. I totally share the problem. We don't have the right certification schemes. I see a big part of the problem that the universities, the academia and the business aren't connected. There's a huge gap. In Stanford, business and academia mold together. So when the students start, they have the practical skills. That's one problem. To the idea to have more the Japanese model and have more official certification schemes, I'm very skeptical if this is the right approach, because as you rightfully said, we need more people in tech, and we don't need a higher bar, we need less friction, and people should be able to hire anybody, if it's a lawyer or if it's a non-techie, they can do the job, then they should
I have to stop
be able to.
So final answer.
Very, very quickly, because we're out of time. I start from you. Yes, you're right, but we need to start injecting a new mindset. So digital is no more kind of math, literature, or any other matter you study at school. It's like your native language. So you go to school, if you're German, you learn German. You have to learn digital as well. So, and we need to start also from as early as possible. This is already happening. In some countries like Japan, they start from elementary school. I'm not saying that that's necessary, but you can do that because you start, counting, you start writing, you start reading. You should start understanding digital because in the end of the day, people, children going to elementary school, they go out and what they do? They take their smartphone in the hands straight away. Do you want to give them education? So the answer is yes, we need to build this connection. Certification is like regulation. You don't fix the problem, but you need it when you have a problem. We do have a problem, so we need to fix it. Maybe one day we won't need it anymore. Why? Because we will have a common culture of digital, which nowadays is seen like STEM. No, digital is not technology, science. No, it's part of our culture, so we need to inject it into the education ecosystem in a new way.
Good. I think I agree with Francesco, and I will perhaps just move into the next panel, and which I'm
in drafting this agenda, I was thinking what is appropriate to address the issue of sell European, because we talk a lot about the demand side, buy European, made with Europe, etc. And my idea was to Sebastiano is let's promote somehow the European tech sovereignty catalog, because there are plenty of European solutions who are not visible. That was exactly the question to Felix Zimmermann, because many people are approaching me say, see, we are there, but they are not seeing us. And after that, Sebastiano said, Pencho, wait, maybe we have something nice to announce till the summit. And it happened. Those who read Politico maybe have found out. I'm not going to tell what it is. Yeah. You can better explain it, but I'm really glad that you are doing for the European Data Summit. So thank you very much, and the floor is yours.
Thank you, Pencho. So I will be leading the last panel, and Francesco is going to stay with me because he is part of the success story we want to present. So maybe I'm going to ask the panelists to join me here. They are here actually from four different European companies, one German, two Italians, and one from Bulgaria. Please have a seat. And as Pencho introduced, what we wanted to announce today is the first package of European stack, which has been integrated among four different for the four solutions from four different companies. Why is this particularly beautiful and important? Because today we have been talking about how we build the technology sovereignty. And we have heard, of course, there's a role for the state, there's a role for the larger companies, there's a role for everyone. We also wanted to understand what is actually the role for the smaller companies. And we have a belief that we should not necessarily try to replicate the American model. We believe there are, thousands of hidden champions or even more visible champions in Europe. And we should just be able to integrate their own efforts, their own capabilities to create something which is a real alternative to the US technologies or Chinese technologies. So we have 4 companies here which are also at the same time part of the tech sovereignty catalog, which is an exercise to basically map out what are the sovereign technological solutions which are available in Europe. These are solutions which are scrutinized and evaluated by independent third-party evaluators against sovereignty criteria. And out of this very nice pool of almost 100 companies so far and growing, 4 of them, we have also said, okay, let's try to move these 100 or so companies into some kind of integration, because it's nice to have the different solutions, but if they're not deployable because you have to integrate everything by yourself, it's going to be a bit difficult to have an alternative to the US technology. And so what they have done together, and they will explain it, is to build a package, one solution which addresses one specific problem, which is the disaster recovery scenario. And it's also a situation which can address the scenario of a kill switch. So if a foreign vendor decides to essentially kill or switch off the technology they are providing, the 4 companies are now able to offer, a practical solution. We are in the B2C or B2B or B2G, business to business or business to government scenario. We are not in the B2C, which we have seen earlier, with the case of social media. With that, maybe Francesco wants to add something just as an introduction to the topic, and then we'll give the floor to them to explain what it is that this package does and how they think that they see the future of development for this package.
I don't want to steal any time, but just one simple thing, because I've been trying to do this in GaiaX, I've been trying to do that with Dynamo, and I keep insisting that the only way for Europe to succeed is to collaborate, because we are in a broken market and fragmented market where, by accident, the collaboration across different entities can produce a new model of digital and cloud services, which is distributed, but they must collaborate, they must be interoperable, they must create a kind of network effect. So what I like is that on the one side, we can talk about let's collect European alternative solution in a catalog, in a directory, call it whatever you want, but that's not sufficient. Most of the people, they are looking, you saw the proliferation of European alternative solution websites. What do I do with that? Nothing. Because on the other side, you need to have multiple companies delivering the solution, getting together around a table, and making it work in a specific use case scenario. So the packaging approach is a kind of a snapshot of multiple solutions that can address multiple different specific business needs. And it will not happen through regulation, it will not happen through catalogs, it will not happen through proclaims, it will happen only through companies that decide to work together. And I think this is a great example.
Right. So with that, maybe I'll leave the floor to one of them, Alessandro Cillario from company Qubit, because he is probably the one who has been triggering this process from the beginning after we started discussing within the catalog. So maybe you have a mic or...
Yeah, of course.
Okay, go ahead then.
Okay, thank you, Sebastiano, and of course, thanks, Pencho, for the invitation. It's great to be here. So very straight to the point. First of all, it's very interesting to see that we are 3 out of 4 people here are co-founder of companies. So we founded these companies because we really believed that there was something that, we wanted to fix somehow and creating something different. And this is extremely relevant because I think that today we all represent the voice of thousands of European companies co-founded by people like us, as smart as us, many of them probably way smarter than us, that are trying to do something. Now, in my personal experience, in the last years, I had 3 different requests, both from my investors and different, players in the industry to move in the US. Why? Because it's better, because it's faster, because everything is greater. And that was the typical scenario in which many of these founders of companies decide just to move and to say, okay, we go somewhere else. The decision that we all made, and we met together also by this, was to say, no, we want to build something that is European. We are able to build great technologies from here, and we want to do it. And starting from this perspective, of course, we approach all the cloud environment and an ecosystem, because we are working on our technologies are related to the cloud system, the IT systems. So we work a lot with CIOs and with all these kind of players. And we faced exactly the same problems that were mentioned before by the CEO of Ionos or Stackit. You know, the Buy European wasn't there. There was no chance to, you know, growing the company by that. But at the end of the day, we are feeling ultimately that something is shifting over there, and so I think we are very optimistic. So what we did basically, starting from that and from the catalog that Sebastiano mentioned before, was to say, okay, let's start from something that it's extremely simple somehow. We have this on one side, the demand that it's trying to move himself by the Buy European approach, and he's saying, oh, maybe we need to do something Buy European. What can we do on that side? And on the other side, we have these offerings that, as Francesco was saying, are very separated. Everyone is providing a very interesting technology, but very dedicated on the other side. So we need to find a way to combine these two. And actually, in the last 6 months or so, many big companies, I spoke with big automotive companies, top managers in Germany, big Italian banks, big French operators, etc. They all are saying, okay, can you provide us something that it's really a bundle, a package of these technologies that we can start using actually? And how can we actually doing it? And by an Italian group, I received this point that was like, at least we want to protect, we want to start by protecting ourselves from a disaster scenario, which is called, for example, the kill switch. In the threat that was run by Starlink activities in Ukraine by the US government was that we turn off Starlink and good luck for your war. That was the kind of negotiation at the time 1 year ago. Now, the same concept applied to the cloud in Europe means that we are all dead, because basically, unfortunately, we are not using as much technologies European as we want. So what we built is a disaster recovery pack that is just a first step, very easy for every single company to move into a scenario that it's European, and it's based on our technologies combined. So we just started working together. We chat with Elemento, with SUSE, with Storpool, and we collected together technologies that were able to deploy that. And these will be deployed. It's a first service provider is already deploying this solution, and of course we are having in pipeline others to join this exactly for the purpose. So combining a stack that is joined together in order to provide services on that. If we push forward that, we're gonna have what is typically coming from each supply chain, which means that big players will buy technologies, and these technologies will be part of a supply chain of skills and of an ecosystem that will grow. And maybe many more companies, European companies, will decide, as we did, to remain in Europe and not moving somewhere else. So that's the spirit of it.
Thank you, Alessandro. And I'm particularly glad to hear all of that, because, with Francesco, we were like more than a year ago together writing the first Eurostack paper, where we imagined what one should do to create an alternative to the European technology. And now this...
If you think of Eurostack, these two guys were the main authors of the paper. So don't think that some other guys can...
But I'm not going around talking about it. Somebody else is doing it.
No, okay, let's leave that aside. But it's nice to see, and Robin, by the way, was one of the of the famous people. But now all of this stack is obviously not the entire thing, and it doesn't even probably make any sense to build the entire thing from scratch. But you need to build some kind of bundles of integration, either horizontal or vertical, to start creating alternatives. So it's very good. I'm very happy to be here today presenting all of this. But from the story we heard from Italy, Alessandro, let me move back to Germany with Matthias from SUSE. So how SUSE is a much more established company, I would say. So how do you see your role in this package, and how you think this is going to go on and evolve?
Yeah, thank you. Thank you for having me here. I'm director for strategy at SUSE for the Linux part. But if we look at SUSE, it's more than Linux. It is also Kubernetes these days. And I think we are the only enterprise level European vendor in these specifically these two software infrastructure areas, right? And one of our let's say, taglines for SUSE is choice. And I think this is a very good example for choice, because choice means that the customer can choose and pick and choose things which are good for the customer. But choice is often very problematic. 10 years ago, I wrote a blog about that. Too much choice is also not good. And building such a blueprint, what we have done now, this is exactly the right thing to do for Europe on a bigger scale from my perspective. Because having choice, meaning also many companies, means that you also increase the resiliency of the whole industry and of the offerings. If everybody runs on the same thing, monoculture, you have the risk of a monoculture. If everybody runs on different mixes, but the mixes are well proven and well established, then you have much higher resiliency. And this is exactly what we're doing here. An example for building resiliency in the stack itself, but also for the customers, because they can use this stack to build up their own resiliency towards, let's say, external threat. And so I'm very glad that we do that together, because it's a perfect example for cross-European collaboration, cross-focus collaboration as well, because everybody from us has a different focus and is a different specialty. And for me, that was missing a little bit when I was sitting here today in the room, to really highlight that Europe has an advantage by being different countries, different cultures, and also maybe different languages, for example, that also raises opportunities that we are not leveraging as Europe.
Yeah. Thank you, Matthias, to highlight that Europe's fragmentation is perhaps a weakness, but it is also a great opportunity. And on that topic, maybe I'll go to Bulgaria with Björn. What's your view? How do we ultimately turn fragmentation into a strength from a weakness, as it appears to be?
I think we're in a very competitive and very turbulent environment, and we see multiple trends and cross trends. You have like globalization, but now you start to see deglobalization. And Europe is a kind of a small boat in the very rough ocean, if we have to put it as an analogy. And one of the strengths of Europe is coming together, like with the European Union, with the European zone, which, if you translate to data sovereignty and IT technology capability, is we have leading companies in different domains in different regions. So unless we actually come together, we stand no chance. And this is kind of the idea behind these initiatives, to get best-in-class technologies, start replacing or start providing a viable alternative to the major technology stacks that our leading enterprises, our governments deploy, and they have no alternative today that is coming from Europe. It's all coming from somewhere else. So we don't have that sovereignty. Our attempt is to start with providing the essential technology stack end-to-end, integrated, proven, also supported, bug fixed, troubleshooted, security patched, etc. So our biggest enterprises, smaller enterprises, and governments can have a viable alternative. In the case of disaster recovery, which means something happens, a foreign vendor, foreign entity tries to kind of leverage, to provide, to put leverage on you, but also to have your core business running on European technology. So this is kind of what we're doing together.
Right, thank you very much. And last of the four, Gabriele, also from Italy, company Elemento. And Gabriele, I mean, I left you deliberately as last because your company is maybe the youngest of the four, but you are very ambitious in thinking about really having a business model which is built on collaboration, on connecting other companies. So you yourself think that your technology can actually be a connector for different type of packages like the one we have today, but even more than that. So can you tell us a bit more about that?
Yeah, I was planning on starting with stating that we are indeed the youngest company among the four. We were born in 2021, we're Italian, as it was mentioned before. And what my company is really doing, and that's exactly the same kind of added value that I'm bringing to this package, is we are producing the glue which enables European technology to work together. But not only European, because after all, if we start fighting fragmentation without thinking at the whole world and not only Europe, we are doing something that is somehow limited. So with Elemento, what we do is actually creating a common language that is able to allow our customer to cherry pick several technologies from different providers, from different cloud providers, as well as technologies like yours, guys, because basically we're working together. And so, as Italians, as European, we are physiologically fragmented, all right? As Italians, I think that 170 years ago, Italy was not there. Okay, and Europe is even younger, all right? And so what I always ask myself is, how can we build something that can stand against or on par, let's say, with American, US technologies and whatever, how can we build this kind of stuff? And my idea is that we don't have to emulate a model which is totally different, which stands on a totally different substrate, which is the American one. We have to understand we are different. We have to understand we are many. We have to build something that is the layer on which you can make different technology work together. And that fragmentation, that when called fragmentation, is really a negative aspect, a negative asset, can become segmentation. And segmentation is something that is really, really specific on a technical point of view. That means that whenever there is something that breaks, you have alternative. You have no single point of failure. Not to bother you guys, but again, this package is a first example. What happens if Kabit switches off the switch? You have an alternative. If Storepool does the same, if SUSE does the same. The real point, and that's something we're building lately and we are starting thinking about, is that rather the cloud should not be, I get a database from a given provider, I get S3 from a given provider, but should come back to, I need a database. And then I find the provider which has the certifications I need, and then I find the provider that provides me and ensures me the right performances. But after all, I don't mind the implementation. And this kind of package, this kind of first blueprint, I like your wording, Matthias. It's really this direction. We have the layer on which containers and virtual machines can run, the layer that provides the storage live for these virtual machines, and the layer that provides the right space to put your data at safe, ready for backups, ready for disaster recovery. And that's something that hopefully we're going to expand even more.
Thank you, Gabriele. I think this describes also the issue of why we can think about fragmentation not just as a weakness but as an opportunity. We have plenty of choice. If one component fails, we can always replace it with another one. So if we are able to do orchestration of our different solutions, then we can turn fragmentation into an advantage, actually into an IT system which is ultimately more resilient than the monolithic IT systems that we are getting from the US or China. If there are any questions from anyone, happy to take them.
I just wanted to add one thing, if I may.
Go ahead.
30 seconds. Because in these days, and also in the past years, I think all of the people that are here in the room and in this type of ecosystem, talking about digital sovereignty, European sovereignty, autonomy, blah, 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 you heard about many times, we need to build a European alternative. We have good alternatives in Europe, or even worse, we need to push away a little bit the Americans. So it's always a kind of a binary approach, like us or them, or a little bit more of us, a little bit less of them. And also, and I know somebody will not love my declarations, but I believe that the effort in regulation and finance projects in Europe has been wrong so far, because we have been spending money trying to pursue the idea that we can have a common ontology describing all the services, a common standard adopted by all the providers, a common way to, common APIs, common. You know what? The reality is that nothing is common. The entropy of the different technologies is growing. There will be more and more technology. And this is a good thing, because we can choose. But if this is true, we cannot keep hoping into something that is going to be harmonized across one single standard, even worse coming from the European Commission, let's be honest. The market will not harmonize on something that is imposed. The market will grow, and if we want to leverage the power of digital, we need to find a way to exploit these differences. So the only way is to collaborate, orchestrate, interoperate. This will not come from hoping in the advent of a common standard adopted by all. And this is my personal opinion, but unfortunately, the years are testimony that this is happening.
Okay.
So this is an example of people that say, okay, let's not try to find a common lingo. Let's work together, each and every one independent and autonomous, each and every one competing, but we together provide a bigger value than the sum of all of you.
On the issue, yes. Sorry? Can I just... Okay, I think with Pencho is suggesting we close. I think everyone is pretty tired. I don't know if there is anyone of the panelists who wants to
yes, just one thing, because we are in the Konrad-Adenauer-Stiftung, and so I did my work, So this was not coordinated? No, not coordinated, but I mean, I'm actually graduated in law, so coming from a completely different background and way more common. So 1956. Okay, 70 years ago, Konrad-Adenauer. In the course of the last few decades, the political and economic power of the free world has become more and more concentrated in the United States. I acknowledge in gratitude and admiration that the United States has been fully aware of the responsibility which the possession of economic and political power entails. But in the long run, the European countries cannot fully develop their entire strength if they continue to find their salvation and their security exclusively under the patronage of the United States. So I think that 70 years after, it's still pretty, actual, and it's even worse than it was. It doesn't mean that it's something that we cannot discuss, but I think that there's just one thing in common between politicians and entrepreneurs, very good politicians and very good entrepreneurs, which is that where other people see problems, they tend to see opportunities, and so we can gonna get those.
Thank you very much. Join me for an applause. Thank you very much to all the panelists, and back to Pencho.
I can't produce this kind of closing remarks. I can promise you that we're going to continue. We're going to fight for rigorous enforcement. We're going to fight for clever simplification, and we're going to continue supporting this kind of initiatives. It was a great pleasure having you all on board. I really enjoyed the discussion. We enjoyed the discussion. I simply want to say also thanks to my colleagues. They are not listening to me. On the other side, our student is here. Thank you, Lucas. Enjoy the small reception, and let's continue the discussion with a glass of wine. Many, many thanks.
And a big applause to Pencho.